What up? Good morning. Good morning or good afternoon if you're over on the other side of the pond. I am Bob Mata. This is Defense Diaries. This is day 19 of Commonwealth of Massachusetts versus Karen Reed. So I had this bizarre dream last night that state called their star witness, and this guy came in and Bob Alessi just like flamed through him. Just set this guy on fire. He was lying about it. Oh, that wasn't a dream. That actually happened. All right. That's good to know. So, man, we're going to pick up right where we left off yesterday with that just unbelievable day of testimony. That was, I just don't know in all my career if I'd ever seen anything like it. I mean, clearly I've had, gotcha moments with experts. I've seen gotcha moments with experts where, you've been able to undermine them, but it's typically based on, things that they've said and opined about on other cases, and, you can kind of get them. But to have a guy just flat out lying about his education with that particular type of witness, I don't like whatever the antis are saying. I don't give a shit. There is no way to rehabilitate that. Just none. And we'll see it. Hank had a very, very long night. A very angry, upset, irritated, long night. That's what his night was like. So, but we're back and I'm home. Allie's going to be joining me 100%. So Scout, of course, overslept. Our flight got delayed by, 4 hours. Got home early morning hours, not that, like 12:40 a.m. we got home last night. So, so Scout, of course, overslept. I woke her up at 6:20 with her alarm blaring, and then she fell back asleep. And I woke up. I popped up when my alarm went off, and she's still lying comfortably in bed, sleeping. I'm like, and our kids are in their last 5 days of school. I think next week, mid next week is their last day. So, I'm like, yo, you need to go, little Joe. So Allie's taking her for the ride over to the school. So she'll be joining us very, very shortly. So let's throw this up. So how are you guys doing? More importantly, is everybody ready? You guys all ready for some more action today? What surprises await us today? That's the $1 million question. What can we expect? What can we expect? I have not seen the new microdots video. I'll definitely check it out. Maybe we'll throw it up on a break. I don't think they'd mind at all. And we'll check out. We'll see what they put together some big videos. They really do. They really do. They've been on it for a long time with this case. So they do some good work. All right. So we got OnlyFan going. So what's up with y'all? Tell me, all the beautiful humans in chat. So excited to see you here again. Just love waking up and hanging with all my homies. All the fam. It's awesome. I didn't even promote this on Twitter. I'm behind in terms of I gotta grab my phone. As a matter of fact, I'm gonna grab my phone now so I can tweet the link to the show. All right, hold on. All right. Sorry about that. Let's see. And let me see what we got going on. Let me check. I think overnight, probably. Yeah, we broke 47K last night while I slept. We're 47,000 subs. You guys are amazing. Just so amazing. So thankful. You guys are amazing. Just beautiful people, beautiful human beings. Yeah, I mean, sounds right. Sounds right. I think, depending on how long Alessi has to go with Burgess and then Welcher, maybe one other, man, I'm like still just gleeful about what happened yesterday. That was amazing. It was so insane. I just couldn't believe it. So yeah, I would not be surprised if Hank rests today or tomorrow. I'm guessing probably tomorrow, but who knows? I don't know. I'm anxious to see who else they have. There's definitely others on the witness list, but just because each side lists certain witnesses, that does not mean they have to call them. You have no obligation to call people on your witness list. It's your case. You can call whoever you want. Aussie. FKR, first time watching you guys the other day, and I'm loving your cast. Thank you. Love that. Absolutely love that. So exciting. So exciting. We are always thrilled to see new subs, and we love to hear from y'all. We love to hear that you love the show, that you kind of like our vibe. I mean, we're definitely laid back, I mean, we're a couple of laid back lawyers that try to keep it real over here at the DD. Itch. Aw, family hugs. Nothing better than a family hug bright and early. Remember, for 12 glorious months, full year of membership. It's amazing. We love you, Itch. Thank you. Thank you. Hey, and I'm gonna be reminding you constantly, because I know that we have a lot of people on the East Coast, and I know that we have a lot of people from Massachusetts in particular. Remember, Allie and I are going to be in Boston the 18th to the 20th of July for the True Crime Podcast Festival. It's an amazing event. Just Google it, and we'll throw the link up throughout the course of the stream. There's just a lot of great creators that go to that thing. My buddy Josh Hallmark and True Crime Bullshit's there. Generation Y's there. These guys are my buddies. Charlie Worrell from Crime Lines, Nina Instead. Just and it goes on and on and on. And I've talked Lauren Bright Pacheco into coming. So Murder on Songbird Road's going to be rep there. But it's a great event with tons of panels, and kind of the podcast row is super low key. Like, you really get time to hang out with the creators, and it's a great con, and it's the only one we're doing. We're not doing CrimeCon, not doing CrimeCon UK. We're just doing True Crime Podcast Festival. So, and if you are going to attend, please make sure to use Defense. It's a promo code, Defense, all caps, Defense 20. You save 20% on your admission ticket. So make sure that you are using that code if you're deciding to go, because that lets Lainey, my friend who puts this thing together, know that we're the reason you're coming, or at least one of the main reasons you're coming. And that's important for us to know. So I hope we see a bunch of you there. We think it's going to be a blast. It always is. It always is. Yes. Oh, Kale. Yeah. I'm working on 67 too. So it's not going to be as long as the wait as there was for 66. So that's coming. Garcia is going to be done by True Crime Podcast Festival. I'll tell you that. So, all right, let's see what you guys are saying. Mickey coming through. Thank you so much. I didn't think Brennan would ever feel defeated, ego, but I bet last night was rough for him thinking about today. 100%. Absolutely. I mean, when you're sitting there as an attorney and one of your key witnesses is just destroyed on the stand. And remember, I mean, we really haven't gotten into the nuts and bolts of it today. And or that's going to happen today. So I don't know. There's no way to rehabilitate that witness as far as his education thing. Like the best that he's going to be able to do is your practical experience, doing this for 10 years. Does that weigh more than the fact that you lied about your education level? And the answer to that is unequivocally no, because it's not a matter if the witness fibs about their education level. When you're talking about an expert witness, it's about the credibility of the witness. That's the thing, and this kind of testimony may be lost on some jurors because it's complicated. There's a lot of numbers being thrown about, a lot of times, a lot of reasons why times line up or don't line up, all that stuff. And, you just might be sitting there as a juror and it's just kind of going over your head. What doesn't go over your head is the fact that this expert witness flat out lied all over the place about his education level. Like that didn't go over the jurors' heads, I promise you. And how can you trust somebody's opinion on anything if the first thing that you're learning about them is that they're lying about one of the most fundamental aspects of being an expert witness, which is your education level? That's what makes you an expert, is being learned in the area that you're testifying about. So it's a problem. It's a problem for Hank, and it's good news for Karen. So, and like I was saying yesterday, the bigger part of this is that it casts a long shadow over Aperture and Jed Welcher coming up. It's like, because you have to question that company. You have to question their inability to vet their experts. I mean, that's some low-level vetting, y'all. That's not like some rocket science shit. That's just like, hey, we need your CV. You put a call into the school. I mean, they do it all the time. All the time. So, that really casts a lot of shade onto Aperture in general, to where it just is going to cloud the jury's feelings about the credibility of anybody coming out of that company. It's a huge problem for Hank. And I really, really look forward to him struggle busing to try to rehabilitate both Aperture in general and Burgess today. It's going to be a great day. It's going to be a great day. Oh, Dr. Shiloh sitting in some LA traffic, heading into work. Thank you for joining us yesterday. It was a blast. It's a blast. It's tough. It's tough when you have a guest on, because, you want to hear what they have to say, especially somebody like Dr. Shiloh, who's just so damn smart and so knowledgeable in her field and can give us so much insight from the psychology perspective. And, we're just kind of sitting there watching it. But she engages in chat and we got to talk a little bit, but it's tough for me as a host, because it's like a day like yesterday, you just can't like pause it, because it was must watch streaming. So, and like, you guys would have been freaking out in the chat. I know y'all. I know you. And I wanted to watch it the same. Like I'm like edge of my seat every time I'm watching Alessi work. Just like huge law nerd crush on that guy. Like I love him. He's just such a good lawyer. He's such a joy to watch operate. Because you know what you're going to get every single time. You're going to get a guy that knows his shit. Oh, there's some shaking going on. I think we're getting ready to rock and roll, but you just know what you're going to get every single time. He's always prepared to the hilt. And nobody's slipping anything by that guy. No one. Like there is no better sound clip for any witness in any case than Jaws for Bob Alessi, because he's circling in the water, laying traps. Because there's the first rule of cross-examination. And I'm sure those of you that watch our channel all the time know what it is, but you'd never, ever ask a question that you don't know the answer to. Because that's where you can get burnt. And he never does that. He always knows what the answer is. Always. And Allie and I were talking about the monacity thing last night. And we both concluded that, that was like, he knew that Burgess wasn't going to know what monacity means, which is lying. And the brilliant part of that was that he didn't give the definition. So, because I tweeted it, and I tweeted the definition yesterday, like right after it happened, and then I forget who it was. Somebody threw up. They threw up a graph of how many times that word had been looked up yesterday, and there was the spike, like a huge spike. Because I had tweeted something like how many of these jurors are gonna, leave the courtroom, and just people in general that weren't aware of what the word meant. And you saw the spike. At least a couple of the jurors had to have gone and like, what was that monacity word that he was talking about? So it was just one of those little things that he does that is just so brilliant. He didn't give the definition for a reason, because that could have gone one way or the other. That's technically asking a question that he didn't know whether or not he would know the answer to, but it was a win either way. Because if he says, yeah, I know what it means, he would have then asked, oh, okay, well, what does it mean? And it would have been him saying lying. Which, either way that thing went down, it was going to be a win. So, yeah, I love watching him work. So, theoretically, we could have a full day of Bob Alessi. If it's going to go Burgess, finish the cross, go redirect, maybe a small amount of recross, and then we get into Welcher, because I think we're off Thursday, Friday, right? I think I heard her correctly, because we've got I thought she said that Thursday was some kind of holiday, but I believe federally Memorial Day is celebrated on Monday. So, but they might have some kind of court holiday. All right. Y'all ready? Y'all ready for this? I'm ready. I'm excited. So pumped. Let's go. Okay, what are the odds? Sidebar? You're going to be a sidebar first? Usually seems to be the case. Small world, little miss. Small world. The world is watching this case. We know that. There's proof of it every day here in this chat.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, council. Good morning, Ms. Reed. Good morning, jurors. So I have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads.
Did any of
Yeah,
you
Mr.
look up
Burgess,
the
please.
word menacity? Holly Johnson, thank you so much. And also Anita. Holly says Turtle Boy found more fraudulent documents. Even
So I remind you, you're still in the room.
Shannon's
Thank you.
lies.
Good morning.
He even showed his grades for junior college. Woof. Woof. Woof.
All right,
That's a
Mr.
fresh
Alessi,
straws,
whenever you're
huh?
ready.
Thank you, Your Honor. Good morning, Mr. Burgess.
Good morning.
On your direct examination yesterday, your experience was brought up in questions, correct?
Correct.
On your direct examination, your certifications were brought up in questions, correct?
Incorrect.
There was no discussion in your direct examination about having certifications in Celebrite and Magnet Forensic Axiom. Did I mishear you?
No, if I misheard your question, it was
I asked about certifications. I'll repeat it, sir,
Sure.
in case I misspoke. On your direct examination, your certifications were brought up in questions, correct?
yes, correct.
However, on your direct examination, no questions were asked of you at all about your supposed education, correct?
Correct.
And you did not bring up your educational background at all on
Correct.
direct examination, correct?
Correct.
A forensic examiner must prioritize accuracy, correct?
Correct.
A forensic examiner must prioritize reliability, correct?
Correct.
Both are important.
Correct.
It's criminal proceeding we're in, correct?
Correct.
And therefore, accuracy and reliability are especially important in a criminal case as opposed to a civil case, correct?
I think that would be equally important in both.
Wrong.
So yes,
But
Wrong.
they're certainly important in a criminal case.
correct.
And accuracy and reliability are especially important when seconds and minutes matter as they matter and as you testify to in this case, correct?
Correct.
You testified yesterday that the events on the timeline contained in your PowerPoint presentation that was displayed yesterday and presented to the jury were accurate, your words several times, down to the second, correct?
Correct. For the Lexus, yes.
For the Lexus.
Yes.
You said they were accurate down to the second, correct?
Correct.
Let's take a look at your PowerPoint presentation that you discussed extensively before the jury yesterday. Mr. Wool, could we please bring up slide 32 of the presentation Mr. Burgess discussed with the jury yesterday? And Your Honor, with your permission to publish,
Okay,
thank you.
It's already brilliant. Money.
Mr. Burgess, pick
Never more
your
important.
screen.
Sure.
Is this a true and accurate representation of your analysis of Miss Reed's Lexus vehicle traveling to 34 Fairview Road and the O'Keefe residence?
Yes.
According to your timeline, Miss Reed's vehicle powered on at 12:36 a.m. on January 30th, correct?
Correct.
Now, is your timeline on this slide accurate down to the second, as you stated in your direct examination yesterday?
For the power on and off events, yes.
Yes. Could we go to slide 33, please, Mr. Wolk? And we're going to go through a handful of slides,
Sure.
Mr. Burgess, to just give you a heads up. Is this a true and accurate representation of your analysis of Ms. Reed leaving the O'Keefe residence at 5:07 a.m.?
Yes, it is.
And according to your timeline, Ms. Reed powered on her vehicle at 5:07:46 a.m. on January 30th, 2022, correct?
Correct.
Is the time on this slide accurate down to the second, as you stated in your direct examination yesterday?
Yes, according to the Lexus, yes.
If we could go, Mr. Woke, to slide 34, please. And these are all your slides, correct, sir?
Correct, they
You
are.
prepared them?
Yes.
Is slide 34 a true and accurate representation of your analysis of Ms. Reed traveling to the Dighton residence at 12:25:01 a.m.? I'm sorry, 12:25:01 p.m.
12:35:01, correct.
I'm sorry. Thank
Yes.
you. 12:35. And according to your analysis, Ms. Reed powered on her vehicle to travel to Dighton at 12:35:01 p.m. on January 30th, correct?
Yes, that's correct.
And is the time on this slide accurate down to the second, as you stated in your direct examination yesterday?
Yes.
Slide 35, please, Mr. Wolk.
Laying traps. Laying traps. God, I love this.
Is this a true and accurate representation of your analysis of Miss Reed's vehicle being towed by the Massachusetts police vendor from her parents' residence in Dighton?
Yes, it is.
And pursuant to your timeline that you created here, Miss Reed's vehicle was powered on at 4:11 p.m. on January 30th, 2022, and towed to the Canton Police Department, correct?
Correct.
Is your timeline on this slide accurate down to the second, as you stated in your direct examination yesterday?
Yes, this timestamp is.
Slide 36, please, Mr. Wolf. Is slide 36 a true and accurate representation of your analysis of Miss Reed's vehicle arriving at the Canton Police Department?
Yes, it is.
And pursuant to the timeline you created, Miss Reed's vehicle powered off at 5:36:42 p.m. on January 30th, 2022, correct?
Objection. Objection.
I'll let you have this.
Okay. Is your analysis is your analysis on slide 36 accurate down to the second, as you stated in your direct examination yesterday?
Yes, according to the Lexus, yes.
According to the Lexus.
Yes.
In point of fact, Mr. Burgess, none of the 5 timelines that we just reviewed from your presentation are accurate at all, and certainly not down to the second. Am I right or am I wrong?
You are wrong.
Are you aware, and if we could go back to the first slide, which is slide 32, and we'll look at each of them quickly.
Sure.
Shit being said.
Are you aware that all of the relevant events in the timeline you described in your presentation in these slides actually occurred on January 29th, 2022, not January 30th, 2022? Do you know that?
This is January 30th, 2022.
That's what you-
January 29th, correct.
It's January 29th, 2022. And in terms of January 30th, I want to go back and make sure it's very, very clear. In your presentation, they actually occurred on January 29th, 2022, correct?
The night of the incident, yes.
Can I have a moment, Your Honor, please?
Yes.
Thank you.
Hold on, I have to go talk to Mr. Woke for a second.
Mr. Burgess, once that timeline crosses into midnight, it's January 30th, not January 29th, correct?
Correct. Yes, it is January 30th. Yes.
So in actuality, these 5 timelines, as you testified to them yesterday, are not accurate down to the second, correct? Because you got the wrong date.
Well, parlance, yes, but yes, they are still accurate to the second.
But the date, these 5 timelines, let's pursue this. These 5 timelines are exactly 24 hours off from the time where the event actually occurred, correct?
No. So these events occurred on January 30th. If I misspoke and said the 29th, yes.
Okay. You understand my point?
Yes, I do.
The core basis of your job, your role in this case, is to reconcile time discrepancies, as you say, down to the second, correct?
Correct.
But your discussion of the timeline on each of these slides, on each of these key events, is incorrect, correct?
No, it's not incorrect.
So your discussion of the applicable date, you're saying, as you described it yesterday and interpreted this timeline, was correct? Is that what you're saying now?
This timeline is correct.
But
Yes.
my question is your discussion of it yesterday.
If I misspoke and said the 29th, then yes, I misspoke on that. Yes.
And that was your testimony yesterday, what you spoke about.
Yes.
You sloppy motherfucker. That's what's going on. You sloppy. I love this.
Let's turn to a different topic. Lights up, if we could, and thank you
Lights
for taking
up.
that down, Mr. Wolf. Your actually, to mitigate the inconsistencies that you analyzed yesterday between independent clocks, am I correct that your position is that forensic methodology recommends cross-referencing timestamps from multiple sources to identify discrepancies, and when possible, leveraging time anchors, events that contain both a system timestamp and an external physical event to identify and correct timing discrepancies? Do I have that right?
Yes, you did.
Yesterday, we talked about the scientific method. You recall that, sir?
I do.
And how it's designed to prevent bias from infecting the analysis. You recall that as well?
Yes, I do.
And yesterday, you agreed that experts should never selectively gather and interpret evidence to confirm a pre-existing belief while neglecting evidence that contradicts those beliefs, correct?
Correct.
And doing that is called confirmation bias, which you said you understood yesterday, right?
That is correct.
That would be improper to do that, correct?
Yes.
It would raise the specter, if not the reality, of unreliability if that occurred, correct?
It could, yes.
And it could also lead into errors in forensic analyses, correct?
Correct.
Let's take a look at your January 30th report, sir.
Okay.
And this is your first report, your second report being the May 8th report. In your January 30th report, you did not issue any opinion or conclusion with regard to the timing of what you call the text stream event 1162.2 in your January 30th report, did you?
No, I did not.
You didn't even mention either the phrase text stream event or the phrase 1162.2 in your January 30, 2025 report, did you?
No, I did not.
But in that January 30, 2025 report, you did evaluate the variance between the Lexus infotainment system on the one hand and Mr. O'Keefe's iPhone data on the other, correct?
Correct.
In fact, in that report, the January 30th report, you compared the call logs on Miss Reed's Lexus infotainment system with the call logs on Mr. O'Keefe's iPhone in order to evaluate whether there was a variance, correct?
Correct.
And do I have it correct in your report that it's the position that the timestamp call log data, specifically the recorded calls between Miss Reed and Mr. O'Keefe, along with the infotainment power event logs, were analyzed for what you called clock skew by cross-referencing them against other independent data sources, right?
No, so that would have been comparing the timestamps from Mr. O'Keefe's iPhone with the timestamps from the defendant's Lexus.
Right.
Correct. Yes.
Yes. Right. To Miss Reed's Lexus.
Correct.
And a forensic comparison of these data sets was aimed to identify timestamp discrepancies, correct?
Correct.
To identify potential clock skew, correct?
Correct.
And potential clock drift that could impact event reconstruction, correct?
Correct.
All this stated in your January 30th report, right?
Correct.
Your Honor, may I have this marked as the next exhibit in order for identification?
Yes.
Sure.
To the BBB for ID.
May I present to the witness, Your Honor?
Yes.
Thank you. Mr. Burgess, I am presenting to you what has been marked as Exhibit BBB for identification. I'd ask you to take a look at it, sir, and then pick your head up when you've had a fair opportunity to take a look at it.
Okay. Sure.
Do you recognize that document, sir?
I do.
May we approach, Your Honor?
Yes.
Thank you. What do you recognize that document to be, sir?
Sure. So this is a graph that I put together that is comparing timestamps, call timestamps from the infotainment module with Mr. O'Keefe's iPhone.
And is that Exhibit BB B for identification in your January 30, 2025 report?
Yes, it is.
And did you create that chart that is depicted in Exhibit BBB for identification?
Yes, I did.
And is that a fair and accurate representation of the information that you discussed in page 33 of your January 30, 2025 report?
Yes, it is.
I offer Exhibit BBB for identification into evidence, Your Honor.
Oh, Bob found
If
another
we can introduce the
misspoken.
whole report to put it in
Why don't I
context.
see you type on?
Some more misspoken. All right, so this is glorious. So he starts off immediately, and look, kind of the times in terms of when they applied to, it wasn't the point of that questioning. It was a bit of a semantical argument. Yes. The point of it was to show that this guy, he be sloppy. He be sloppy as hell. You can't, hey, can you trust a guy who's sloppy? You can't trust a guy who's sloppy. So we got liar, sloppy. Can you trust that kind of expert witness? I ask you, jurors, can you? The answer to that is no. It was really a rhetorical question. What he also did early on that was just delicious was he put it on Hank. You can't trust the Commonwealth. There's no winning for Hank. It's what I was talking about yesterday. Either he knew that this guy was full of shit about his education level, all over the place. All over the place. He misrepresented what his educational background was. And Hank either knew that and avoided it like the plague on direct, or he didn't know, and Hank's not vetting his witnesses and just putting any old turd up there. Either way, it's casting massive shade on the Commonwealth. You can't trust Hank Brennan. Those were two beautiful ways to start the day right there. I'll tell you that right now.
Yeah, continue, Your Honor.
Yes.
Thank you.
Absolutely.
Your Honor, at this time,
Let's see.
I offer Exhibit BBB into evidence.
Okay.
Exhibit 189.
Thank you.
They represented to the witness, Your Honor.
Yes.
Thank you. Mr. Burgess, I am represented to you what is now Exhibit 189 in evidence. Ask you to once again take a look at it, and if you need further time, please take it, sir, and then pick up your head when you've had a fair opportunity to look at that document.
Okay.
Despite claiming the purpose in your January 30 report of, quote, identifying timestamp discrepancies, potential clock skew, and clock drift, you did not compare the time of the three-point turn between the infotainment system in the Lexus SUV and Mr. O'Keefe's phone, did you?
Not at that time, no.
Instead, you identified the potential variance by analyzing various calls on the infotainment system of the Lexus versus Mr. O'Keefe's phone, correct?
Correct.
This data in that exhibit captures a precise moment in time that is easily compared between the two devices, correct?
Correct, it does.
Mr. Wolk, Your Honor, may Mr. Wolk please publish this exhibit?
Okay.
So this data, just to reestablish, captures a precise moment in time that's easily compared between the two devices, correct?
Correct.
Now, according to your own table, there are potential offsets of reading in the far right-hand column. 2 seconds. 1 second, 2 seconds, 1 second, 8 seconds, 16 seconds, and 21 seconds, correct?
Correct.
And yet, you failed to apply this variance to the infotainment time on the Lexus associated with the text stream event 1162.2, correct?
Correct. May I explain?
I will proceed along. I'm sure if Mr. Brennan has questions and wants you to explain, he may choose to do that. This is simple arithmetic, is it not? It's either an addition or a subtraction, the offset, correct?
Correct.
And yet, in your initial report on January 30th, 2025, you did not take that final analytical step, did you?
No, because these clock variances do not apply to that time frame.
But you didn't take, you know what analytical step I'm talking about, correct?
No, I don't. I don't
All right.
believe so.
We'll come back to it. I want to go focus on your opinion. What you did do, as I understand it, in your January 30th report. So in your opinion, we can leave that up for a moment, please, because I want to see if we need to show the contrast. With your Honor's permission, can we leave it up just a little bit longer?
Yes.
Thank you. In opinion number 5, and please feel free to look at your January 30th report,
Sure.
You indicated only this. The difference between the Lexus infotainment and Mr. O'Keefe's cell phone ranged between 8 seconds and 16 to 21 seconds during the period between 5:21:36 a.m. and 5:30:31 a.m. on January 29, 2022. Do I have that correct?
Yes, between 5:21 and 5:30 a.m.
Yes. Now what I'd like to do is, and we can take that down. Thank you, Mr. Woke. Let's talk about what information you learned after you issued your January 30, 2025 report. Or at the time of that report, you received and reviewed a copy of a portion of your colleague's slide presentation and report at Aperture, Dr. Judson Welcher, correct?
From a presentation by Mr. DeSogra. Yes.
Well,
correct.
I understand you want to add Mr. DeSogra. My question is,
Sustained.
okay, yes, Your Honor, thank you. I'm focusing on what would you like to call it? Do you call it a slide presentation you prefer, Dr. Welcher?
Sure. We can.
I want
we
to
can
use whatever parlance you're comfortable with.
Yeah, slide's fine. Yeah.
Slide. So the slide presentation of Dr. Welcher that he submitted the same day you submitted your report on January 30, 2025. And in that, he analyzed the timing of the 1162.2, what he calls an infotainment event, you call a text stream event, correct?
Well, could I see the slide we're talking about to clarify?
Absolutely. Could we publish what is in evidence? It was 188.
Okay,
And I'm also, sir, at your request, may I approach, please?
yes.
At your request, I want to give you
Sure.
that, if we have 188, we'll just give them the actual marked exhibit. You know what we'll do? We'll use the slide. If you need an exhibit, we'll pull the exhibit and move it along. Please publish, Mr. Woke. Now, if we could enlarge the text, we don't need the map, so make that as large as you can, please, Mr. Woke, in the relevant portions. All righty. You're aware that according to Dr. Welcher's analysis, as depicted in this slide in evidence, the 1162-2, what he calls an infotainment trigger that you call a text stream event, right?
Correct.
The 1162-2 text stream event occurred at 12:31:38 a.m. on January 29, 2022, correct?
Correct.
And that's when it began, right?
That's when the trigger threshold was met. Yes.
That's when the trigger threshold was met.
correct.
You we can take that down now, Mr. Woke. You also testified yesterday that you reviewed Mr. Whiffen, Mr. Ian Whiffen's January report, which established a timeline of the last interactive events on Mr. O'Keefe's phone, correct?
Correct.
Your Honor, could we please publish Exhibit 39, which is in evidence?
Okay.
And if we could go to slide 82 and have 83 available, if we can enlarge the applicable sections. And what I'm going to ask you, Mr. Burgess, is to see whether these events are consistent with your memory of what the applicable events are. Do you see the column biometric device unlock with Face ID event at 12:32:04 a.m.?
Yes.
Now that's after the 12:31:38 a.m. 11:62:2 text stream event that's in Mr. Welcher's slide, correct, that we just saw?
Correct. The unadjusted Lexus clock. Yes. Timestamp. Yes.
So, but I'm going to repeat the question. The 12:32:04 a.m. device unlock with Face ID event is after the 12:31:38 and 12:31:43 11:62:2 text stream event that is stated in Dr. Welcher's report, correct?
Correct.
Now, do you see the lock event which occurred at 12:32:09?
Yes, I do.
That is also after the 12:31:38 to 12:31:43 text stream event, correct?
Yes, the unadjusted time.
That 12:32:09 a.m. lock event is after the 12:31:38 to 12:31:43 range that is stated in Dr. Welcher's report, correct?
Correct. From the Lexus clock.
So if we could go back, and we're going to toggle back with Your Honor's permission between these two slides for the next couple questions. If we can go back to and enlarge Dr. Welcher's slide. That 12/31/38 to 12/31/43 time period is what your colleague, the licensed engineer, Dr. Welcher, chose and his slide analysis as the last user interaction, according to him, on John O'Keefe's phone, correct? That's what he chose.
Yes, the 12/32/09. Yes.
Now, if we could go back to the and zero in, please. Now, but even Mr. Whiffen's report establishes additional activity on Mr. O'Keefe's phone after the event chosen by Dr. Welcher, correct?
Correct.
And in fact, Mr. Whiffen identifies a quote lock event that occurred 26 seconds after the 11:62 text stream event identified by Dr. Welcher at 12/31/38 to 12/31/43, correct?
Correct. Using the unadjusted clock.
I would like, does Dr. Welcher at all use the words unadjusted clock in his slide, sir?
No. He does not.
Okay, what I'd like to do is ask you a question about whether, in fact, Mr. Whiffen identifies a lock event that occurred 26 seconds after the 11:62 text stream event at 12/31/38 to 12/43, as stated in your colleague's report, Dr. Welcher, the slide presentation. Is that correct?
Yes, that's correct.
Do you know whether a lock event on an iPhone requires human interaction?
Typically, yes, it would.
Is it just typically, or does it?
Well, it does. And in this case specifically, I believe it was via the lock button.
Correct. But this specific instance, the lock, it requires somebody, a human being, to actually press a button on the side, correct?
Unless it's auto locking, yes, it requires a button press, yes.
Do you have any reason to believe that the iPhone of Mr. O'Keefe had an auto locking function on it, sir?
No, as I said, he used the lock button.
Right. If we can enlarge that, do you see the end of health event 36 steps that we talked yesterday that was covering a distance of over 84 feet? Do you see that occurring at 12:32:16 a.m.?
I don't believe we talked about that yesterday, but yes, I do see
Do
that.
you see it?
I do, yes.
And that's also after the 12/31/38 to 12/31/43 text stream event identified by your colleague, the licensed engineer, Dr. Welcher, in his slide, correct?
Correct.
Now, finally, do you see the entry pocket state detected at 12:33:14 a.m.? You see that, sir?
Objection.
Sustained.
Do you know what a pocket state is, sir?
I do know what a pocket state is.
Do you know when the pocket states occurred on the iPhone of John O'Keefe pursuant to your analysis of his phone?
I do not.
You didn't analyze pocket state detections on Mr. O'Keefe's phone?
No, I did not personally.
Do you believe pocket state detected data Well, let me just go back and confirm. So you didn't analyze with any source pocket state detection information with regard to Mr. O'Keefe's phone. Is that correct?
That's correct.
So let's go back and summarize for each of the ones you did look at and analyze that you just testified. Every single one of those that we just discussed, those user interaction events, occurred after Dr. Welcher claims a collision occurred as represented in a text stream event of 11:62:2 at 12:31:38 to 12:31:43, correct?
Objection.
Do you understand? Let's, if we can go back, please, to Dr. Welcher's slide. Highlight the text again, please, Mr. Wolf. Do you understand that Dr. Welcher is correlating the infotainment trigger 11:62:2 with an alleged collision? Do you understand that?
Objection.
Let's come to sidebar, please.
It's all fair game. It's all fair game. If he's going to be trying to say that he can't testify to this because Welcher hasn't testified, he relied on reports of other experts. All of them did. Welcher relied on his. They both relied on Whiffin's.
But him and Welcher are like a freaking team.
I know. That's what I'm saying.
I'm coming down.
All right. Well, they spoke a handful of times. Anybody's buying that. These guys were huddled up, talking constantly. Guarantee it. And I'm talking about Welcher and Burgess. Oh, all right, let's see. While we're at the bar, let's see what's up. Trial lover. Thank you. Question. So Aperture has now put a mark on all employee CVs stating not for expert designation, including Welcher. What does that mean going forward? Well, I mean, that's a CYA to cover your ass for Aperture. And that's all that means moving forward. I mean, if you're a lawyer looking for an expert and they've got an asterisk where they're saying, hey, well, you know, this person's we're a company that farms out experts for your case, but we have this little asterisk here where it says that, you know, they're not designated experts. I mean, it's bad for Aperture, I'll tell you that. It's a liability thing. It's covering their ass. 100%. I think what it means for Aperture is bye-bye Aperture. I mean, I don't know how you recover from this because it's not an opinion thing. I mean, every trial you have difference of opinions between experts, right? I mean, that's the whole point of experts. State or the Commonwealth has an expert that says one thing because it's all about interpretation in the law. That's what the law is. Two people or two sides interpreting the same thing in a completely different way. It's literally what the practice of law is, and it's literally what trial work is. And when you have a situation where you have not done the work that you are charging people for, which is to vet the people that you're putting on the stand, if you're a lawyer, what's your purpose? What objective are you serving if you're not doing that basic function? I mean, they're in deep shit. That's what's going on with them. Oh, what's up, girl? My beautiful
babe.
and brilliant co-host, Allie.
Hey, babe. Hey, all.
I've been missing you, girl. I've been missing you. Wow, you missed it yesterday.
I mean, I caught a lot of it from the background, but I'm
People want you
confused. Is
during your shift.
Aperture not the company they work for, but a third party like expert securing company? Is that what we're saying?
No, they work for Aperture.
Oh,
I mean, but in
I-
the sense that like Aperture is like Arca, where they hire people that are experts in fields, and that's what they do.
but there's a difference between whether they employ these people already or because there's a lot of companies that
I
just
don't think these are consultants. Like I don't think that I think that they're employed by the company, but they're hired as experts because of what they do. I mean, that's why they exist. They don't exist independently, meaning like, I mean, if they're a company that exists that has gathered up a bunch of experts in various different fields and they don't exist independently because they're not doing any work unless they're hired by clients or attorneys that are trying to get, it's like, I guarantee they live in the world of civil litigation. Like that's their bread and butter. Like if you were, I bet, and I don't know this for a fact, but I bet if you were to look at their bottom line where they make most of their money, it's that they're getting hired out as experts in accident cases in civil litigation. That's where they're making all their dough. So I don't really understand your question. What are you saying? Like they're not just like a company that exists in the world that just you call up and say, hey, like they're not like headhunter.
okay.
Like a headhunter company just looking for experts.
Right. So these are employees of ARCA. Well, when you say ARCA is supposed to be vetting the experts,
Aperture.
Aperture.
Don't ever confuse those.
Sorry, I was reading somebody's new acronym for ARCA over here, which was funny.
Horrific.
I missed it. Oh, here, Gwen
You can put it
Garnett.
back up.
Thank you, Your Honor. If we could go now, Mr. Woke, back to the slide from Dr. Welcher's slide presentation. And if you could re-enlarge the applicable section that we've had up before. Thanks for your patience,
Sure.
Mr. Burgess.
Well, we had to instruct the judge on the law.
You have reviewed this slide and this specific data in this slide previously, correct?
Correct.
And I just want to, Mr. Woke, just go back to the slide so we're clear on what this is. So this slide here is what you're speaking about, right?
Correct.
And you've reviewed this slide prior to your testimony in this court, correct?
And your report.
And you considered this slide as part of your analyses that you have performed and testified about, correct?
Yes, I have.
So now, Mr. Burgess, I'd like to
Go back to my question.
ask you a question. Every single one of the user interaction events that we talked about, steps, lock, etc., occurred after Dr. Welcher's, what he calls an infotainment event, which you call a text stream event, in the range of 12:31:38 to 12:31:43, correct?
I would agree that yes.
So the answer is yes?
With the caveat.
I'm sorry, I didn't know you hadn't finished.
Sure.
Please finish your answer.
Yes, with the caveat that user interaction only applies to the device lock, steps, and the pocket state are not duplicative of user interaction per se.
Let's just assume that is
Duplicative
the
or
case.
indicative? What the hell is he
Let's
saying?
then just focus on
I don't know
what you
what word he just
consider
used.
to be a user interaction, which is device lock, correct?
Correct.
And the device lock event that you agree is a user interaction, we could go back to that just so we have clarity.
Yeah, let's get some
The
clarity. Let's give him some
lock
clarity,
event
Alessi.
that you agree is a user interaction occurred at 12:32:09, according to Mr. O'Keefe's phone, correct?
Correct.
In that 12:32:09 time period, we could go back to Dr. Welcher, it is after the end of the text stream event dubbed as 11:62:2, correct?
Correct. According to
And that's
sorry.
26 seconds. I didn't finish my question. I'm sorry, Your Honor.
So go ahead, finish your question. Don't answer, Mr. Burgess, until the complete question.
In that event lock, even according to Dr. Welcher's own words in his own slide, occurs 20 seconds after the end of the text stream event 11:62:2, correct?
Of the unadjusted clock, yes.
May I have a moment, Your Honor?
Yes, do you want the lights on, Mr. Alessi?
I'm going to keep that up. And so to repeat to alter it, hopefully make it a little clearer. So according to Dr. Welcher, the licensed engineers, your colleague at Aperture,
He's
his
licensed.
slide that he has here, the last O'Keefe cell phone event, the lock, occurred within approximately 26 seconds after the end of the text stream event dubbed 11:62:2. That's what's stated there, correct?
Correct. According to the unadjusted clock.
You keep adding according to the unadjusted clock, but do the words according to the unadjusted clock appear anywhere in that slide, sir?
No, they do not.
He took into account some
We
adjustment.
can
I
take
thought.
that down
This
and
is-
with
this
the
is
court's
where it's
permission, turn the
getting-
lights back on, please.
I'm actually having
Yesterday,
trouble-
you stated that you
Pause it a sec.
reviewed a presentation by another expert.
and I did miss some of it this morning. So I'm having trouble understanding if the defense is actually parsing it to make it seem more misleading, or if this guy is just being an obstinate asshole, because it seems like Welcher gave a range that was supposed to account for some sort of clock drift or time drift. Is that not accurate?
Well, I mean, what he's insinuating is that Welcher never uses that terminology. The
Well,
thing,
no, I get that. I get that.
well, I think there's a little bit of both is the answer for you. I think that this guy's being an obstinate asshole, but I also think that Alessi's pointing out the fact that the report in and of itself is disingenuous in that he didn't quantify his answer by stating or accounting for this drift. You know what I'm saying? Like that's like, so he's trying to do both things.
I mean, let me see what the
All right, let's
chat
keep going
is
though.
saying. All right.
Expert presentation by yesterday you stated that you reviewed a presentation by another expert, Mr. DeSogra, who reviewed the findings of your January 30th report. Do you recall that, sir?
Yes, I do.
In fact, in your May 8, 2025 report, your second report, your first being the January 30th report, you only cite 2 new sources of data that you reviewed before making your conclusions, correct?
Correct.
May I have a moment, Your Honor?
Yes.
May I approach, Your Honor?
Yes.
need to be heard about on this as well.
Right.
He needs to be heard about Bubba. Right. So he keeps trying to add this unadjusted clock thing. But I think that what Alessi's pointing out is that in a sense, Welcher did, was adjusting for that. It was part of their entire first assessment because he was supposed to be doing a clock drift. He said that in some sort of clock drift analysis with which his first report, and then never said anything about this. And then Welcher gives a range, which clearly, if you knew the precise time, or were not accounting for a clock drift, you just give an exact moment in time. Right?
Yeah. I mean, in theory, I think the bigger takeaway really is that does the jury understand what any of this means?
I think they're hearing enough about this took place, after. And then they're hearing, obviously they are hearing the experts say, oh, but that's the unadjusted clock. But I think they don't believe anything this guy says.
Well, that's
He's either willing to lie, sloppy, doesn't know the science, is not properly trained. So I think that.
I mean, that's the takeaway. But he's got to cover both sides of it. Like he established that you can't trust this guy, but he's going to have to pick apart what he's been doing point by point, and whether it's a death knell to their overall.
As far as I'm concerned, and I'm sorry, babe, go ahead.
Like, I don't know that Alessi's like destroying their analysis completely in terms of what they came up with.
Death by 1,000 paper cuts.
It's
sure.
death by 1,000 paper cuts because they're not going to trust this guy. They already don't believe a word this guy says. So they want it there. But that's what I was saying yesterday. I mean, Bob's still got to go through and pick apart the timeline. Because I mean, they're going to have their own witness who's going to get.
I agree, Ann. Right. So, but as far as I'm concerned, none of these times even fucking matter. Yeah, you know what you're establishing? That's the time Karen dropped off John and the time she left.
Right.
We already know this. And nobody believes that she backed that car up and drove 20 some miles an hour and slammed into, but just clipped. I mean, you can't have it both ways. You just can't. So I think literally all they're establishing is Karen was there. Thanks. We knew that. Karen dropped John off. Thanks. We knew that. And then Karen left. At the end of the day, because I don't think that reversing means jack shit when you put all the, obviously, especially when you get to ARCA. But
I mean, all it means is that she wanted to head the other direction on the street. It's literally all it means. They've tried to turn a 3-point turn into a nefarious act, that it was an intentional act, and it's just not.
Looks at him in the rearview mirror.
There he is. I got him lined up.
All right. I'm gonna jam on my gas.
Yeah,
I'm coming.
Well, that's what I was saying yesterday. I don't give a shit what any of these times say because like Welcher and Burgess can kiss my ass. I don't.
What the hell happened to what was the thing last year?
What?
Whatever times the
key cycles.
Where are the key cycles? Because that shit was different.
It's totally different. Completely different.
Yeah, we're gonna ignore those this time around.
We don't care about key cycles.
No, because we got that all screwed up the first time.
Paul didn't really get it.
May I proceed, Your Honor, and approach the witness?
Yes.
Thank you.
No, Burgess lying is definitely a big deal. People are being stupid.
Each of which is marked for identification. The first is
D's right.
CCC for
put it right on their CV.
That is
cross-examined by Alessi.
Slide out of what is marked as Exhibit DD.
Peer-reviewed by Alessi.
For identification.
Talking about we should get CLE.
And
Yeah.
Exhibit
Lawyers,
CCC is one page.
Oh,
out of
yeah.
Exhibit
Oh, yeah.
DDD
Lawyers
for
should.
identification.
I think the experts should too.
And I'd
They
ask
keep
you, sir,
continuing.
to
Yeah,
take a
legal
look
education.
at
Sorry.
those documents and
We should.
reference either one.
Sorry, D. I'm just saying these
And
experts should get
please-
some continuing education from this too. Credits.
Reference
Sorry,
I-
yeah. We'll talk over it all. Go.
those documents.
You should get as a T-shirt that says "I survived an Alessi cross"
But I didn't.
and ellipses, kind of.
Documents and reference either one. And please let me know, sir, when you've had a fair opportunity to review those documents so I can proceed with questions about them.
Sure.
So the company put an asterisk
Okay.
against all their
Sir, can you
employees?
please read the exhibit designation on
Fucking
the
joke.
entire slide presentation?
On DDD,
Pardon me?
on D exhibit DDD.
And that's triple D as in David.
Correct.
So in exhibit
It's like I don't understand
DDD, is that the March 5, 2005 PowerPoint presentation of Mr. DeSogra that you spoke about extensively yesterday?
Yes, it is.
And sir, before you came to court yesterday, did you review and consider the exhibit DDD for identification?
Yes, I did.
And as a matter of fact, you spent considerable time with regard to exhibit DDD before you came to court yesterday.
Correct.
And in addition,
Mhm.
isn't it the
Spent some time.
case that your testimony yesterday is that exhibit DDD, the March 5, 2025 slide presentation of Mr. DeSogra, was part of the reason why you created your May 8th, 2025 report, correct?
Correct.
Let's test that
May I
logic,
quote, Your Honor?
sir.
Yes.
I'm about to test that logic with you, buddy. Here we go. See if that tracks.
Your Honor, I offer exhibit exhibit CCC into evidence and do not offer exhibit DDD at this time.
Okay, the witness just spoke of DDD, so why don't you have him just say what CCC is before we put it in?
I will do so, Your Honor. Thank you. Mr. Burgess, is exhibit CCC a slide page out of exhibit DDD?
Yes, it is.
Okay, now it'll.
Thank you for that, Your Honor. I now offer exhibit CCC for identification into evidence.
Yes.
Thank you. And I also hand back to Madam Court Reporter exhibit DDD for identification.
Exhibit 190.
And sir, do you have before you read the three letters, please, just so we're on the same page in that exhibit?
Jim, we need the
That
other
the one that's in
Agreed, Bella's
the
mom.
one page?
I'd never hire
Yes.
these assholes.
Exhibit 190.
And that's the entitled All Possible Combinations?
Yes, it is.
They're burnt.
So we'll refer to that as exhibit 190, okay?
Okay.
Have you had a fair opportunity to refresh yourself on that one-page chart?
Yes, I have.
I assume
Your Honor, may
Yes.
I please publish exhibit 190?
Yes.
mentioning Googling that
And if we could
word.
enlarge it
Steve.
without, I think, Mr. Wolk, we can
I wonder if
obscure
that's
for the moment
technically
the
allowed.
all positive on the right and
like-
come back to that as needed.
It's not like part of the case. It's not like science. It was just a word, right? I mean, I think you can look in a dictionary
you.
for God's sakes.
Now, Mr. DeSogra, who is an expert for the defense, took the data points you evaluated in your January 30, 2025 report and simply performed the last step in your analysis that I was referring to in previous slides, correct?
Correct. For a lot of data points that do not apply for the time of the accident.
I understand you may
Dude,
have a view
don't you
as to whether they
pause it.
apply or not. I'm
Pause
just
it,
trying
babe.
to understand
Just
what
real quick.
you understood he did.
I will
I'll
take
repeat
control.
that.
I will take control. You'll blip
People
back
will
5
blip.
seconds.
We all
Nobody
want
will miss shit.
We want to
Nobody
hear.
will miss shit.
All right.
This witness should not be able to say the words during a crash. He did nothing to do with the crash. He can't testify there was a crash. He's got a going in reverse. He should not be allowed to use the word. It's not relevant for the crash event. Call it the reversing event. Call it whatever the hell you want, but do not call it a crash event because you are not a crime scene reconstructionist and you have not done any testing to determine if a crash occurred. It should be stricken and he should not be allowed to say the words crash event.
Agreed.
All right.
I don't think Bob cares though.
For a lot of data points that do not apply for the time of the accident.
I understand you may have a view as to whether they apply or not. I'm just trying to understand what you understood he did.
Again,
I'll repeat that. Yes.
So we'll strike the comment part and just a
I'll
question.
repeat
By
and
whose
just go to
comment?
the question.
She better be striking his comment, the expert's comment.
So you
No,
understand
not no,
that
by this guy.
Mr. DeSogra took the data points that you evaluated in your January 30, 2025 report and simply performed the last step in your analysis, correct?
In my report, in addition to Dr. Welcher's.
Right. In addition to Dr.
Correct.
Yeah, he just did your
Now,
math there,
what
didn't
I
he,
want to
buddy?
do is just elucidate the columns and
Elucidate.
their meaning. So
I'm sorry, baby.
the column on the right
Sorry, it makes sense when I do.
equals the number of
You can do
seconds.
it. Pause it.
And is the far right. The number of seconds between the end of the 1162.2 text stream.
All right.
Okay. You'll rewind it. So if you guys remember earlier, Alessi said, but you did not take that next analytical step, did you? And the expert said no. And Alessi said, you know which analytical step I'm referring to, though, right? So this is circling back to that. Alessi is establishing all my expert did was that analytical step that you decided to just not do, despite both you and Welcher together providing the data points to do that next analytical step. So that's what all this is coming back to. And that's bringing Brennan back to, they were just fact checking their expert's report. No, it sounds like their expert was literally doing the last analytical step of the data provided in these two experts' report. So, I mean, I think he's going to flesh that out more, but that's what sounds to me like happened.
Yeah, I mean, you knew he was going to circle back to that.
Mm-hmm.
Asked him.
Oh, yeah.
The
Nothing's
column
by accident.
on the right equals the number of seconds, and it's the far right, the number of seconds between the end of the 1162.2 text stream event that in the slide of Dr. Welcher is ending at 12:31:43 and the lock event on Mr. O'Keefe's phone that's occurred at 12:32:09, correct?
Correct.
And that's your understanding of that column as well.
Correct.
Now, even taking your colleague Dr. Welcher's assumption that the last user interaction on Mr. O'Keefe's phone occurred at 12:32:09 a.m. on January 29, 2022, is Mr. DeSogra demonstrating in this chart that by using the clock variance that you calculated in your January 30 report, there are no circumstances where the trigger event of 1162-2 occurs before the lock event on Mr. O'Keefe's phone.
Objection.
After.
Sustained. There's one part of your question that needs to
Okay.
be omitted.
Can you
In
back
terms
that up?
of
Let's hear it again. Let's see what
this chart,
the judge
do you
thinks is the issue here.
in your
And look-
January, by using Mr. DeSogra demonstrating in this chart that by using the clock variance that you calculated in your
Mhm.
January 30 report, there are no circumstances where the trigger event of 1162-2 occurs before the lock event on Mr. O'Keefe's phone.
Objection.
After.
Sustained. There's one part of your question that needs to.
Okay.
Now let's
be omitted.
compare it to what he does now.
In terms of this chart, do you agree that the methodology and application of it of Mr. DeSogra is that Mr. DeSogra took the last user interaction data point of Dr. Welcher in his slide of 123209 and applied the clock variance that you calculated in your January 30th report? Do you agree that that's what Mr. DeSogra did?
No, I do not.
What do you believe Mr. DeSogra did here?
Well, so the math is correct. So
Okay.
when he's trying to adjust clock variances between the two devices, that math is correct, but he's applying incorrect adjustments.
I understand, but what I'm trying to get at is just what you understood Mr. DeSogra did in this chart.
Correct. I did understand, yes, what he
Okay.
was trying to do.
And so do you agree, based upon what Mr. DeSogra did as represented in this chart, there are no circumstances where the 1162-2 text stream event occurs? Well, let me have you describe what you believe
Thanks,
Mr.
Mr.
DeSogra is doing with regard to comparing, based upon this chart, the 1162-2 text stream event of Dr. Welcher with the lock event on Mr. O'Keefe's phone.
Sure. So he's trying to adjust the clock from the Lexus to the Mr. O'Keefe's iPhone clock, but he does that inaccurately.
Well, I understand you have I understand your comment. But my question, sir, is this.
Is he just applying
What
your
do you
numbers?
understand Mr. DeSogra is doing with regard to this chart? Do you understand what he is doing in this chart?
Correct.
I'd just like you to state what it is you understand he is doing.
Sure. So he's trying to adjust timestamps.
He's trying to adjust timestamps. In adjusting timestamps, do you agree that Mr. DeSogra makes the point with this chart that there are no circumstances where the 1162 trigger occurs before the lock event on John O'Keefe's phone?
Objection.
Sustained.
All right. Can I have
He's-
a moment, Your Honor?
Sure.
So he's not trying to say, do you think it's right yet? He's just saying, based on the way DeSogra did it, is that what his chart, is that what
Let
he
me
is
see if I
showing?
can clarify this in this my question.
Sure.
Do you believe, do you understand that what Mr. DeSogra is doing in this chart is he is showing numerically and arithmetically that there are
Mathematically.
no circumstances where the text stream event 1162-2 occurs after the lock event on Mr. O'Keefe's phone?
Objection.
I'm going to allow it in that form.
So yes, I understand he's trying to show that.
Right. Well, he did more than try. Isn't that what he, by his math, that he is demonstrating?
Objection.
I'm going to allow that.
Yes, but it is inaccurate.
I understand, but that's, again, the question is that what he demonstrates using this chart?
Yes.
Okay, now we're getting
And what
to
he
why.
demonstrates is that Mr. Tsoga demonstrates that there are no circumstances where the 1162-2 trigger event occurs after the lock event on Mr. O'Keefe's phone, correct?
Yes, inaccurately.
So I'm asking what Mr. DeSogra demonstrates in this report, and isn't it correct that Mr. DeSogra, using this math, Mr. DeSogra demonstrates and concludes that there are no circumstances where the 1162-2 text stream event occurs after the lock event on Mr. O'Keefe's phone?
Objection.
I'm going to allow that. Does that demonstrate that?
Yes, inaccurately.
Okay.
So let's.
I'm going to move on, Your Honor. I'm going to move on. And this methodology and approach of Mr. DeSogra is simply math that he's using, correct?
No, it's not simply math.
Well,
He said
let's
his
go
math was
to
right
the
before.
clock variance values in the middle column on that chart. You see that, sir?
Yes, I do.
Those are, as of March 5 of the date of this, that this column was created, nothing in that middle column is new, is it? That data.
Yes, some of that data is new.
Well, the source data upon which it is created is not new, is it?
No, it is not.
All right. So the source data of that column, it's not new.
Correct.
And the middle column uses your data points from your January 30th report, correct?
No, not all of those are.
But it does use some of the data from your January 30 report, correct?
Yes, it does.
Is the reason that you did not take that final analytical step that we've been talking about in your January 30th report, and this is a question, is the reason you failed to take that final analytical final analytic step we've been talking about in your January 30 report was because you knew if you did that if you calculated the actual time of the 1162-2 text stream event based upon your own methodological analysis of the clock skew, there would always be continued interaction on Mr. O'Keefe's phone after the text stream event.
No.
So you deny that?
Yes.
He always knew he was going to deny that, but the question is asked.
Did you keep your January 30, 2025 report purposefully vague by merely noting a clock skew without engaging in any further analysis, such as tethering that clock skew or otherwise connecting it to the text stream event in Dr. Welcher's slide presentation?
No, I did not.
Sounds like you did, buddy. Sounds like you
Switch
did.
to another topic. Take that down. Thank you, Mr. Woke. After reviewing, and I'm going to identify 3 timelines. After reviewing the timelines, the timelines presented by Dr. Welcher, 1, Mr. DeSogra, 2, and Mr. Ian Whiffen, 3, all of which established that the 1162-2 text stream event occurred before that last user activity, the lock on Mr. O'Keefe's phone. You then decided to issue a new report that would become dated May 8, 2025, correct?
Objection.
I'm going to allow that.
No, so I issued the supplemental report based on that presentation that you just had up.
Well, before you issued that report, isn't it correct that you had reviewed the time data of Dr. Welcher in the slide that we've been reviewing?
Not before that time, no.
You had not
What?
looked at Dr.
Preposterous.
Welcher's slide with a text stream event 1162.2 and a time for that before issuing your May 8th report?
No, yes, before my, sorry,
Oh,
misheard you, yes.
That's my question.
Yes.
So let me just ask it through a question.
Sure.
So it is correct that before you issued your May 8th, 2025 report, that you had reviewed that slide of your colleague, Dr. Welcher, on 1162.2 that establishes the text stream event as 12:31:38 to 12:31:43, correct?
Correct.
You reviewed it before your May 8th report.
Yes.
You
yes.
also
yeah, I meant
reviewed
yes.
before your May 8th report the slide presentation of Mr. DeSogra, correct?
Yes, I did.
And before you issued your May 8th, 2025 report, you also had reviewed the January 2025 report of Mr. Whiffen, correct?
Correct.
Yeah, I did all those things.
Each one of and all of those three established that the 1162.2 text stream event occurred before the last user activity on Mr. O'Keefe's phone, correct?
Yes.
I'm going to allow it if that's what, let's see what the answer is.
Using either unadjusted timestamps or inaccurately adjusted timestamps, yes.
Let me ask my question again, and if it's not clear, please let me know.
Sure.
After reviewing what we've discussed, prepared by Dr. Welcher, Mr. DeSogra, and Ian Whiffen, each and all of which established that the 1162.2 text stream event occurred before the last user activity on Mr. O'Keefe's phone, you then decided to issue a new report that would become dated May 8th, 2025. Is that statement I just made correct?
Yes, that is correct.
Okay.
Now let's take a look at your May 8th, 2025 report.
Son of a bitch.
You departed in your May 8th, 2000. Do you have that report in
I
front
do,
of you?
yes.
Do you need a moment to look at it, or are you ready to take
No,
questions?
go ahead.
Thank you. You departed from your analysis. Let's start it this way. In this May 8th, 2025 report, you departed from your analysis in your January 2025 report to reach a conclusion that would attempt to put the 1162.2 text stream event after human interaction with Mr. O'Keefe's phone, correct?
No, I did not depart from my original report. I clarified.
Okay. So you didn't depart from it, but you, in your May 8th report, but your position is you clarified it.
Correct.
But isn't it correct that in your January 30, 2025 report, you did not address at all whether the 1162.2 text stream event occurred before or after the last user event on Mr. O'Keefe's phone, correct?
Correct.
But you did that in your May 8th report, correct?
Correct.
You don't call that a change, sir?
No, sir, I do not.
You call that a clarification?
Sure.
I do.
Are you? Everything that guy just says is bullshit.
In your January 2025 report, you compared call log entries between the infotainment system on the Lexus and Mr. O'Keefe's iPhone to determine a potential variance, correct?
Correct.
And call logs are discrete points in time that are fairly easy to compare.
Correct.
Now, in your May 8th, 2025 report, you abandoned the call log analysis from your January 30th, 2025 report, correct?
No, I did not abandon it.
I've been touching
But
buttons all
you
morning.
did depart from it, at least in some respects, correct?
I did not depart from it. I used another method.
Oh, I changed my. Is that another way to say I changed my methodology?
So you used another method.
Correct.
Woo!
In your May 8th, 2025 report, you opined, as I understand it, that the call log variance has been ignored because, in your words, this offset is measured approximately 5 hours after the time of the alleged collision and cannot be assumed to apply to other timeframes as stated in the initial report. Do I have that right?
Yes.
Now, please show me, show the jury, in your January 30 report where you ever made that statement.
Oh, he's going to actually look. I love it. I love it. I
You know where he does that thing where he looks for something that doesn't exist and he knows that it doesn't exist.
Right. I wish he was twirling his little patch while he was looking.
The tough.
Okay, the tough. Whatever it is.
You can
I need
always
him to-
tell his mood from his tuft. His tuft is sad for it.
Oh, God. I used a different method. I didn't change my method.
Sure. So that would, it's not worded exactly like that, but that would be in conclusion 5.
Okay, let's see what he found. So you're going to tell me.
Conclusion number 5
This means I just
is
said.
on page 37 of your January
Blah, 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 blah.
30, 2025 report, correct?
That you
Correct.
did?
And you concede at least as much that at least different words are used in paragraph 5 in your January 30th, 2025 report, correct? And your position is that it's the same statement as in your May 8th, 2025 report? Because that's my question.
That is correct.
In your May 8th, 2025 report, instead of applying the offsets from the call logs, which are discrete points in time that are fairly easy to compare, as you stated just moments ago, you decided to use, in your words, quote, approximate time
You know, that vague
of
thing I
the
mentioned?
3-point turn as your anchor between the two devices. Do I have that right?
Yes, you do.
Starting to sweat.
Isn't what you did and we just discussed a classic example of confirmation bias, which is to be avoided in science?
No, it is not.
Absolutely.
So
not.
you believe that that is not confirmation bias?
No.
Are you sure?
Choosing the 3-point turn as the independent data source is the only way you could ever get the text stream event to even possibly occur after the lock event on Mr. O'Keefe's phone, correct?
That adjustment is the only adjustment that can be applied due to the data. Yes.
And that adjustment is the only thing that can be done to get the text stream event 1162.2 to occur after the lock on Mr. O'Keefe's phone, correct?
Correct.
Yep, that's
And
the
that
only way. to
only
make this
one
shit work.
is the one that you chose, correct?
Correct.
And that's only because it's not a pinpoint in time. It's an amorphous range that can only, in your words, be approximated, correct?
No, that is because it is the only time adjustment in that time range that can be applied.
So
But you applied a different one.
it's your view that that's the only one that can be applied, but it is even what you're using is, in your words, an approximate time, correct?
Correct.
Oh, I thought you said precisely
Isn't
to the second.
the shortcoming, sir, in
Which
your
is it?
analysis that you ignored the additional user activity on Mr. O'Keefe's device that
Mhm.
occurred after the lock event?
Can you repeat that question?
Yes, I can.
Yeah, we're going to repeat it.
Isn't the shortcoming in your analysis, sir, that your analysis ignores the additional user activity on John O'Keefe's device, his cell phone, that occurred after the lock event?
No.
Well, let's take a look at events
Yeah, let's check your
that
self there.
you tell me if I'm correct or not, occur after the text stream event 1162.2.
Sure.
So do you recall our discussion yesterday about the Apple Health data event of 36 steps covering a distance of over 84 feet? Do you recall that?
Yes, I do.
And do you recall that that occurred at 12:32:16?
Yes, I do.
Mhm.
And that's after the text stream event of Dr. Welcher that he put in his slide, correct?
Correct.
Do you also recall a Doppler pocket state detection at 12:33:14? Do you recall that?
Yes, I do.
And that is almost an entire minute after the 1162.2 text stream event that is identified by your colleague, the licensed engineer, Dr. Welcher, in his slide presentation,
A
correct?
licensed one.
Correct. And neither one of those are user interaction.
I understand your, well,
What?
but let's just take one of them.
Sure.
And that is the Apple Health data event of 36 steps covering a distance of 84 feet at 12:32:16. Would you agree that those steps covering that distance is human activity at least? Would you agree that's human activity?
Yes.
Thank you. Let's take a look at opinion number 7 in your initial January 30th, 2025 report. And sir, tell me when you had a fair opportunity to locate that.
Okay.
It's like Bob's got his
You
binder.
concluded to a reasonable degree of scientific certainty that, quote, the infotainment module power on events were on average recorded 3 seconds after the ignition release or finger off, correct?
Correct.
That means that your own testing
Mhm.
requires an offset of -3 to account for a delay in the power on of an infotainment system, correct?
Correct.
That increases the time between the text stream event 1162.2 and the iPhone lock event by 3 seconds, correct?
Correct.
You testified about this same 3-second discrepancy yesterday during your direct examination in connection with your January 30,
Did you not?
2025 report, correct?
Correct.
However,
Mhm.
you did not mention this offset of 3 seconds in your May 8th, 2025 report, did you?
No, I did not. Can I explain?
Mr. Brennan may
Yeah,
have
go
questions
with
for
Brennan.
you with regard to that. So nowhere in your May 8, 2025 report did you include the 3-second offset that you discussed in your January 30, 2025 report, did you?
Correct.
And in fact, sir, nowhere in your May 8th report do you even discuss why you're not addressing that 3 seconds, do you?
I do not discuss it, but it is that offset is adjusted within the adjustment that we do with the 3-point turn.
I understand. My question is simply, there's no discussion in your May 8th, 2025 report how or why you're not discussing that 3-second offset, correct?
Correct.
Correct. There's a T.
I was trying to keep it vague, because we needed to adjust this shit later.
I've got a
So-
next section, Your Honor, if you would like me to move into it.
So why don't we keep going?
Okay.
Oh, let's keep going.
Sir, a text stream data event like 1162.2 does not, well, let me back up this way. You testified on direct that you're involved in accident reconstruction. That's part of the work that you do, sir?
No, that is not part of the work that I do.
Well, let me clarify then.
Mm-hmm.
Do you at all understand whether there's an issue as to whether a collision actually occurred in this case? Do you understand if that's an issue?
Objection.
Sustain.
What?
Sir, do you have any understanding about
Whether a collision
what
occurred?
Dr. Welcher in his slide presentation was addressing in context with this case? Do you understand it?
Objection.
I'll allow a yes or no on that.
No, I do not.
So
What?
you have no idea
What
what your colleague, Dr. Welcher, who's working on the same case, was addressing in his slide presentation?
Generally, yes, but I cannot speak to it.
What
That's
do
not what
you
he asked you.
generally understand?
Objection.
Sustain.
We need a sidebar.
What understanding do you have after reading Dr. Welcher's slide presentation?
Objection.
Sustained. Ask it to.
Do
Sustain.
you have any understanding? Can we approach, Your Honor?
Sure.
Yeah, I mean,
Joel.
one of the things that he could be asking is, are you under the impression that there was
Oh,
a collision
coughs.
a collision that occurred in this case or something? I mean, he's trying to show confirmation bias. He needs to be able to know what this witness knew and what information he had. I don't understand what her issue is.
Oh,
Do we-
anger bias.
bloop,
You
bloop,
know, that, like
blooping.
that he had a well, we have some blooping, but I thought I'd save it for the morning break.
All right, yeah, and let's go
But
through
before
some
we do that,
questions.
we all know what happens at a side, like when it's a sidebar, right?
Can we turn that one down?
What?
It's loud. It's
Is
so
that a
loud.
loud one? That is a loud one.
All right, what time is it? 9:50. Let's see.
All right, I'll do a little blooping. Bloop, 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 bloop,
Mickey says,
bloop, bloop.
"Are we as certain about that, sir, as we are about your education?" I mean, he said the words, "I used a different method. I didn't change anything. Nothing was changed. I
Correct.
used a different method."
Correct. That's correct.
That's correct.
All right.
Thank you, Stephanie.
He doesn't have a
Gifting
T at the end.
Membership.
Correct.
Hey, I heard yesterday that a bunch of people had donated like $50, or at least somebody. Did you let them know that they have the opportunity to leave a wonderful voicemail? Because
Somebody in our chat when we played Mags is like, oh, so we have to listen to some rando saying rando shit for 4 minutes. Keep it to a minute. I'm like, no, that's not how that thing works, dude.
well, we could keep it to a minute for the live ones.
Absolutely not.
Bob says no. He's like, what one jerk off says. I'm sorry, buddy, whoever you are, you're not a jerk off.
Let
What
the
one
peop-
guy says is not dictating what I do here.
let the people speak.
Let the people speak.
Let the people be heard. That's where I'm at. This is a long sidebar. See, I just blooped all our shit away.
Well,
No, we're live.
we're live.
Wow,
We're live.
that's terrible.
Did you answer? You did all these supers so far? Every one of them like had a little.
I've been popping them up.
All right,
Okay.
well, we'll discuss them again on the morning break. I got court this afternoon.
You do?
Yeah.
Fuck you. Love you, babe.
I need water. I realized I just drank out of this
May I
cup.
proceed, Your
from
Honor?
Thursday.
Thank you. Thanks for your patience, Mr.
Yes, sir.
Burgess. I would like to go back to the line of questioning I was starting, and that is I would like to discuss with you, and I'll start with your conclusion, and I'm going to
Jennifer's
reference your
comment.
May 8th, 2025 report, sir. If you could turn to the conclusion section of your report, which is on page 7. And I'm going to start with, and I may just end with, we'll see, conclusion number 1. Please take a fair opportunity to read that. Pick your head up when you have concluded that fair reading.
Correct.
All right, I'll go get her, have a drink. I'll go grab a drink.
Correct.
Watch you guys on my phone.
Pick my head up, but my
Now, that paragraph 1 states, under conclusions, you say the following can be stated to a reasonable degree of scientific certainty. 1, as noted in my initial report, the only call logs that can be used to compare and synchronize the clocks between Ms. Reed's Lexus and Mr. O'Keefe's
Can't go
iPhone
yet.
are those occurring between 5:21 a.m. and 5:30 a.m., which occur approximately 5 hours after the collision. You see that, sir?
I do, yes.
Now, what I'd like you to do is to go back in your report.
Same report?
Yes, sir, same report, May 8th.
Yeah.
And I'd like you to turn to
Okay.
page 3.
Okay.
And if you could go to the 4th full paragraph that begins with 2 events near the time. And let me know, sir, when you're there. And if you could read that paragraph, pick your head up after you've had a fair opportunity to read it.
We were just in Denver. You gotta keep hydrated with the altitude changes. That might be
Okay.
what's happening.
Thank
We're
you.
just gonna have to wait. And see.
Now, you state 2 events near the time of the collision were recorded by the Lexus system as identified by Dr. Welcher and referenced by Mr. DeSogra. The first event, labeled TechStream Event 1162-1, is associated with a 3-point turn on Cedar Crest Road. The second event, labeled TechStream Event 1162-2, is associated with a reverse maneuver on Fairview Road. These events will be referenced below for clock synchronization analysis. The timestamps associated with these 2 events are based on a combination of the Lexus infotainment power on event and TechStream time count. Did I read that correctly, sir?
Yes, you did.
So in the same paragraph, am I correct that you're discussing a couple of TechStream events, 1162-1 and 1162-2?
Yes.
And you are talking about that TechStream event in the same paragraph as you're talking about an alleged collision, correct?
Correct.
And in your paragraph of your conclusion that we were referencing,
Thanks,
conclusion
Clemens.
1, is this paragraph part of the basis for that conclusion 1? Is this sort of like some predicate analysis for conclusion number 1?
No, it is not.
So it has no, your view, it has no relationship whatsoever to conclusion 1.
No, correct.
So let's go to your discussion of a collision and a tech stream event. Let's go back to paragraph 3. You mentioned the word collision in paragraph 3, correct?
Who in the hell told you there was a collision, buddy?
I do not.
I'm sorry, I just had paragraph 3. I meant page 3, sir. Page 3.
Yes, page 3. Yes.
Page 3, that paragraph we were just looking at, paragraph 4.
Yes. Sorry. Yes, I do say
You
collision.
see the word use of the word collision.
Yes.
And again, that term is used in the same paragraph as you're identifying tech stream event 1162.1 and 1162.2, correct?
Correct.
Where did you get
Who
the
in the
basis
hell told
to
you that?
use the word collision at that part of your report?
That would have been from crash reports.
And
No,
who's
crash reports.
The Massachusetts State Police.
So
What?
you used Massachusetts State Police
Maybe he
reports
means-
to discuss allegations of
Oh.
a crash, collision.
Yes.
Do you state anywhere in your
I guess yeah.
May 8th report that you
Because yeah, there are
used those reports at all? Do you list it in your references?
No, not in this report. No.
Oh,
And as a matter of
oh,
fact,
oops.
this is the first time
You're
right
saying the
this
words.
previous moment that you
Right
are
now.
mentioning those reports at all, correct?
Correct. No, those were mentioned in my initial report.
But I'm talking about your May 8th report.
Yes. Sorry. Yes.
Okay. Your
He's got to mean Trooper
statements,
Paul's
and
reconstruction.
I want
right?
to clarify this because this is the ultimate
Don't
topic I
crash.
want to go to.
Correct.
It is not your conclusion that every tech stream data event means that there is a collision. Do you, sir?
It's got to
No,
be.
that is not my conclusion.
So isn't it correct that you can have tech stream events and they're not collisions?
Yes, you can.
And isn't it a fact that a text stream event, sometimes called a trigger event, is not like an airbag type deploying, correct? They're just, and we're going to get to this later, it's
That's
just
true.
something that happens with a Lexus vehicle that can cause the vehicle to register a text stream event, correct?
Correct.
And some people refer to text stream event as a trigger, correct?
Correct.
But there's many things that can happen with a vehicle that can cause a trigger, correct?
Sliding in the
Correct.
snow in
We will
reverse.
come back to that. So you would agree, again, that a text stream trigger event does not
Buckle up,
mean that there was a
Buttercup.
collision, correct?
Correct.
A text stream data event doesn't mean that airbags were deployed, correct?
Correct.
A trigger data event doesn't mean that there was a vehicle impact, correct?
By itself, no.
By itself, it doesn't mean, correct?
Correct.
A text stream data event merely refers to Lexus's practice of capturing real-time data from applications databases and not devices and transporting that data for immediate processing and storage or for real-time analysis and analytics reporting, correct?
I don't think I understand your question. If you could rephrase.
Sure. A text stream event merely refers to Lexus's practice of capturing real-time data from applications and databases. Is that correct?
I would not call it applications and databases, no.
What would you call it?
So from various sensors or other modules on the vehicle.
Okay, so
Sure.
it's Lexus's practice of capturing real-time data from various
Various
sensors and modules on the vehicle, right?
Correct.
Why don't we stop here, Mr. Alessi?
Yes.
Okay.
Yeah,
Oh,
yeah.
so
Why don't we
take our
stop him
morning
right in the
recess.
middle? He tried to tell you he was changing
All
gear.
right, please.
Correct.
I need to continue to discuss this whole thing. What in the hell is he talking about? Somebody said he didn't see Trooper Paul's report. So what crash reports are we talking about?
Like what what you prepare, like, so if you get in an accident in Illinois,
Right, but there was
yeah,
no crash report because there was no accident reported. They just came up with this theory sometime after the fact.
I don't know. I don't know what the fuck he's looking at. Correct. Yeah, I don't know what he's looking at. Like in
I was starting to think, all right, it's Trooper
being,
Paul.
Alessi's being very vague with regard to the crash report.
No, it wasn't Alessi. He said, Alessi's like, where did you
I know, but
used
Alessi's not like trying to nail him down on it
right. So maybe he knows something we
for a
don't know.
reason, right?
Right.
Some kind of reason.
Yeah, maybe after the break they'll be like, "Can you figure out what the hell what the hell crash reports he talking about?" But
Correct.
if it doesn't come back, I'm gonna just assume there's something out there that they drew something together, drew up something based on Trooper Paul's reconstruction. But I mean, usually a crash report is done like at the scene when somebody.
Well, I mean, it depends. Like there's two types. There's the crash report that a cop will make in terms of if they got witness statements, they'll list the vehicles that were involved and all that kind of info. But we in Illinois also have to prepare a crash report.
What do you mean?
Like we get into an accident, like I have to you have to fill out a crash report
Yourself with your own hands?
and send it in to the Secretary of State.
What?
Yep.
Since when? I've heard if you leave the like if you guys don't report it right then, you've got a certain number of days to go back to the state police and report an accident. But I didn't know we actually we the people actually handwrite our own crash reports out.
Yeah, I mean, you're supposed to. There's like a requirement in Illinois. Requirement. It's required. Correct.
About this.
Correct.
I'm trying to think, did I never get in an accident in Illinois? I'm a damn good driver.
Wow. I'm just gonna let that like lay there and fester. Yeah, I mean, here's where I'm at.
That actually
guy.
Right. Sorry.
It's like no, I mean it's like you're kind of getting lost in the weeds, not you, just like in general with this shit. And at the end of the day, none of it matters.
No, I agree. None of it matters. We started with that before. Okay, so you have proven through all of your testing and all of these reports and different that Karen Reed, she drove in a car she drove John O'Keefe to 34 Fairview.
Correct.
Holy and
correct.
Not only that, sir, she dropped him off there.
Sure. Correct.
But even more than that, she left after that. Left 34 Fairview.
Sure.
Oh no.
Correct.
But
correct.
In addition to all of that, she turned around before she left to head the other direction.
She did a 3-point turn. That's correct.
Oh my God.
Correct.
Case closed. Case closed. They did it. They did it.
Yeah, all of this is for naught. Like it just doesn't matter.
No.
Wolf and Rensler see to that.
Yeah.
I mean,
but they're going to show a really big difference between. I mean, what about this morning? He's like, what word did he use for like when he was like, okay, but you testified all this shit happened on the 29th. You're literally here to talk about how seconds matter to the T, to the second on the day. But everything you just said is bullshit because that's actually after midnight. So, and he said, yeah, except for cadence. I think that's what he said, except for the cadence.
Right.
It's pretty goddamn important.
God damn it.
I mean, what in the hell? Yep. He just misspoke some. So Jennifer makes a real good comment here. Aperture's slogan didn't age well. We exist to shine a light on the
We kind of do.
Sometimes. The truth is different things. The truth, asterisk, truth as defined in the undefined regions. Truth
is slippery.
The truth
Aperture.
is vague. It's a vague truth. It's vague.
It's vaguely correct.
I honestly, to tell
Mandy,
you the
we
truth,
need it
Shannon,
correct. We need it
how
correct.
often is judicial misconduct actually pursued? Honestly, I honestly do not know. And like I get the general feeling that it's very not often.
Yeah. So I mean, there's been plenty of times when Allison and I are like, man, we should really file some kind of shit against that judge, and never do.
Right. I mean, the lawyer can't really, because even if you write it anonymously, they know damn well who did I do that to? You know,
100%.
and I think the ones they get from people are often such shit, you know, like this judge made this horrible decision and like what they're saying doesn't make any sense, you know, that they're probably very, very often just like
so grilled
dismissed.
cheese. Thank you. Taking the LSAT in a couple of weeks. Any advice?
Practice tests. I mean,
practice tests and just really just do thousands of the multiple choice questions.
Yeah.
You can't do enough of them.
And the time.
Here's my biggest piece of advice on taking the LSAT, which it's the law school aptitude test. So if you are, because time does not move in a normal fashion. And for any of you out there that have taken exams that are lengthy, you know how time moves. It's like time moves much quicker.
Clocks are different.
Do not get caught up on a lengthy question in terms of it's got a very long hypothetical. Just move on. You're better off moving on past those questions, and if you have time at the end to come back. So go through, kind of like leave that one blank if there's long, because if you get bogged down on a long hypo, like a hypothetical, and you can eat up 10 minutes.
Right. And then I just don't remember though, babe. She's got to look at what they say. Is it better to guess or is it better to leave it blank? Because I don't remember how it works. It could change. It could be different when we did it.
Well, I think that as far as multiple choice, the rule of thumb has always been, at least what I've heard, is to always pick the same letter. That you're
when you're guessing.
If you're going to just guess on certain questions, you're better off, instead of trying to be like, I'm going to go with this one. You should always just go all C's.
Grilled cheese, Google it. Right, because sometimes they say don't guess. It's better to leave blank than guess, and sometimes they say it's better to guess. So I can't remember
why would leaving it blank.
I don't remember, but I don't want to be the one giving her bad advice or him.
Yeah, like I'm not going to even take a shot at getting it right, so I'm just going to leave it blank.
I don't know. You're right. Yeah. Okay, Proctor's dishonorable
advice. I want you to ignore. My advice is to ignore that last bit of advice that Allison just gave.
I told him to Google it and decide what the best way to do it is. All right, Proctor. We're moving on from the LSAT. Proctor's dishonorable discharge.
I love that LSAT question. I crushed the LSAT.
You did.
I did.
I was just. What is happening here?
Let's see.
I was just reading Proctor's dishonorable discharging. You clicked on.
Well, I think
Bob and I are going to start to have to battle through the screen here.
Impeaching Hank while we're at it. Did you hit that one from 5 a.m.?
All right. You know what? You go up and start where you left off, because I honestly don't know. But now that Proctor's is up, let me just deal with this. Imagining a rat caught in a trap using the trap bar to do push-ups. The rat would be Man-Shan.
Man-Shan. Yes.
Quite a picture. Thank you.
And Man-Shan. I was coming up with all kinds of nicknames for him in my brain. 5 a.m. I see you trimmed a little of the fat off your moniker there. 5 a.m. It was longer. Now it's just straight up 5 a.m. I like it. Brevity.
Are we on? Oh, is that, man? I thought it said Sam. I'm like, what are we talking about?
I mean, it could be. It's really, well, it is, but it could be Sam as the name and just being clever, you know. So Sam says impeaching Hank while we're at it, lying sex. Yeah.
Yeah, I heard your point that he got that in there early on.
Did
he being
Alessi. Little dig.
Little dig.
Thank you. Kitty Beans, thank you so much for that $5 super. And I got a Venmo from Sarah. Thank you very much. And she had a nice little comment, which I'll read. Sarah had said, "It's Sarah." I think my YouTube is psychic. I think she was writing psychic. Anyways, I still can't figure out how to gift memberships on the channel, but love you guys. I'm a week behind trial, but want to get on the wheel and whatever, and also support the fam.
All right, you got to put her name around for the next wheel.
Yeah, for the next wheel, I'll definitely put it in.
So Jen, she says it's a new luxury SUV. It would beep when you back up and before you hit something. Typically, I would agree with you, but Bob and I have a new luxury SUV, and if there's snow on it, sometimes it's already beeping. So I would say I haven't had it not beep because of like the snow or the weather. I've had it over beep to such a point where I'm like, all right, I'm ignoring the beep at this point unless I get out and like clear the sensor or something.
And interestingly, with our vehicle, it only does that like auto brake ramming brake thing it does if we're going like under 5 miles an hour.
Did you double check that?
Yeah.
Yeah, I guess they don't want to give you whiplash. But what Bob's describing is like if it thinks there's something behind us, even if it's not, I mean, that thing will slam on the brake where you actually now think that you have hit something because the force was just so abrupt that you're like, holy shit, did I just hit something? Like I could definitely see myself
horrifying
hitting something and not thinking I hit something.
I always think that I hit something when that thing slams on. It's so violent.
Right. That's why I'm saying you might actually at one point in time hit something and then be like, oh, that was that thing the car does when I didn't hit it.
Right. Cat Tracks. Oh, family hug. Welcome. And to all of our cupcakes that are stepping out on Melanie, don't worry. We have a hall pass. Melanie gives you guys a hall pass. We have great love for Melanie and all the cupcakes. I'm sure some of you dipped over here over on the break. Be like, hi.
Now they're gone. They're like, we gone.
We go. Hold on.
Matt Lap 4 says, do you think the jury is lost now? This feels like over the top. The jury is probably lost as I am. I mean, it's definitely a possibility that they are lost. I think that there's certain things not lost on them, though. I can tell you yesterday I had the channel up while I was with my family, and my mom was shocked about the guy's education and the lying. But then like several minutes later, she was like, are we still talking about him lying on his application? Are we still on his CV or his education? She's like, shouldn't we have moved on from this yet? And I was like, all right, well, let's listen a little longer. And I hear Alessi say, so this is the third example of you. And I was like, all right, well, that explains why. So that he clears up it wasn't just a mistake the first time, an oversight one time. You got the misspoke,
correct,
the oversight.
That's correct.
And then the I don't know. And I'm like, wait a minute. He not only lied and made it appear as though he got a degree, but he got a degree the school doesn't even offer. He got a degree that the school, he said, oh, that should say a degree in general studies. What? With a minor.
Correct. That's correct.
So I do think that there are parts of it that they are probably lost on, but I again, like, I don't think the overall message is lost on them. I think that they are left thinking, I hope at least, that they are left thinking that this guy used a different method. I mean, I hope Alessi starts to highlight that. He said, I used a different method. I didn't change anything, but he used the only method that, this different method came into being once they needed to adjust the time so that the last human interaction occurred before John O'Keefe was supposed to have been hit by the car. Cristobal Mateo says it's not a lie.
I wanted to chime in.
Sorry, babe.
I think, yes, I think the jury is a little bit in the weeds, like on all of that, but that's a win for the defense, frankly. Like if you're in a position where you can kind of cloud up an issue, and for the Commonwealth, this is their whole case. If you can murky it up enough to where you're then following it up in your case in chief with some really, really clear evidence that there was no motor vehicle strike here, it just works. You know what I mean? I mean, sometimes you're just going to be presented with evidence as a defense team or a defense lawyer wherein you're not going to be able to disprove it per se. And again, we don't have any obligation to prove anything at all. But if you can murky it up, make it confusing enough to where the jury's like, I don't even know what the hell they're talking about, really. It's like they keep talking about like all this shit and like my head's spinning and I don't know what it means. And then in your case in chief, you're not even talking about that shit, because all you're talking about is what really matters here. Was John O'Keefe struck by a motor vehicle at all? At all. And you've got two really educated, really well-spoken guys that actually know how to say the word correct, who are going to lay it out for the jury, led by Bob Alessi, in a way that's so crystal clear that they're going to walk away from that testimony, no matter what they get into in the weeds with that the end result of that is going to be that two things are true. One, that the Lexus and the damages that was sustained on the Lexus was not as a result of a impact of the human body. And two, that John O'Keefe's injuries are not consistent with a motor vehicle pedestrian strike. And that's it. That's all you need. Because I mean, that is reasonable doubt. That's all it is in terms of, and that's all you need to walk Karen out of that courtroom, free woman, and never having to worry about this shit again. So, I mean, yeah, like I think that I understand and I agree with why Alessi's doing it, because he has to. But I mean, just in terms of the way that they were able to absolutely destroy his credibility leading into all of this shit that we've heard today, like this dude is the grain of salt. I mean, everything that he has been, everything he's saying is taken with a grain of salt, with the premise that he's a fucking liar. So, it's like, you address it because you have to, but like they got the win on this guy yesterday. So no matter what's happening today, like in my opinion, matters not. So.
Did you read Norman Corey's?
Oh, Norman, Alessi needs to ask this guy if he is aware that the trigger happened while in state police custody. If it was not the tow driver, it was the state police, 1162.
I mean, I think this goes, I think what Norman's talking about is like when they use the
key cycles,
it shows a different, and Norman, if you can,
see, I loved the key cycles. I thought the key cycles were awesome, because I mean, it was number one, it was a great way to just destroy Trooper Paul beyond what they were already doing to him. But I mean, to me, I walked away that was definitive proof that there was another key cycle.
Right. I think that if there is a discrepancy that they can point out with that, Alessi's going to circle back to it. Or if there is truly like a glaring discrepancy in the way they interpreted the data, and if that data can even be trusted, do they have to call back Trooper Paul to get in, this is what you testified before, Now
that's the $1 million question. Like how many of the Commonwealth's witnesses that testified in trial 1 that Hank Brennan has zero intention of calling in trial 2, and not so much, you know, the Higginses and the Proctors, but like their expert, like a Trooper Paul. I mean, do you put that guy? I mean, you almost need to put him on just to illuminate what the Commonwealth came with at the first trial in terms
If it's
of
very different. If it's very different. Yeah. And if
It's
there's
gonna be
I
completely
can't
different.
remember all the discrepancies now. Like if any of this really changes like their key cycle analysis. I do remember there were issues with it. You
It
know,
doesn't sound
but
like it's going to be in terms of the how John was struck. I mean, like the side swipe doesn't sound all that different than the pirouette.
right. So that there might not be that much of a point to call him, but I don't remember, you know, all the
I just
discrepancies.
want to get him on the stand to shine a light on the fact that this is the bullshit that they tried to put to the
Yeah.
jury first time.
And I
Like-
don't know that if
Right.
it just depends how that's what I'm saying, depends how differences. Did you read Cristobal Mateo's last comment?
Cristobal Mateo, thank you. It's not a lie if you believe it.
George Costanza. Yep.
Oh,
Very, very true.
uh,
Gigi
super-
says, remember, Alessi asked Hartnett about the odometer reading if anybody took the odometer reading. Right. So maybe they were going to circle back to the key cycles and stuff. All right. So Mandy says that a lot of people in chat are asking to watch the microdots video. Mandy, if you text it to me, she's probably gonna be like, I already have. Look at your text, Sally. I'll put it up while we're
I can find it real fast.
on. Well, we don't know which video they're talking about. They've
Most
done lots of videos.
I think it's the most
Oh.
recent one.
Oh, I gotta shit.
Yeah, we'll pull it up. I'll pull it up right now. It's 8 minutes.
Oh, Allison.
Hey, oh, Allison. All right, let's watch a little dots. Let's watch the dots. All right, so pull that up. We'll keep an eye on the fan, y'all. Don't worry. Don't worry. Okay. All right, so this is the one.
Special thanks to Olivia Lambo for pointing this out.
Olivia
Follow her on
Lambo
X.
getting love.
Let's set the stage. It's day 18 of the grueling case against Karen Reed. Judge Beverly Cannoni, long accused of harboring a bias in favor of the prosecution, is eager to wrap up an excruciating day of cross-examination. On the stand is Commonwealth expert witness Shanon Burgess, who's just been exposed for lying about his educational credentials and misrepresenting his communications with lead prosecutor Hank Brennan. And Brennan himself has been hemorrhaging credibility for putting such a deeply flawed witness on the stand in the first place.
Were you notified within the last 72 hours that someone from the defense accessed your publicly available or viewed your publicly available LinkedIn account?
Correct.
No, I was not aware.
Can we put up microdots
Yeah,
thingies so people know where to follow?
Aperture Forensics to remove that link. They must have been notified somehow that his educational background was of interest to the defense, that is information only he would know as the holder of the account.
Are you aware that within the last 72 hours, that hyperlink on Aperture's official website was disabled?
Ooh,
No, I was not
disabled.
aware.
Are you aware that now if you try to go on that link, that you can't, that it's disabled?
No, I'm not aware
Ooh,
of that.
disabled. I wanted him to do an in-court demonstration
Do you
right there.
know whether anyone from Aperture directed someone within Aperture to disable your LinkedIn account within the last 72 hours?
No, I'm not.
Have you spoken to anybody at Aperture about your LinkedIn account?
No, I have not.
And at the end of his disastrous testimony, Aperture Forensics went a step further and added this watermark stating, not for expert designation to his biography on their website. Another reputation ruined for taking part in this fabricated case. Burgess is experiencing involuntary facial spasms under the extreme pressure.
If I did the math correctly, sir, you've been pursuing a Bachelor of Science degree for 17 years, correct?
That is correct.
His LinkedIn,
What about
his
the
credentials.
That is just
Anything on his
not
credentials
even.
at all?
Idea of anyone. It's called fraudulent. It's fraudulent. It's a lie.
And you have not obtained it as you sit here today.
That is correct.
Correct.
And yet there are the various documents that we've seen that state that you have obtained the Bachelor of Science, correct?
Again, with errors or misinterpretation. Yes.
Once Robert Alessi finishes dismantling the witness over his false claims about his credentials, he shifts focus to the larger issue at hand. He presses Shanon Burgess on the revisions made to his report, alterations that conveniently adjusted the Commonwealth's timeline midway through the trial. Although Hank Brennan previously claimed to be surprised by the updated report, no one seriously believes that. Alessi methodically uses the report's own language to demonstrate it was, in fact, revised at Brennan's direction.
You did delve into that, and pretty heavily, in your May 8th report, correct?
Correct.
And you delved into that pretty heavily in the middle of this trial, correct?
Correct.
So after the trial, do you know the trial started around April 22nd in this case? Generally?
Yes, generally.
So let's do the timeline on this. January 30th, 2025, you prepare your initial report, correct?
Correct.
In that initial report, you mentioned nothing about text stream event 1162.1, correct?
Correct.
In that report, you mentioned nothing about text stream event 1162.2, correct?
Correct.
The trial starts April 22nd, correct?
Correct.
Roughly.
Generally.
No, the trial in this case, this trial, about April 22nd. After the trial starts and after witnesses, of course, are appearing, you prepare another report, correct?
Correct.
And that's your May 8th report,
Correct.
right in the middle of this trial.
Correct.
There we go.
I'm going to read the first line of your May 8th, 2025 report.
Okay.
Do you have it in front of you, sir?
I do. Yes.
It starts, "Dear Mr. Brennan." Do you see that?
Yes, I do.
"Pursuant to your request," that's the request you're referring to of Mr. Brennan, correct?
Correct.
"I have completed an additional analysis concerning the above referenced matter. To formulate opinions, the following additional items were reviewed." This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
My God.
At this point, we are approaching the end of the day in Judge Cannoni's three-ring circus, but she saved her most disgraceful trick for last. Robert Alessi is zeroing in on the moment that matters most. After methodically laying the foundation, he's now ready to challenge the discredited witness on the centerpiece of his revised report, a brand new finding that conveniently alters a critical segment of the timeline, introduced halfway through the trial.
Mr. Burgess.
Yes.
I'm going to show you what are 2 pages out of the report of Mr. Whiffen that you referenced, and we've been discussing about pocket state.
Sure.
And this one here, if you just read this line, because it's the heading.
Cannoni glances at her watch, clearly weighing whether it's close enough to the end of the day to call it, just as the cross-examination is about to strike a nerve.
And then the next page, "And tell me, sir, with reference to this entry right here, if that refreshes your recollection with regard to..."
She takes a deep sigh. Now, we will play through what she does next once, then break it down.
A deep sigh.
"With regard to the phone of Mr. and whether it refreshes your recollection on any comments Mr. Whiffen made about pocket state."
Objection. I'm going to see it side by for 2 minutes.
Okay.
Big smile. he's saying that's the signal.
with regard
She glances at Brennan to see if he's looking in her direction.
to the phone of Mr.
She does it again, now realizing he can see her. She abruptly raises her arm to her face in a sharp, unnatural motion, making one of the most unmistakable signals imaginable. Then she locks eyes on Robert Alessi, like a trained hound pointing to its target, all with a bizarre grin on her face that gives it all away.
and whether it refreshes your recollection on any comments Mr. Whiffen made about pocket state.
Objection.
Brennan finally picks up her signal and states his objection, and she couldn't be more pleased. It's one of the strangest moments we've seen from this judge, as if the gravity of a woman fighting for her life means nothing. She's just been caught sending covert signals to the very prosecutor whose conduct should be under scrutiny, not aided by the bench. Whatever her reasoning, this is unethical, inexcusable, and she should be removed for this infraction immediately.
I'm going to see you sidebar for 2 minutes on this.
Okay.
All right.
There we go. The dots.
Dropmicrodots.com, people. If you want to check out more of their work. All right. And if by chance we got lucky and the trial has already started, I love my bloop bloop time.
Your Honor. Mr. Burgess.
Wait.
I'm going to pick up, sir, where we left off. A text stream trigger event does not automatically mean there was a collision, correct?
Correct.
A text stream data event doesn't, without more, mean an airbag deployed, correct?
Correct.
A trigger data event doesn't mean, without more, that there was a vehicle impact, correct?
Correct.
A text stream data event merely refers to Lexus's practice of capturing real-time data from applications in databases, correct?
Sensors and other modules.
That's right. You had said that earlier, sir.
Sure.
Sensors and modules. You reviewed the raw text stream trigger events on Miss Reed's vehicle, correct?
No, I did not.
Oh, you did not?
No.
Do you understand whether...
Oh, you did not.
Do you have an understanding whether Mr. DeSogra reviewed those events in his March 5, 2025 report?
I do not.
So you did not review the raw data for text stream trigger events on Ms. Reed's vehicle, and you did not therefore perform any analysis of that data as you sit here today, correct?
Correct. Outside of what Dr. Welcher provided.
Are you aware that there were approximately 30 text stream trigger events in an 8-month period on Ms. Reed's vehicle?
No, I'm not.
Assume the data shows that in the mere 8-month period that Ms. Reed owned her vehicle, the Lexus in question, there were 30 text stream trigger events. Assume that. You would not conclude that there were 30 collisions in that 8-month period, would you?
No, I would not.
Would you agree, sir, that there were actually 2 triggers on January 29th?
Yes.
And the first trigger that you referred to of 1162.1, that was not a collision, was it, sir?
Without reviewing the data, I don't know.
Well, as you sit here today, you have no basis to state that the 1162-1 trigger was a collision, do you?
No, I do not.
And in fact, didn't you refer to that as a 3-point turn?
I did, yes.
And you didn't mention in your direct testimony when you talked about the 3-point turn anything about a collision, did you?
No, I did not.
And as you sit here today, there's no fact or data that you have to conclude that there was any supposed collision associated with that 1162-1 3-point turn trigger event, correct?
Correct.
A trigger event can occur on a Lexus vehicle by a whole host of possibilities, correct?
Correct.
You could maybe slam on the brakes and cause a trigger event.
That is one possibility.
You could have just unusual driving. You could be going at a speed or doing something else that has nothing at all to do with a collision, correct?
That is correct.
And in fact, there are almost countless events that can occur that can cause a trigger event in a Lexus vehicle.
So I don't know the exact count of what type of triggers there are, but yes, there are a
many.
number. Yes.
So back to the 1162-1 3-point turn trigger event. On your direct examination, you just referred to event surrounding that as a 3-point turn, correct?
Correct.
And yet that 3-point turn registered as a trigger event, right?
Correct.
Are Lexus SUVs trigger happy?
I do not know, sir.
As you sit here today, none of the information in that black box that you referred to on your direct testimony indicates that there was a collision on January 29th, does it?
Not by itself.
Not by itself.
Correct.
And it doesn't occur that none of the information in that black box indicates that there was a collision on any day without more, correct?
Correct.
I'd like to now turn to a different topic, sir. In your direct examination, you reference a Ms. Maggie Gaffney. Do you recall that?
Yes, I do.
And wasn't part of your reference
What the hell's going on?
that she did with respect to the Lexus SUV?
Yes, it was.
And for instance, you criticized her for failing to extract the micro SD card from the circuit board during the initial chip off, right?
So sure. So I did criticize for not identifying the micro SD card and subsequently not downloading it. Yes.
And on direct, you even tried to lay at her footsteps, if you will, your bits, bytes misinterpretation on her by claiming that you assumed, quote, a competent expert, close quote, would not have overlooked a relevant chip. So you became confused how there could be data missing. Is that a fair characterization?
No, it is not.
Did you at all try to use as a justification for your misunderstanding of bits and bytes that it was her work?
Her word? you
Her
say?
work.
Her work.
Yes, her work.
So it was the overlooking of the SD card. Yes.
Right. So you did try to lay at her footsteps, part of the reason why you misinterpreted the bits and bytes that we discussed yesterday. Is that correct?
No, that is not correct.
Okay. So you would agree then that the the bits and bytes misinterpretation that you and I discussed yesterday had nothing to do with the work of Miss Gaffney, correct?
So in part, but that was my mistake. Yes.
All right. I'm trying to understand which is it. Is it Miss Gaffney's work had some part in your misinterpretation of bits and bytes, or her work had no part in your misinterpretation of bits and bytes?
Some part.
So you do attempt to lay some blame on Miss Gaffney for your misinterpretation of bits and bytes, correct?
No, I'm not trying to blame anyone.
Okay. In your January 30, 2025 report, are you consistent with your criticism of Miss Gaffney?
As I recall, yeah, I believe so, yes.
In fact, you yourself provided the explanation for why the micro SD card was not extracted during the original chip-off, didn't you?
Yes, that it was overlooked.
Right.
Yes.
So if you could please turn to page 5 of your January 30, 2025 report.
Okay.
And sir, when you get there, if you could let me know, and I will then proceed with questions.
Okay.
It was at this moment he knew he fucked up.
So you do attribute to Ms. Gaffney in your report some responsibility for this micro SD card not being extracted during the original chip-off. Is that correct?
Yes.
So let's go to page 5 of your report, sir. And bear with me, I want to get you the exact location. I don't have it exactly, but I want to quote it. Your Honor, may I have a moment to get the exact quote?
Sure.
Thank you.
Oh, is Thursday a half day? Master Woke there, pointing things out. Eliza's pouring through the documents.
Thank you for that, Your Honor. I now have it. Mr. Burgess, if you could turn to page 5, as I was referencing, and go to the third full paragraph. If you could look about 2/3 of the way down the far right, you see the word where it starts with at. It's the paragraph beginning when examining vehicle
Yes,
systems.
I did. Yes, I see it.
And do you see the at that is at the very far right of that paragraph?
Yes.
So it says, at the time of the incident, Burla, and Burla is what? Can you read?
Burla is a company that offers and develops forensic hardware and software for vehicle modules.
Right. So at the time of the incident, Burla did not offer support for the infotainment and telematics modules removed from the Lexus, but have since released updated software indicating similar modules are supported supported via in-vehicle acquisition. According to Burla, currently, there are 2 known and documented modules within the vehicle that have the capability to store data. The infotainment module removed from Ms. Reed's Lexus is consistent with the MMU documented by Burla and has been identified as containing an internal micro SD card not acquired during the initial chip-off acquisition by Ms. Gaffney. Did I read that correctly?
Yes, you did.
So as you stated, Burla is the organization that you described, which for the purpose you did, I'm not going to repeat it on direct examination. If I could sort of put in layman's terms and see, you tell me if this is correct.
It's not me. It's not me.
Where to make it easier for non-technical people, as you put it, to extract data from a vehicle, correct?
Correct.
You describe in your January 30, 2025 report that at the time of the initial chip-off, Burla did not provide support for the information contained on the micro SD card, correct?
No. So I think you're misreading that last sentence, and I can clarify.
Can you read the last sentence, sir?
I can. So the infotainment module removed from Ms. Reed's Lexus is consistent with the MMU documented by Burla and has been identified as containing an internal micro SD card not acquired during the initial chip-off acquisition by Ms. Gaffney.
So my question is, did or did not Burla, at the time of the initial chip-off by Ms. Gaffney, provide the technical support to address the information contained on the micro SD card?
No, Burla did not and does not.
Good. That I wanted to.
That was my identifier of the micro SD card. Correct.
So it was not until after the initial chip-off that Ms. Gaffney participated in that Burla updated their software to be able to identify the types of data, for Burla software to be able to identify the types of data contained within the micro SD card on the Lexus circuit board. Is that correct?
No, that's incorrect.
So
Are you sure?
Burla didn't do anything new after the initial chip off with its software?
Sure. So Burla released new software after the initial chip off that addresses being able to download software via the infotainment module while it's in the vehicle. So that involves plugging a USB in to the vehicle and downloading data. That does not address the micro SD card on the circuit board itself.
And Ms. Gaffney did not have, at the time of the initial chip off, that updated Burla software, correct?
Correct.
Okay, thank you, sir. Appreciate your questioning. Thank you for answering my questions. That's all I have at this time, Your Honor, but I have a bit to pack up, so Mr. Brennan can have a clear podium.
Go right ahead.
Thank you.
Well, I suppose. I'm finished with this guy.
There we go. There we go. Can't wait to watch this. Can't wait to watch this.
Pretty good. It's pretty good.
Pretty good. Yep, it's pretty good. Pretty. There's Hank. I need to look through papers. Oh, here's that one paper I need. Here's that one paper where I can explain how this guy lied about his education. There's that paper. Been looking for it.
Thank you for that opportunity, Your Honor.
You bet, Bob. You bet.
Look at this distinguished gentleman. Look at the way he is sitting. Yes, very distinguished. I see.
Good afternoon.
Good one, man.
Good afternoon.
Do you know what a sequestration order is?
Yes, I do.
And what is it?
So it would be an order to not view any testimony of a trial, is my general understanding.
Does that mean that you can't watch any of it on television?
Correct.
Do you understand whether or not you can speak to attorneys about testimony? Is that precluded as well?
I'm not aware either way.
Has anybody ever spoken to you about any testimony about that occurred in this trial before you testified?
No, they have not.
Have I ever discussed, intimated, or suggested any information whatsoever to you about arguments, testimony, or anything about this case as it's ongoing?
No, you have not.
Do you follow the rules, sir?
Yes, I do.
Have you followed them in this case?
Yes, I have.
When you gave your opinions and you've testified, do you have any information or knowledge about this trial as it actually occurred until the point when you testified?
No, I do not.
You were asked some questions about your CV. A CV is a resume?
Yes, it is.
Okay. And you were asked about a LinkedIn account.
Yes, I was.
Is your LinkedIn account different than your CV?
Yes, it is.
And in this case, when did you learn that your LinkedIn account was wrong or had not been updated? When was the first time you learned that?
That was yesterday.
When you started your LinkedIn account, do you remember when it was you set it up?
I do not. It would have been maybe 10 years ago or more.
Do you routinely update your LinkedIn account?
No, I do not.
When you set up your LinkedIn account, the section where it asks for education, whether graduated or ongoing, do you remember filling out that section?
I don't particularly remember filling it out, but obviously I did at some point.
When you were asked about Aperture's website, how many experts are associated with Aperture?
I could give you a rough number between 80 and 100.
How many offices?
15 or so.
Are you involved in the website design or content?
No, I'm not.
Do you know if Aperture gets the information from their website directly from LinkedIn?
I don't know where they get all of their information from.
Did you ever weigh in or develop your information that was on Aperture's website?
No, not on the website.
You do provide CVs before you come to court, don't you?
Yes, I do.
And in this case, you were asked by the defense, when you provide your CV, do you understand that it's going to be reviewed by whoever requests it, the Commonwealth or the defense?
Yes, I do.
And that it will be shared with both sides in the court?
Yes.
In fact, the first time you provided a CV in this case, was it October 11, 2014?
Objection, Your Honor. So the leading nature sustained.
Do you remember the first time you provided a CV in this case?
It would have been around October.
What year?
2024, sorry.
And when you provided that, was it as an exhibit to something?
Yes, if I recall, it was as an exhibit to the initial protocol that I sent out.
And when you submitted that CV, did you appreciate whether or not it would be part of a court filing in public?
Yes, I did.
If I could have exhibit 183, please.
That was my hair.
183. You could enlarge the top section. Right there is good. And sir, when you provided this CV to be filed with the court and made public, did you indicate that you had obtained a bachelor degree?
No, I did not.
Why did you put currently pursuing?
Because I am currently pursuing a bachelor's degree.
And did you understand your CV was received by the defense and they knew this?
Yes, I do understand that.
Subsequently, you were asked to provide an updated CV in April 2025?
Yes, I was.
Did you do that?
I did.
And can we have exhibit 184? Did you further appreciate this would be provided to both the court and the defense?
Yes, I did.
Did you represent to the defense that your education included earning a bachelor degree?
No, I did not.
You've testified in, you can take that down, please. You've testified in many other cases
I have, yes.
in courts around the country.
Yes, I have.
And when you've testified in other courts around the country, do you know whether there are transcripts of your actual testimony?
Yes, I believe there are.
Have you ever represented in any court that you achieved your bachelor's degree?
No, I have not.
Have you ever inflated your qualifications in a court?
No, I have not.
When I asked you about some of your background, you told us that you had certificates in Celebrite and Axiom. I didn't go through all of the qualifications and all of the accomplishments you had, did I?
No, you did not.
Do you have professional certifications, GIAC, Advanced Smartphone Forensic Analysis?
Yes, I do.
Do you have professional certification from CCME, Celebrite Certified Mobile Examiner?
Objection, Your Honor. Sustained.
Do you have professional certifications as a Magnet Certified Forensic Examiner?
Objection, Your Honor. Sustained for the same reason.
Leading.
Sorry?
You're
Sustained for
leading,
the same reason.
jackass.
Do you have a number of certificates that I did not ask you about?
Yes, you did. I
Can you
did,
share
yes.
some of those with us?
Sure. So one of those is going to be GIAC, Advanced Smartphone Forensics. So that's going to be Global Information Assurance certification. And that is basically a 40-hour class or 48-hour class with a test at the end to get that certification. There's also a Celebrite Certified Mobile Examiner certification. That is specifically to, kind of demonstrate your knowledge of the Celebrite software, as well as Magnet Forensics certifications, again, for their software specifically.
Any certifications regarding computer hacking?
What was that last part? Sorry.
Any certifications regarding computer hacking?
No, not currently.
Did you also take any classes regarding crash data or BOSH?
Yes, I have.
What do you have for certificates in that arena?
So those certifications would be Crash Data Retrieval Technician and Crash Data Retrieval Analyst. So those courses would be around acquiring and analyzing crash data from airbag control modules.
You mentioned that you had over 700 hours
Yes, I do.
of classes and certification.
Yes, that's of classes and classes and seminars or conferences, specifically in digital forensics or vehicle forensics.
Do you need a bachelor's degree to be competent and achieve in this area?
No, I do not.
Is a bachelor's degree a prerequisite of success in a particular field?
No, it is not.
You ever hear of Bill Gates,
Yes.
Stephen Jobs,
Yes.
Oprah Winfrey?
Sustained.
You had become engaged in this case in October 2024?
Correct.
And when you first became engaged, you had a chance to look at photographs and some data?
Yes, I did.
At that point, you hadn't had a chance. Did you have had you had a chance to actually inspect any of the physical property?
No, I had not.
Did you have an understanding that somebody else did?
Yes, I did.
Who?
Miss Gaffney and a number of other people with the MSP.
Attended some type of procedure?
Correct.
And do you know who led the actual procedure?
As far as I'm aware, it would have been Miss Gaffney.
The defense expert?
Correct.
You filed a protocol. What was the purpose in October when you first got involved with filing a protocol?
Sure. So the first purpose of the protocol was just to address the fact that we were missing data that we expected, and address a potential solution to gather more data.
Without having looked at the physical property, the actual boards, how did you conclude simply on data and photographs that there was missing data?
Sure. So that would be reviewing the initial data that was provided, and not seeing user data like I would expect. And that's because there's a number of different chips that are on a circuit board for an infotainment or a telematics or any other module. And there's a number of different data bearing chips. The purpose of those chips will vary. Some chips' main purpose is to store user data. Some chips' main purpose is to store software or firmware. So if you're gathering, acquiring data from chips that only have software and firmware, then you would not expect or you would not see user data within those chips.
When you made that analysis and concluded that there was missing data, had there been any report provided by Ms. Gaffney suggesting there was missing data?
No, there was not.
Had there been any analysis or opinion alerting that there was missing data?
No, there was not.
Was there anything to indicate that the person who did this test missed data at that point?
No, not at that point.
When you decided to write a protocol so you could actually look at the boards and do an analysis, did you put that protocol in writing?
Yes, I did.
And do you remember if that was around October 10th, 2024?
That sounds familiar. Yes.
Now, when you were cross-examined, the attorney asked you if you knew what the word mendacity meant. Do you remember that?
Yes, I do.
And you didn't know. Do you now know that means to lie or be untruthful?
Your Honor. Sustained.
He didn't ask you a question. He just asked you if you knew what the word was. Do you remember that?
Yes, I do.
Okay. Do you remember he also, on cross-examination, suggested that when you had your mistake about megabytes, megabits, it was the defense expert that alerted you to that mistake? Do you remember that suggestion by the defense?
Yes, I do.
Did they ever show you the documents so you could see the chronology?
No, they did not.
Okay. You wrote a report on October 10th, 2024. Did you then write another report, a supplemental protocol?
Yes. So I did write that initial protocol and then a supplemental protocol.
Was that on October 17th, 2024?
That sounds about right.
When you wrote that a week later, at that point, had you realized your mistake?
Objection, Your Honor. Sustained.
Why did you?
Can we approach, please?
Okay.
Ooh, Hank's in trouble. I don't know about y'all, but this whole redirect sounds exactly like this. That's it. I mean, that's it. Oh, God. He's so hard to listen to. All the guy does is lead. All he does is lead. He's just such a leading son of a bitch. It's insane. It's insane. So calming. The calming sound. So, only to be, it's like we got that thing, and then as soon as Hank comes back, it's, the record scratch thing. Oh, no, they're going to the fan. What's that mean? What does that mean? Oh, God. Yeah. I mean, so do you guys feel like the Tuft was rehabilitated? I don't.
When you realized your error, what did you do?
So I intended to correct it with a supplemental protocol.
When you corrected it with the supplemental protocol, do you remember what date that was?
Not specifically, I do not.
Okay. If I showed you your report, would that help your memory?
Yes, it would.
May I approach?
Yes.
Please don't read this, just look at it. And if it refreshes your memory, let me know, and then I'll ask you a question.
Yes, it does.
When did you correct your error with the supplemental protocol?
That was on October 17th, 2024.
Boring.
And do you remember the date that you first received any information from Mr. DeSorga?
No, I do not
Do you
specifically.
remember the date when Mr. DeSorga's information was first filed?
No, I do not.
And do you know if it was, whether it was after your October 17th supplementary report?
Not specifically, but I believe it was after.
And so when it was suggested that you had to be schooled or advised by Mr. DeSorga, was that accurate?
Objection, Your Honor.
Word it differently. Word it differently.
The claim that was made that you weren't aware until someone advised you of your error, was that true?
No, that was untrue.
When you realized there was an error and you put it in a report, were you ever dissuaded from publicly alerting all the parties of your mistake?
No.
Do you leave stuff in or out of a report if you find it helpful or hurtful to one side?
No, I do not.
Have you, in this effort that you've made in this case, have you always been encouraged to provide all information regardless of what it is?
Objection, Your Honor.
I'm going to allow that.
Yes, I have.
And who's encouraged you to always provide all information regardless of what it says?
No one. So my job is to assist the jury. So the jury, assisting the jury means presenting all the information.
Have you ever been discouraged by me?
No, I have not.
When you looked at the photographs and you looked at the boards without actually touching them, how long did it take you to figure out that there was some other vehicle for data?
Sure. So it took a few times to look at the photographs before I identified the micro SD card slot.
You were asked whether it's important to be accurate and reliable. Is it in this field?
Yes, it is.
And if data is not found on the chips, is it a standard practice to look elsewhere?
Yes, that would be a standard practice.
Was that done in this case before you became involved?
No, it was not.
Who was the first person to identify where the missing information was?
Myself.
What happens if you miss information because you don't see it?
So if you miss information, that's information that won't help in the analysis.
In this case, the information on the SD card that you found, how important was that to this entire analysis?
It was important to timestamp certain events.
Without that information in the SD card, would you have been able to so accurately timestamp certain events?
No, not so accurately.
Before you were involved, was that information, that very important information for timestamps, was that available for either side?
No, it was not.
Is it now?
It is.
You were asked about Burla. When Burla did not have updated software to simply plug into a car and download the information, what process would have to be used?
Sure. So best practice for vehicle forensics is if the module or a vehicle is not supported by a forensic tool, would be to remove that module, or let me start over, manually document the screens on that infotainment module if it's available and it can be powered up. But then also going through disassembling the module, identifying any type of chips or SD cards that may hold data, and acquiring that data.
Is that called a chip-off process?
It is called a chip-off process.
Does it describe the process well, chip-off?
Yes, it does.
Since Ms. Gaffney did the original analysis and did that chip-off, has the software updated?
Yes.
Is that the Burla software?
No, I'm sorry. So she has not done a updated analysis with the Burla software.
But has the Burla software itself updated?
So the Burla software itself has updated, but it is limited to, again, plugging in a USB into the infotainment module while it's in the car running.
Does the updates in Burla software have anything to do with the SD card?
No, it does not.
Why not?
Because, again, they're going a different route to acquire data. And they are acquiring a limited amount of data through what's called diagnostic logs. So if you think of diagnostic logs, your radio unit is keeping logs of any time things happen on the radio for manufacturer purposes. So Burla is taking those logs and they can interpret some of those logs. They are not, acquiring all the data that is on the SD card itself.
You have drafted a number of reports in this case.
I have, yes.
Regarding the chip-off process, did Ms. Gaffney ever write a report?
No, not that I'm aware of.
When you wrote reports in this case, do you expect for them to be shared?
Yes, I do.
When other experts, like, for example, Mr. DeSorga writes a report, do you expect to have a copy and review it?
Yes.
Sustained.
What is the standard practice when there are reports from different experts regarding the same subject matter?
Objection, Your Honor. Sustained.
Is there a standard practice
Sure.
regarding reviewing reports from similar experts in similar subject matter?
Sure. So anytime a report is written by an expert, that report would be provided and shared with opposing experts.
Reports, do they always come at the same time in a case?
No, they do not.
When you wrote your reports, how would you provide them so they could be disseminated?
Sure. So that I would typically provide them to the client or the attorney that hired me, and then that would be disseminated from there.
Did you have an opportunity to receive Mr. DeSorga's March 5th, 2025 PowerPoint?
Yes, I did.
Were you provided that by me, the Commonwealth?
Yes, I was.
And were you asked or given any direction on what you could or should do?
No, I was not.
Were you ever asked to reach any particular result?
No, I was not.
Were you ever asked to avoid anything?
No, I was not.
What did you see your role as when you receive a report from another expert like Mr. DeSorga?
Sure. So when I receive a report, I would typically review it and then make a decision if it's better to address any issues in that report through testimony or address those with a supplemental report.
Boring. And in that analysis, do you follow your own discretion or do you follow directions of the client?
No, I would follow my own discretion.
Did you ever receive any direction on what you should and shouldn't do regarding considering Mr. DeSorga's report?
No, I did not.
When you looked at Mr. DeSorga's report, did you have concerns about his report?
I did, yes.
I want to talk about his report in detail. Before we get there, share with us what your general concerns were about Mr. DeSorga's report when you reviewed the whole report.
Sure. So what Mr. DeSorga does is take a couple different adjustment methods to attempt to adjust the clock from the Lexus with the iPhone. But what he does is takes a lot of methods or data points that are not applicable to the time that we're interested in.
What do you mean? Can you explain with a little more specificity what he does?
Sure. So if you think about it, your clock is constantly, changing as far as it syncs up with other GPS satellites or network time servers, and it's updating constantly. So a clock variance between two devices may be different at, say, 12 o'clock in the day versus 1 o'clock in the day. So best practice is to choose an event that is nearest to your time in question, so you have the most appropriate adjustment for that clock variance.
Mr. DeSorga's analysis, did he choose the event most closely tied to the backing up event?
Objection, Your Honor. Sustained.
The backing up event, are you familiar with that time frame?
Yes, I am.
Okay. Was Mr. DeSorga's analysis based on information most closely related to that event?
Objection, Your Honor. Sustained.
What information did Mr. DeSorga choose to use for that analysis relative to the backing up event?
Sure. So he chose a couple things. That's going to be call logs that happened on both devices or that was recorded on both devices, as well as a GPS data point, which was incorrectly identified as being near that or encompassing that 3-point turn. So what we did is did a more thorough analysis of that 3-point turn event when it occurred within the iPhone data, and then compared that and adjusted with the Lexis.
Explain to us your concern about using call logs.
Sure. So there's a number of call logs that you saw earlier that were recorded by the phone and the Lexis. The one thing you'll notice, and it's hard to kind of go back to it without the graph, but the calls that happened between 1 and 5 o'clock that morning actually happened when the car was powered off. We know that based on the power on and power off events. So those timestamps that are recorded with that 2 second and 1 second offset is actually from Mrs. Reed's iPhone as she gets back in the vehicle and her phone connects up and syncs back up. So the 8 second and the 16 or 21 second offset are the only offsets that we have to compare to calls.
Was that a concern?
It was a concern.
Why?
Because if you're using the 1 and 2 second offsets, that could be misleading because it's not actually comparing the Lexus clock with the iPhone clock from Mr. O'Keefe.
What's it doing?
It's comparing the Mr. O'Keefe's iPhone clock with Mrs. Reed's iPhone clock.
What other concerns?
Sure. So the other concern was a GPS point known as GPS 154, which if you remember yesterday, we talked about it a little bit. So that was misidentified as being the end or towards the end of that 3-point turn. But when we look closer at all the location data, we can see that that actually occurs between 12:23:59 and I believe it was 12:24:07.
Let me ask you some questions about what compelled you to look at the 3-point turn and synchronize the clocks. Were you aware of Mr. Whiffin's report where he offered that the last user interaction on Mr. Whiffin's phone was 12:32:09?
Objection, Your Honor.
You were asked, did you consider Mr. Whiffin's report where there was a last user interaction of 12:32:09 by the user?
Objection, Your Honor.
I'm going to allow that.
You were asked if you considered that. Did you know that information?
I did know that information was available and existed, but I did not use that in my analysis for the clock synchronization.
Did that have any part of your motivation to do the clock synchronization?
No, it did not.
Were you attempting to match the synchronization with any of this other information that exists in data?
No, I was not.
You were also asked if you were aware of Mr. O'Keefe's phone that at 12:32:16, it ended its movement.
Yes, I was aware of that, yes.
Did that in any way affect your interest or your decision to synchronize the clocks?
No, it did not. So my primary focus and to adjust the clocks was because I thought the PowerPoint slides by Mr. DeSogra were misleading.
When you were shown Exhibit 190, can we have 190, please? You were shown this chart. Was this the entirety of Mr. DeSorga's report?
No, it was not.
Was there text information offered by Mr. DeSorga to give his position or explanation of this?
Yes, there was.
Is that included in this exhibit?
No, it's not.
Did you get a chance to read Mr. DeSorga's report, including the actual text explaining his analysis and process leading to this chart?
Yes, I was.
Did you look at Mr. DeSorga's entire report?
Yes, I did.
I move to introduce Mr. DeSorga's report.
No objection, Your Honor.
Okay, no tips. So this was triple D for identification. Agreement, that would be the next exhibit.
Exhibit 191.
You said as a result of Mr. DeSorga's report, you were concerned, so that compelled you to do your analysis that resulted in your May 8th report?
Correct.
I want you to take us through Mr. DeSorga's report and explain to the jury what concerned you about his analysis.
Sure.
With the court's permission, I'd like to put this page 1 of this report.
Boring.
Is this the front cover of Mr. DeSorga's March 5th, 2025 report?
Yes, it is.
Turn to page 2, please. What do you recognize this slide or photograph coming from?
Sure. So this slide is coming from Dr. Welcher's overall PowerPoint slides.
When you first saw this slide, where did you first see, what source did you first see this through?
Through Mr. DeSorga's PowerPoint.
Well, Dr. Welcher works at Aperture, doesn't he?
He does, yes.
Did you know he was working on this case?
Yes, I did.
Was he providing you his PowerPoint or slides before this point?
No, he was not.
When you first saw this slide, did you see information about the timing of the text stream event, which was the backing maneuver?
Yes, I did.
And what time did that show?
Can we blow it up just so I don't get the time
Please.
wrong?
Up, please. I'm sorry. Up. There we go. Thank you, Ms. Gilman.
Sure. So that's got the text stream event ending at 12:31:43.
These text stream events that are captured, do you know how long of the event is captured? How many seconds?
Yes. So approximately 5 seconds before the trigger threshold is met and 5 seconds after.
When this information that you reviewed in Mr. DeSorga's report, do you know what clock is used to identify the 12:31:38 to 12:31:43?
Yes, I do.
And what clock is that?
So that's a combination of the Lexus clock that's coming from the infotainment center, as well as the running timer that we discussed yesterday that's coming from the airbag module itself.
Is the source of that time important?
Yes, it is.
If you compare time from a different clock with time from a different clock and don't synchronize the two, does that lead you to an accurate result?
No, it does not.
When you were answering questions, you repeatedly were saying, according to the Lexus clock. Why were you offering that qualification repeatedly? One moment, please.
Sure.
Why were you offering that qualification repeatedly?
Sure. So to make sure that the jury understood that that timestamp was coming from the Lexus itself and was not an adjusted timestamp to Mr. O'Keefe's iPhone.
Could you scroll down, please, Ms. Gilman? Up a little bit, please. Thank you. The 3209, what did you understand that information to be?
Sure. So that is information I understood to be the last device lock recorded on Mr. O'Keefe's iPhone.
And what clock did you understand that time came from?
That would come from Mr. O'Keefe's iPhone clock.
If you reconciled his iPhone clock information, or if you compared it without reconciling to the Lexus information, what's the danger in doing that?
Objection, Your Honor.
Sustained.
Is there any danger in doing that?
Objection, Your Honor.
I'm going to allow that.
Is there any danger in comparing two times if you don't consider the clocks that they came from?
Yes, there is. So you could essentially be, in inaccurate time for when that event actually occurred.
If you could just scroll down to the bottom so we could see the rest of that. You mentioned the word variance yesterday during your direct examination. I'm going to ask you to look at that box that has the green around it. Is that an example of variance?
Yes, that is an example of variance between, no. So I take that back. That is not an example of variance itself. That is an example of comparing the end of the tech stream event to the device lock event.
Is that attempting to compare two different devices?
So that's attempting to, that's not attempting to compare anything. It's just stating that the time between the device event lock and the end of the tech stream event, unadjusted, is approximately 26 seconds.
Is that accounting for synchronization or not accounting for synchronization?
That is not accounting. That is not with synchronization.
Can we turn to the next page, please? Did you review the next page of Mr. DeSorga's report?
Yes, I did.
And did it lead you to any concerns?
This page specifically, yes and no. So this page again is just showing the time difference between the end of the tech stream event and Mr. O'Keefe's last device lock event.
Is this another way of showing the information that was in that green box?
It is. It's another way of showing the information in that green box, but it is not a clock variance or an adjustment.
That's
Could you turn the page, please? When you read this page, is this a opinion or conclusion?
No, it does not.
What is it?
So this is just pointing out that when the 26-second window, which they'll refer as John's interaction window, when that number is positive, then the phone interaction occurs after the end of the tech stream event. When that number is negative, the phone interaction occurs before the end of the tech stream event ends.
Did you have any issue with that slide?
No, not that slide in particular.
Okay, if we turn the next page.
Come on now, dog. Come on, man.
Did you have an opportunity to review the next page?
Yes, I did.
And were you in agreement with this page?
I was in agreement with this page, yes.
And what does this tell us?
So this page points out that two clocks are not always in sync. So again, to synchronize those clocks, you would have to have a shared event that occurred on both devices.
If we could have the next page, please. Any chance to make that a tiny bit bigger, Ms. Gilman? Were you in agreement with this page?
No, I was not.
Tell us what concerned you about this page.
Sure. So this page is potentially misleading to the jury again by using,
Your Honor, move to strike.
I'll strike that.
Just tell me what your concerns were.
Sure. So my concerns with this, that it was potentially misleading to the jury.
Objection, Your Honor, move to strike.
No, I'm going to allow that. That's his concerns.
Sure. So that this slide was potentially misleading to the jury because it uses incorrect adjustments to try and adjust the times.
How does it use incorrect adjustments? Explain that to us so it's very basic, please.
Sure. So as we kind of go through the next few slides, you'll see. But essentially what they're doing is, or what is being done, is they're comparing call logs, timestamps from call logs from when the phone was off, suggesting that, again, that the lock event occurs after the end of the tech stream event, as well as incorrectly identifying the GPS point when the 3-point turn ends.
Will you better be able to explain that to us with the further slides that come next?
Yes, I believe so.
If we could turn to the next page, please. Okay. Is this just a label of what's to come?
It is.
And could we turn to the next page, please? If we could start, Ms. Gilman, with the top left-hand box, if you could enlarge that for us. Did you review this information in this box?
Yes, I did.
Okay. And before we get to your opinions, what does this information tell you?
Sure. So this is a snapshot from my initial report where I point out that the ignition on happens approximately 3 seconds before the infotainment power on event. So you can see that. I think we're up a little too high on the page. Yeah. So highlighted in the red. That's based on our testing where we identified that the ignition on, or your finger on the ignition pressing it, and the engine coming on and the vehicle coming on happens 3 seconds before the infotainment system powers on.
You were asked on cross-examination about that 3 seconds between the pressing the button and the infotainment system going on, but you weren't allowed to answer the question whether you considered it or why that was important. So I'm going to give you that opportunity now.
Objection, Your Honor.
Sustained. Ask the question.
Okay. Is there significance to that 3 seconds, and did you consider it in your report, in your findings?
Yes, I did.
Share with us.
Sure. So when we make our adjustments based on the event, so in this case, the 3-point turn, what we're looking at is the approximate time frame when that 3-point turn occurred via Mr. O'Keefe's iPhone. And then we're adjusting that for the approximate time that the text stream event and that 3-point turn ends. So as we sync those clocks, we're adjusting not only for the difference in the clocks, but we're also adjusting for this 3-second delay.
Did you accommodate that 3-second delay in your analysis and your conclusions?
Yes, that was included in my analysis.
Now back to the screen. The information there, is that text taken from your actual report?
Yes, it is.
Could we shrink the screen, please? And then the photograph in the bottom left, if we could enlarge that, is that as well from your report?
Yes, that is also from my report.
Did we look at that yesterday on your direct examination?
Yes, I believe so.
And briefly tell us what that depicts?
Sure. So that's during our exemplar testing, where again we've got it rigged with cameras that are recording video and timestamps of interactions we're having with the vehicle, which include powering it on and powering it off.
If you could shrink the screen, and we'll go to the right, Ms. Gilman. What was the import of this screen to you in its entirety?
Sure. So this is not actually a valid.
This whole line of testimony is exactly what it's like to listen to the Peanuts parents or adults. It's exactly what it is. I am having the hardest time staying awake because this is the most boring shit I've ever heard. Do you think that the jury for 1 second is engaged in this bullshit right now? Do you think that they're sitting taking diligent notes, every word that's coming out of this guy's mouth? Get the fuck out of here. Be done with this. No one needs to hear this shit. We're over it. We don't need your direct of your redirect.
Valid way to adjust or synchronize clocks, because again, we're not adjusting based on a shared event. So the ignition on event occurs, it is not recorded by Mr. O'Keefe's iPhone. But again, we are adjusting and including this in our timestamp adjustment.
If we turn to the next page, please. You were asked about the process of synchronization through phone calls or through the 3-point turn data.
Yes, that's correct.
Why did you choose to use the 3-point turn data instead of phone calls?
Objection.
Sure. So I chose to use the 3-point turn data because it was closer in time to the event that was of interest, as well as it was based not only on the infotainment clock, but it was also based on that running timer. So once we adjust that first event to Mr. O'Keefe's phone, the second event is also based on that running timer, so it would also be adjusted.
Did you have any concerns about using phone calls specifically?
Yes, I did.
And what were they and why?
Sure. So those concerns were related to the phone calls that we could actually compare, and again, some of the phone calls that happened earlier or closer to the event of interest were not actually recorded by the infotainment system itself.
Why is it important to take an event closest to the time of the event you're studying?
Sure. So like I kind of said before, clock variance will change between devices as they are constantly syncing back up with reference systems. So a clock difference that you see at 1 o'clock in the day is not going to be the same as you would see at 2 o'clock in the day.
When you chose the 3-point turn, how close to the backing up event was that in time?
I believe it was within 10 minutes or so.
Was that closer in time or further away in time than the phone calls as a method?
That was closer in time than the phone calls. If you think back to the phone calls that we could have compared, those occurred at 5 o'clock in the morning.
We turn to the next page, please. Did you have a chance to review this slide of the PowerPoint?
Yes, I did.
Okay. Now you see on the left is a box. Where's that box taken from?
Sure. So that box on the left is taken from my report. That's going to be my initial report.
January 30th, 2025?
That's correct.
Okay. And share with us what you were trying to express in this box.
Sure. So again, this box is a
I'm sorry to interrupt you. I
Sure.
apologize. Ms. Gilman, is there any chance we could enlarge the box on the left? My apologies. Okay, please proceed.
Sure. So this is a comparison of the calls. So the infotainment call timestamps are on the furthest left column. So again, your infotainment system, when you plug your phone in, is recording and synchronizing your calls. It's not great about recording and synchronizing every call. So there's a lot of calls here that we don't have that we know exist based on Mr. O'Keefe's iPhone. So the calls that we do have that were recorded in the infotainment system, we can compare to the timestamps that those are recorded on Mr. O'Keefe's iPhone. So when we do that, there's a couple things we notice is during that 1 o'clock and 4 o'clock and 4:45 time frame, when we look back at the power on and off events, we know the vehicle was not powered on at that time. So the vehicle's off. So those timestamps are not coming from the vehicle. They're coming from Mrs. Reed's iPhone or the defendant's iPhone. And then the times after 5:21, we know the vehicle has been powered up at that point. So those timestamps are coming from the infotainment system itself. So that's why we can actually do a comparison of those timestamps and determine the exact or the approximate clock variance.
When you look at the call timestamps of 1:14:13, 4:38:16, at 4:42:06 and 4:45:12, was the power on or off with the car during those four first calls?
Yeah, so with those first 5 calls, the car was powered off. And again, we know that based on the power on and off event. We also know that just by looking at the offset, it's a consistent 1 or 2 seconds. And that's what we typically expect and see between two iPhones. That's because iPhones are generally pinging back to Apple servers or GPS towers that are the same. So those times are pretty consistent and pretty accurate.
Was the power on by 5:04:28?
No, not at 5:04:28. It was still powered off.
So those first five events, were they reliable for you to use in synchronization?
No, they were not.
You gave us a number of reasons. One, the time distance between the event and because they were phone to phone. Any other reasons why they weren't?
I'll strike the first part, ask the questions.
Besides the reasons you already gave us, are there any other reasons why this would not be a reliable way to synchronize two separate devices?
Not besides the points I've made already.
Okay. And if we could zoom back on this. The box on the right, is that from your report? Is that Mr. DeSorga?
That's Mr. DeSogra.
Was there anything about that analysis that concerned you?
Sure. So that analysis is misleading because, again, it's not comparing Mr. O'Keefe's iPhone to the infotainment system. It's actually comparing the defendant's iPhone to Mr. O'Keefe's iPhone.
Is there any acknowledgement anywhere in Mr. DeSorga's report that he appreciated that this was iPhone to iPhone rather than iPhone to infotainment?
No, there's not.
Did you ever receive any report from Mr. DeSorga that would alert that he appreciated that this was iPhone to iPhone and not iPhone to infotainment?
Objection, Your Honor.
If we could go to the next slide, please. Is this a similar or different slide?
Sure. So this is a different slide.
Okay, if we can zoom in on the left box, please. Where does that box come from?
Sure. So again, that's coming from the same page of my report, just highlighting the 5:30 phone call. And this is comparing the iPhone from Mr. O'Keefe with the infotainment clock.
At that point, is the power on of the Lexus?
Yes. So at this point, the power is on. So this is a comparison of the infotainment clock with the iPhone clock at that time.
Could you zoom out? That final box that shows the comparison between the defendant's Lexus and Mr. O'Keefe's iPhone, do you have any concerns about the accuracy of that information for that time?
No. So I think those times are accurate. But again, that's at 5 o'clock in the morning when we're trying to adjust the clock variance. And it's too far away from the time in question. So if we zoom back in to the box, we can actually see in the data what I'm talking about as far as clock variance will change, with time. So the phone call at 5:21, we see an offset of around 8 seconds between the two devices, between the infotainment system and the iPhone. And then at 5:30, which is only 9 minutes later, we can see that offset has actually increased between 16 and 21.
I just hate him. Capturing this data, were there phone calls between the infotainment system and Mr. O'Keefe's phone?
Yes, those last two phone calls were between the infotainment system, or were recorded by the infotainment system with Mr. O'Keefe's iPhone.
How does that happen?
Sure. Dog. So that's when the device is connected up to the vehicle and you make a phone call. The call is recorded within the infotainment system, and it's recorded with the infotainment system's timestamp.
Could you focus on the right-hand box, please? Did you review the right-hand box?
Yes, I did.
Was that from your report, or is that Mr. DeSorga's opinion?
That's Mr. DeSorga's.
Did you have any agreement with that?
Yes, so I do agree with that calculation, but again, that's 5 o'clock in the morning versus when we're really interested in around 12:30.
Can we have the next slide, please?
Oh my God. Oh my God. See, here's the problem with this guy. Not only is it boring, but it's so fucking boring because we just don't believe a word that he's saying. It's like we're being forced to listen to this guy's bullshit a second time, knowing it's bullshit. Like, what is more boring than listening to something that is utter bullshit? I don't care what this guy's saying at all. Like, I am actively trying to listen so I could give some thoughts. It's so fucking brutal. I just can't do it. I can't do it. But I have a special treat for all the ladies in the audience for our lunch break. I'm gonna leave it to you guys to just let your minds wander, and I'm gonna have you watch over the lunch break.
Could we enlarge this? Do you know where this photograph came from?
Yes. So this screenshot came from Dr. Welcher's presentation.
When's the first time you saw this screen?
When I saw this presentation.
In Mr. DeSorga's report?
Correct. Yes.
Had you seen this before that?
I had not seen this before that.
If we could focus in a little more, especially the bottom left hand. When you reviewed this, did you feel any need to do further testing?
Yes, I did.
Why?
So what we're looking at, if we zoom back out, so what that is the 12/23/38 is the approximate time that the text stream event occurred. Now, what we want to do is we want to be able to compare that to the 3-point turn from Mr. O'Keefe's iPhone. What you'll notice, though, is right here, we've got a circled GPS point. So if we can zoom in there. So this circle here is actually circled GPS point 155, which is after this point but we'll kind of ignore that. But GPS 154, and it's hard to see, the time is 12:23:58. When we look at that, what we see is that actually that GPS position is recorded before the 3-point turn even starts.
You mentioned 154 begins recording before the 3-point turn starts.
Correct.
Is the end time of the 3-point turn a time before or after that 12:23:58?
Sure. So the end of the 3-point turn logically would be after this point.
At the time you saw the slide, had you broken down point 154?
No, not at the time that I saw this slide.
Could you zoom back out a little bit, please? The information in the right box, is that from you or from Mr. Disorga?
That is not from me.
And when you read that, did that compel you to want to do anything?
Yes, it did. So again, my initial thought was to address this during testimony. With further review and further thought, I decided it was best to offer a supplemental report. What this is, basically the math I agree with. The point I don't agree with is that GPS 154 is the time towards the end of the 3-point turn. And now reviewing further data, we know that's not true.
The 12:23:58 event on the phone, is that related to the first event, the 3-point turn, or the second event, the backing maneuver?
So that's going to be related.
Was there any other data that was closer in time to the to the backing event that you had access to?
No, not that we had access to.
We turn to the next slide, please. You've seen this part of the report before?
Yes, I have.
Having seen the earlier part of the report, does it help you explain and understand this diagram?
Yes, it does.
Is this your diagram or Mr. Disorga's?
This is Mr. Disorga's.
Do you agree with this diagram?
No, I do not.
Okay. Could you explain to us what this, from your perspective, from your experience, what this chart is trying to suggest?
Sure. So this chart is trying to suggest that the lock event always occurs after the end of the text stream event. And again, that's using inaccurate adjustments to make that conclusion.
I want you to use the pointer and I want you to take us line by line why you believe that this is inaccurate in trying to conclude the time of those locking adjustments.
Sure. So it's kind of hard to tell. So what we've got is we've actually got two different sections. So we've got the top section, which is 1, 2, 3, 4, 6 events. So that's going to be the GPS event, and those, let's see, no, that's going to be this, it's hard to say. That's going to be the phone calls and the GPS event that are calculated in this. And it's also done with the 3-second delay as well, adjusted. But what we see is, so this obviously +1 is one of the phone calls that was from the defendant's iPhone time. So not from the infotainment system. So that's a inaccurate comparison. Same thing for the +2. The +1 and the +2 again, the +8, the +16, and the +20 are going to be those last two calls. If you'll notice, the very last call, we can't really tell which phone call is the correct one to compare. So we're using both within that same time frame. And that's why we get the 16 or the 21-second variance. But again, that's 5 o'clock in the morning. So that's not appropriate for the time that we were interested in. And then the 20-second variance is coming from that inaccurate GPS position comparison.
Could we enlarge that a little bit, Ms. Gilman? On the 2021, is that plus or minus 21?
So that is -21.
The 20 and 21, is that based on different information than the 1, 2, and 8?
Yes, it is.
And explain again for us, where's the different source of the information?
Sure. So the -20 is coming from that GPS point 154, which we know is not the end of the 3-point turn. It's right before the 3-point turn begins. And the -21 is coming from the last phone call that happens around 5:20, I believe, or 5:30. And again, that's 5 hours after the time of interest.
The -20 and -21, is that suggesting that time should be taken off or put onto Mr. O'Keefe's phone for synchronization?
Sure. So that's suggesting that time should be, I'd have to go back to the other slides. I believe that's, either way, it's suggesting that the iPhone lock event occurs +6 or +5 seconds after the end of the text stream event.
Besides not accommodating for the timing of that timestamp at the beginning of the 3-point turn, is there anything else about this that concerns you?
No, just that overall, these numbers can be misleading, again, because they're based on inaccurate adjustments, and could lead, again, the jury to believe that the lock event always happens after the end of the text stream event.
Can we go to the last page of Mr. DeSorga's report? Is this a conclusion offered by Mr. DeSorga?
Yes, it is.
Did you agree with that?
No, I did not.
Why not?
So based on those inaccurate adjustments, this slide is again kind of misleading in the fact that it states there's always interaction with Mr. O'Keefe's phone after the end of the text stream event.
You can take that down and turn that off, please, for a moment. After reviewing this report, you told us you then engaged in further study for synchronization?
Yes, I did.
Did you call me on May 7th?
Yes.
Okay. And what were you told to do about a report?
On May 7th?
Yes.
Sure. So I would finish the report and submit it.
Did you?
I did.
When did you submit it?
May 8th.
And do you know that it was provided to the defense by email on May 8th?
Well, here's the $1 million question, because Roosevelt asked a great question. Why is Bev allowing full direct here? If you've been watching the trial, you're aware that Brennan's been doing it the whole trial. The entire trial, every witness has been just a replay of the direct. And that's not what redirect is supposed to be. Redirect is obviously supposed to be addressing issues that were raised during cross-examination, not a time for you to rehash everything that was brought up originally during direct. And for me, the $1 million question is, why isn't the defense objecting to it constantly? And I think that the most likely answer is probably because I think where their head's at is that they, number one, don't care all that much about this data. It's like the Commonwealth wants us to be caught up in the data because that's what their case lives in. They need this data. It's their whole case is this data. The defense, if they object too much, if they're constantly, saying beyond the scope of cross, object, it then can appear as if you're trying to hide something from the jury. Like anytime something is objected to repeatedly, the jury starts thinking, all right, well, like, what don't they want us to hear? So I think that's why we're not getting constant objections as to beyond the scope, because this is clearly beyond the scope. This is obviously just him regurgitating the direct examination again. So that's my best guess on it. I mean, it makes for, a really, really long redirect because we're just not getting new information. We're just getting the regurgitated information, and he's not really attacking anything that was done. I mean, what he did in the first 25 minutes of the redirect was him doing what's a classic redirect, where you address things that were brought up during cross. And then he shifted to just directing him again. So it's painful. It's painful for me as a lawyer to kind of sit through it. And, I think that there's probably a thought that it's also painful for the jury as well.
Do you know if it was provided to the defense?
Yes, I know it was provided. I don't know when.
Now, if we could have Mr. Burgess's PowerPoint, we can go back to page 38, please. After you explain to us.
All right, so we got a little grouping to go.
Nicole, thank you very much for that. Should the defense raise hell and ask for comms communications with the expert for their motion to dismiss and do the same thing Hank did to them? So my answer to that would be no. And it's not because I don't think that there's anything there. I think there's plenty of smoke there. What's going to happen at the end of the Commonwealth's case in chief, which is imminent, like we're definitely not going to get it today because there's probably going to be some limited recross potentially, maybe not, unless he might be like, but there could be potential recross of this witness after lunch. And then they're going to be calling the next witness, who I have a feeling is probably going to have to be Welcher. Maybe they stick somebody else in there just to kind of add a buffer so that you don't have two very kind of dry expert testimonies back to back. But the Commonwealth's case is very close to being done. And at that point, the defense will file not a motion to dismiss per se, but it's a motion for what they call a directed finding or a directed verdict. And that's where and I went over this briefly yesterday. It's where you're just asking the judge to find Karen Reed not guilty because the Commonwealth did not meet their burden during their case in chief. Therefore, the defense doesn't have to do anything, which they don't have to do anyway. But the concept being that the judge is being essentially the trier of fact, finding that they had not met their burden. Those typically get denied, but the real reason is, Nicole, that they don't have time. They don't there's no point in filing another motion to dismiss at this juncture because they've got that motion for directed finding coming up to make the record for that. And they just have to prepare for their case in chief, and when you're preparing for your case in chief, you got to line up all your witnesses. You got to get all your directs ready. You got to set, what order you want the witnesses to testify. So they're not going to have the time to file the motion to dismiss. And I think based on what Canoni has said thus far, especially in terms of her ruling the other day, with respect to getting this stuff barred in terms of the new timeline or the amended timeline or the corrected time, whatever you want to call it, they know where her head's at. So it would be, and they made a record because that's all they care about is making a record for the appeal. God forbid that there were a conviction. So the record's been made as to the issue. I think that issue's been preserved. It would be a waste of time and resources for them to pump out a 25, 30-page motion to dismiss over Memorial Day weekend as opposed to preparing for the case. So it's kind of my thought on it. We got a little blooping, so let's bloop. She's going to come back, go to lunch.
A 50-minute lunch. I thought it would be quicker. It's my fault. So
yeah.
Lunch and Ms. Burgess again.
Thank you.
All right, please. Jared, follow me.
Okay, so we are officially on lunch break. Thankfully. I'm very, very hungry. So I'm very, very happy. Okay, so we're going to take a 50-minute lunch break. And I am going to give you the gift of Crash Daddy, Dr. Daniel Wolf testimony in anticipation of his testimony, which we will be seeing towards the end of the case in chief, I assume. But he'll be pleasing to look at for all those interested in that kind of thing. And we're going to be watching it off of the Trial channel, which is an awesome channel. If you guys want to have particular witnesses broken down, they do a great job of organizing it. So we're going to watch it from their channel. And I hope that you all enjoy it. So I'll pop off. I'll be back a few minutes before we're coming back. We'll get OnlyFan back up there and we will see what's next. I think Hank's getting pretty close to being done.
And the more I think about it, Alessi might ask a few questions, but he's not going to belabor the point, for all the reasons that I said. All right. So here's the dashing, handsome, brilliant Dr. Wolf walking to the stand. Judge Bev is getting into position to be just enamored. Loves her some Dr. Wolf. So this is part 70 of Karen Reed's first trial, courtesy of the awesome Trial Channel. And I hope you all enjoy it, and we'll see you after a little bit of a break. Make sure you feed yourselves. Feed the soul. It's important. It's very, very important. Let me boost the sound as well.
You solemnly swear the evidence given to the court and jury in the case now and hearing should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Doctor, could you state your full name and spell your last name for us, please?
Daniel Michael Wolf, last name spelled W-O-L-F-E.
Dr. Wolf, what do you do for a living?
I am the Director of Accident Reconstruction at a company known as ARCA, A-R-C-C-A.
And what is ARCA exactly?
So ARCA is a forensic engineering consulting firm. We have a variety of disciplines that include human factors, biomechanics, crashworthiness, accident reconstruction, just to name a few.
Based on your title, it sounds like you're the director of the entire accident reconstruction format for ARCA, correct?
That is correct.
What sort of contracts does ARCA routinely engage in?
So we do a lot of work in civil litigation. So we work with insurance carriers, law firms, but we also consult with and do projects with the federal government, as well as the National Hockey League on player safety. So we're involved in a number of research projects as well.
Is there other clientele that seeks out ARCA for accident reconstruction or biomechanics or human factors issues?
In terms of beyond the parties that I just listed?
You mentioned the U.S. Department of Defense.
Yes, the military, yes, the Army.
Tell me a little bit about the work that you've done for the Department of Defense.
Well, that was before my time, but I'm aware of projects that dealt with working on vehicles that were over in the Middle East, where they basically designed energy absorbing seats because there was injuries when the vehicles were going over IEDs.
Is ARCA known both nationally and internationally? Or is it recognized as a leader in accident reconstruction issues?
Yes.
As the director of accident reconstruction at ARCA, do you specialize in both accident reconstruction and the human factors that are associated with such reconstruction where necessary?
Yes.
Can you give me a synopsis of the professional discipline of what is accident reconstruction?
I think a simple definition in my mind would be the application of physics, engineering science, and mathematics to collision events. I always like to think of it as if you open up a puzzle box and you dump the pieces out and you've got a bunch of pieces and you're trying to piece together the evidence to see how everything fits to get a clear picture.
And what is the application of human factors to that process?
So to give you an example of human factors in the field of accident reconstruction, so I do a lot of nighttime visibility and conspicuity work. So to give you an example of that, let's say a driver's driving down the road at night, there's a pedestrian that's crossing the road. So we want to have an understanding based upon that pedestrian's clothing, the headlights of the vehicle, any potential artificial lighting in the area. When does a driver recognize that individual on the roadway? And then we can also look at literature to have an understanding of how do drivers respond based upon the hazard they're presented with. So there's different response times depending on the hazard. So it's going to be different for a pedestrian crossing the roadway or a driver responding to a vehicle suddenly stopping in front of them.
Dr. Wolf, as an accident reconstructionist, do you investigate and reconstruct both passenger vehicle issues, commercial vehicle issues, motor vehicle pedestrian issues, all of the above?
Yes, I see all types of accidents.
And how long have you been doing this work with ARCA?
A little over 7 years now.
What education, training, and background qualifies you to perform the duties that you've just described for the jury?
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
What additional training or experience do you have as it relates to accident reconstruction in addition to the formal education and the PhD?
Certainly. So in addition to my undergraduate degree and my PhD, I've continued to take courses through Northwestern University in crash reconstruction. Some of those courses have included human factors, lighting. I've taken courses on electronic vehicle data, photogrammetry, three-dimensional laser scanning. So I've continued to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstruction.
Are you trained in photogrammetry?
Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on map scenes, evidence from photographs, things of that nature?
Absolutely. So photogrammetry is the science of extracting information, if you will, out of photographs. So things dimensionally about an object, spatially, without ever actually physically seeing the object or inspecting it.
So you don't have to be at the scene to effectively and scientifically reconstruct it to your satisfaction?
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk, it's, the accident happened 5 years ago. Some I've even had 10 or 15 years ago. So getting access to the vehicle at that point, it's going to be a long shot.
Doctor, are you a member of any professional societies?
Yes.
Describe those, please.
So I'm a member of the Society of Automotive Engineers, SAE. I'm also a member of the National Association for Professional Accident Reconstructionists, the Optical Society of America, and also the Illuminating Engineering Society.
How many cases would you say in your experience in your career have you reconstructed or attempted to reconstruct, you or your team members?
I don't actively track that. If I had to estimate at this point in my career, it'd probably be well over 1,000.
And how many of those 1,000, I know you'd have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
You've done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
Absolutely. So we do a number of tests at ARCA to look at the interaction between pedestrians and vehicles. One of the ones I know I did most recently where we were evaluating a vehicle essentially rolling over a pedestrian. So we wanted to understand the vehicle dynamics as well as the interaction between the pedestrian and the road surface. So we conducted testing at ARCA to evaluate that.
Does ARCA have any other disciplines other than just accident reconstruction?
Absolutely. So as I mentioned earlier, we have crashworthiness. So again, that's where you're going to be looking at the safety of a vehicle. How does it perform in a crash? We have human factors, failure analysis, premise liability, and biomechanics.
As an accident reconstructionist, doctor, do you or have you studied or tested the forces that are at play between objects interacting, a human being interacting with a vehicle, for instance?
Yeah, absolutely.
Part of what you do.
Yes, sir.
Describe that.
So we use hybrid instrumented dummies at ARCA for our testing. So if we want to have an understanding that an occupant in a vehicle, the forces that they might experience, or for any matter, again, if it's an instance where you have something that ends up falling on someone's head and you want to have an understanding of the forces involved in that, we perform testing with hybrid dummies.
Have you ever authored any peer-reviewed papers in the field of physics?
Yes, sir.
Describe those for me.
So I have a number of papers in the field of lighting and optics. I have a recent publication that deals with Toyota and Lexus vehicle control history records as well.
Is that called Toyota Vehicle Control History, Sudden Braking History Recording Characteristics?
Yes, sir.
All right. Was that specific to dealing with vehicles and their interaction with other vehicles and or pedestrians?
It involved looking at the various triggers that system is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a driver, or I should say the vehicle, reaches...
May we approach?
Sure.
Now,
Yes, you
Thank
can
you.
move on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction, is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized a report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides.
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us and testify, correct?
That is correct.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case, as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
I would simply say it was looking more at the damage to the vehicle.
Okay, so in terms of your team and the responsibilities of each of the team members, you were more focused on the damage to the SUV. Dr. Rentschler was more focused on the injuries suffered by Mr. O'Keefe, correct?
I think that's a fair characterization, although with the caveat that we worked together as a team. So we weren't isolated kind of in those areas, not speaking to each other. We certainly worked together on the analysis.
Understood. Were you provided or did you review materials in furtherance of your consultation in this matter?
Yes.
What were you provided?
We were provided photographs of the incident location. We were provided photographs of the Lexus. There were a couple of incident reports that we received. I could look at my report for the full list, but those are the ones.
You can go ahead and do that, Doctor.
Do you have the report with you?
Yes, sir.
I have a copy of it. Is this faster?
Sure. If you...
May I?
Sure.
How many categories of materials were you provided?
Provided, it would be approximately 10.
Could you list those off for the jurors, please?
It would be the Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570, report of autopsy, and autopsy photographs.
Based on these data that you were provided, were you able to satisfactorily, to your mind, satisfactorily engage in the consultation that you were hired to do?
Yes.
And come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs, from the scene specifically?
So from those photographs, I was able to identify there was fragments of transparent red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime, yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where that evidence is. I noted that in a lot of these photographs, I didn't see a whole lot of that stepping in. It was essentially just zoomed right into where that evidence is, but not really having a great understanding of where was it relative to all of the other evidence.
Or when it got there?
Correct.
Based on your review of all the materials that you described for the court, did you get an understanding of what the Commonwealth's theory of the case is, specifically Mr. O'Keefe was struck by the Lexus SUV?
Objection.
Sustained.
Did you come to understand that the allegations before the court were that Mr. O'Keefe was struck by the vehicle?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Did you perform an accident reconstruction specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe?
Yeah.
Also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle?
Yes.
Okay. During your analysis, did you note the damage to the vehicle?
Yes, sir.
Describe that, please.
So the primary damage was to the right taillight. It appeared to be fractured with the majority of the lens cover, so that clear and red plastic covering missing from it. In addition to that, if you're looking at the back of the vehicle, to the left of that, in the area above there's also another tail lamp assembly on the lift gate. So above that assembly, there was a small dent along with some paint chips on the bumper. More so on the wraparound section, as it kind of curves around to the right side of the vehicle, there appeared to be some superficial scratches as well in that area.
Was there any other damage or deformation that you were able to glean from your review, the photogrammetry, damage to the Lexus, the bumpers, the panels, the quarter panel, the sheet metal, anything like that?
No, the rest was remarkably intact.
Is it common in vehicle pedestrian collisions that there is some sort of bumper displacement and or sheet metal deformation that's concomitant to that?
Absolutely. Assuming a pedestrian is positioned in a normal upright position, you certainly would expect to see damage to the bumper. In a lot of cases, what happens is, the bumper is just clipped on. So again, the force of that impact will oftentimes cause the bumper to kind of become unmounted or unclipped. You certainly could see deformation to body paneling, such as the lift gate or the quarter panel as well.
Is that especially true at higher speeds, meaning above 15 miles per hour or so?
Oh, absolutely, yes.
Was there any apparent damage to the Lexus that appeared consistent with any kind of pedestrian interaction that you saw?
No, it was really confined to just the taillight, a very isolated portion of the vehicle.
During your review and your investigation, did you note information concerning items that were supposedly found on the bumper?
Yes.
What was that?
I believe it was noted there was 2 apparent glass fragments located on the top bumper cover.
What's the significance of the presence of those items or the lack of materiality of those items in your view?
Well, again, I think it's going back to the scene evidence. Again, we knew that there was glass fragments, what appeared to be from a drinking glass, at the scene of the alleged incident.
Is there any glass consistent with the glass that was supposedly found on the bumper, in the taillight housing, the taillight mechanism, anything from the car, from the Lexus, that would account for that glass?
Okay, I think I understand. So the taillight itself is not comprised of any glass. It is all plastic. So that damage, or I should say that glass on the top bumper cover could not have come from the right taillight.
Now, based on your review of the information that was provided to you, did you undertake any testing of that vehicle? I'm sorry, any testing concerning the damage to the vehicle?
Yes, sir.
All right, can you describe what that testing was?
So we performed, again, this is with Dr. Rentschler and I working together on this again. We performed projectile testing to the tail lamp with a drinking glass as well as a hybrid head form.
Let's take those one at a time. How would you describe the drinking glass test?
Certainly. So again, from our review of the evidence, we knew that we had an isolated portion of damage to Lexus confined to the taillight. So we know that we're dealing with potentially a small object that could have created that. Looking at, again, the evidence in terms of the scene photographs, we know that we have a damaged drinking glass at the scene in the vicinity of the fragments of the taillight. So the theory that Dr. Rentschler and I put forward is potentially an individual threw this drinking glass at the back of the Lexus, causing the taillight to fracture.
I'm going to interrupt you right there. You and Dr. Rentschler formed that theory and wanted to test that theory, correct?
Yes.
You were not told that theory by the defense because you've never met us.
Correct.
You were not told that theory by the Commonwealth. You've never met them, correct?
Correct.
Your theory was the product of simply having some facts extant in the data. Got a broken drinking glass, a broken taillight. Let's put them together and figure out if the drinking glass could be responsible for the taillight and vice versa.
Absolutely, yes.
And that was your determination of, well, we were given instructions to reconstruct this. Let's look at every single angle, correct?
Absolutely. And I will note, as part of the engagement with the entity that retained us, we were asked not to do any outside research or investigation of the case. It was to be based solely on the evidence that we were provided.
Okay. As a matter of fact, and importantly, while you were doing your testing, had you ever even heard of the Karen Reed case?
No.
So getting back to that testing, and I interrupted your flow, you were looking at whether or not the glass could have produced the damage to the rear taillight that you saw, correct?
Correct.
And what did you do in furtherance of making a determination about whether or not that was possible?
Certainly. So myself and one of our lab technicians at ARCA, we designed and developed a pressurized air cannon. So it was capable of firing a projectile such as a drinking glass at the taillight. So it essentially, you can think of it kind of as a giant cannon, but it had a barrel, and then there was a valve that would open rapidly, and directly behind that was a pressurized vessel. And depending on the pressure, the PSI of that vessel, would determine essentially the speed at which that glass would be projected into the taillight.
So you literally built a cannon?
Yeah, it's pretty awesome.
Pretty cool job. Tell me what the results of your testing was with this pneumatic cannon that would fire the drinking glass.
Certainly. So we performed 2 different tests in terms of speeds. The target speeds were 30 and 40 miles per hour.
Why was that?
Well, so with consultation with Dr. Rentschler, he indicated that is a reasonable speed at which an adult male or an individual, for that matter, could throw a drinking glass at the taillight.
Had anybody up to that point, told you any specific, let me see if I can rephrase that. Had anybody indicated that there was any evidence whatsoever that John O'Keefe had thrown a drinking glass at the taillight?
No.
Was this another example of you and Dr. Rentschler and your team just exploring sort of every possibility and working a little bit in the blind?
Objection.
Sustained.
What was the reason that you decided, or you and your team decided, that you wanted to approximate how a grown man could throw a glass at a taillight?
Well, I think we wanted to have an understanding is when a projectile such as a drinking glass interacted with the taillight, would we get damage on the test taillight that was consistent with that of the subject taillight?
Understood. So based on your theory, were you able to approximate the damage on the taillight?
Yes.
Describe that for us.
So as I mentioned, we ran two tests. The target speeds were at 30 and 40 miles per hour. And there was a little bit of variability in terms of what our target was and what we actually achieved. So the achieved speeds were at 31 miles per hour and 37 miles per hour. So there's just depending on how the glass leaves the barrel and some of the rotation can affect some of the speed, or ultimately the end result speed to that. So what I will say though is that with the 37 mile per hour projectile into the taillight, we noted and observed that there was damage that was consistent with that of the subject tail lamp, and that the test tail lamp had the majority of the outer lens fractured and missing, broken into pieces, as well as some underlying damage to some of the internal components as well.
Are you saying, well, let me ask you a different question. You were able to replicate the damage to the taillight using a pneumatic cannon firing a glass at 37 miles an hour directly at the taillight, correct?
Correct.
All right. And that would also shatter the glass too, correct?
Correct.
Did you do any testing about whether or not that damage to the taillight could be produced by a person simply holding a glass and being hit by the car driving in reverse?
We didn't do any testing of that, and primarily because, again, if we're looking at the arm and its total length, right? We only have a narrow damage pattern, which on the taillight, if you think about where the kind of where it meets the lift gate into where it starts to wrap around to the side of the vehicle, that's only about 6.5 inches in width.
All right. When you fired the glass into the taillight was static. In other words, it was not going to move. It was immovable at that point, correct?
Correct.
All right. So the glass is hurling through the air at 37 miles an hour and hits a static object that's resisting, and that smash is what produced ultimately the taillight damage that you were able to replicate. Is that right?
Yes.
If a person were holding in his hand the glass, and the taillight were to hit that hand, the hand would not remain static, correct?
Objection.
Sustained. Ask it differently, Mr. Jackson.
If the taillight were the taillight were to make contact with a person holding a glass, would that replicate what you did in terms of your firing a glass into the taillight? In other words, are they apples and apples?
No, I don't think it would be the same.
Okay. Why is that?
Well, as I mentioned earlier, again, the damage to the back of the Lexus, again, is confined to just that roughly, again, when we're talking about the taillight itself, that 6.5 inch section in width.
Right.
So it's inconsistent with the total length of the arm, and certainly from discussion with Dr. Rentschler, inconsistent with the injuries to the arm.
So given everything in your investigation was revealed concerning this testing, are you saying that the taillight was damaged by John O'Keefe holding a drinking glass that was hit by an SUV?
Objection.
Sustained.
In all the information that you were provided, you were not provided anything that suggested that John O'Keefe threw a glass at the taillight. Right?
Objection.
Sustained.
Your approach.
Yeah, it's just, yes.
What information, if any, were you provided that suggested that John O'Keefe threw a glass at the taillight?
No information.
What information, if any, were you provided that suggested that John O'Keefe may have had a pneumatic cannon with him that night?
I'm not aware of any information regarding that.
All right. You also did some testing concerning a drop test. Is that right?
Correct.
Tell us about that drop testing.
Certainly. So, again, through discussion with Dr. Rentschler, it was my understanding that Mr. O'Keefe had a skull fracture on the back of his head. So we wanted to do an evaluation of the interaction between the back of a head. In this case, we used again, talking about that instrumented dummy again, we used the instrumented hybrid head form to perform a drop test to evaluate the forces of an interaction between a tail light from the Lexus and the human head.
What height did you choose to perform this drop test?
7.5 feet.
Why did you choose that height?
Well, if you calculate it through physics and the acceleration due to gravity, that would equate to an impact speed of 15 miles per hour at that height.
And what was the significance of 15 miles per hour?
Well, that was essentially kind of a starting point for us, if you will. So I will tell you that in reverse, 15 miles an hour is fast. I don't know if you've ever looked at your speedometer when you're pulling into your driveway, reversing into a parking stall. Most people probably don't go more than 5 miles an hour or so. So 15 miles an hour in reverse is fast, especially when we're talking about, it's my understanding it was nighttime. There was winter conditions, potentially wet or icy roads. So again, that speed is going to be what I would say on the high end for going in reverse. So also in addition to with respect to kind of just the nature of that speed, it's my understanding through discussion with Dr. Rentschler that at 15 miles an hour, you start to see significant injuries to the human body when it makes contact with a vehicle. And I think one last point is that we needed to pick a speed where, again, this is kind of just us brainstorming, where we would have damage to the taillight, right? It would fracture it, but it wouldn't completely obliterate it. So we knew if we chose a speed, for instance, of 40 miles an hour, we know we're going to completely essentially explode the taillight. But if we do, 1 mile an hour, we may not do anything to it, right? So we kind of had to pick a middle ground to again, cause damage to the taillight.
What was your conclusion following that testing? What was your conclusion with regard to whether or not it was consistent or inconsistent with the damage to the truck and the taillight was consistent or inconsistent with making contact with John O'Keefe's head at or above 15 miles an hour?
So strictly speaking to a damage perspective, the 15 mile an hour interaction between the hybrid head form and the test tail lamp produced significantly more damage than that of the subject vehicle. So that indicates that, again, the damage on the subject tail light was less than that of the test tail light.
So if I were to ask you whether or not there would be more or less damage to the taillight if you increase the speed to 24 miles an hour, what is your conclusion?
Well, you're talking about significantly more kinetic energy. So if you just think about it from, again, a kinetic energy standpoint, kinetic energy is equal to 1/2 times the mass and the velocity squared. So if you're squaring that velocity and you're going from 15 up to 24 miles per hour, you're going to get a significant amount of more energy associated with that. Probably, I could pull up my calculator, but you're probably looking at 2.5 more times energy than the 15 mile an hour test.
Which means 2.5 more times the damage to the taillight?
Certainly.
Which you did not see in your review of the materials, correct?
Correct.
So what is your opinion or conclusion as to whether or not the damage to the taillight was caused by striking John O'Keefe's head?
From a damage standpoint, it was inconsistent.
I want to shift gears back to the injuries that you saw concerning Mr. O'Keefe's arm, his right arm. During the course of your investigation, did you look at photographs and investigate the injuries to his right arm?
Yes, sir.
What's the width of the taillight, specifically from where it meets the lift gate to the left side? I'm sorry, to the side of the vehicle, the right side of the vehicle. To the right.
So yeah, as I mentioned earlier, that is about 6.5 inches. It starts to wrap around to the right side. So really, it's even though the taillight continues, it's not projecting out on the back end where it's again wrapping around. So in terms of the width that is facing the rear, if you will, it's about 6.5 inches.
And you noted that there was a dent and some paint chips that you identified above the lift gate, correct?
Correct.
How far away from the right side of the vehicle were those scratches and that dent?
Approximately 20 inches.
What was the significance of that distance?
Well, again, to go back to your question about, I think if somebody was holding a drinking glass, right, and their arm was extended to cause that damage, or if it's theorized that those dents and chips were from that. Again, the thing that sticks out to me is that you have essentially the Lexus taillight.
So ask another question.
What's the significance of whether or not there was damage between the dent and the taillight? In other words, that 20-inch area. Was it dented? Was it harmed in any way?
So in terms of, again, if we're talking about, again, looking at the back of the vehicle and we go to kind of where that right tail lamp just meets the lift gate, as I mentioned, there's another lamp assembly on the lift gate itself. There's also a chrome trim piece above that, and then certainly the body paneling to the lift gate itself. And I think what stood out to me is that between that dent and the fractured taillight, there was no observable damage to that area, which I would have expected had an arm been positioned there.
Can you calculate, or could you calculate, or did you calculate the amount of force that would be required to strike a person just only on the outstretched portion of his arm in order to project him a number of feet, for instance, 30 feet in one direction or another?
Okay, I just want to make sure I understand. Objection.
Take a distance out of it. Break it down.
I'll ask you the same question, but without the 30 feet.
Okay.
Were you able to calculate, or could you calculate the force that would be required to strike a person on his outstretched arm hard enough to spin him around and project him a number of feet?
If you're talking about only an interaction between the arm and the back of the vehicle, no, there wouldn't be any projection. Again, if you think about this, the arm weighs about, again, with Mr. O'Keefe would be about 11 pounds. So you still have, another 200 plus pounds being held down by gravity, and the force is only acting on the arm. So essentially the arm would be accelerated, but the whole body, because the center of mass is not being struck, would not be projected.
Is the absence of the damage that you described, between the dent and the rest of the vehicle, with the exception of the taillight, is that consistent or inconsistent with striking an outstretched arm of a human being?
Objection.
I'll allow that.
That would be inconsistent, in my opinion.
They have just a moment, Your Honor.
Yes.
And what is your opinion, Doctor, as to the amount of damage that you would expect to see at 15 miles per hour or above on the taillight if, in fact, that vehicle were moving in reverse and were to strike something on a human body, for instance, an elbow or an arm?
Objection.
I'll allow that.
I'm sorry, can you repeat the question?
Probably not.
Sorry.
I'm trying. Physics, that's why. From your testing, what would you expect to see in terms of the damage to the right rear taillight if, in fact, that taillight were to make contact with a part of a human body, for instance, an elbow or an arm, at 15 miles an hour or above? What would the level of damage be as compared to the damage that you actually saw?
Well, if we compare it to, again, looking at the drop test that we did with the hybrid head, which weighs about 10 pounds. So again, if we're talking about now a human arm that's comparable in that same weight, we certainly would expect to see a comparable level of force and damage. So as I mentioned, if the arm is outstretched across the right tail lamp and into the liftgate section, I would certainly expect to see deformation to that body paneling, even potentially the tail light on the liftgate itself and that chrome piece as well.
Based on the entirety of your investigation, your entire team's investigation, all the testing that you did, all the biomechanical testing and the engineering and the physics testing that you did, in your expert opinion, was that taillight damaged by striking John O'Keefe on the head?
Objection.
Sustained.
In your opinion, was the taillight damaged by either striking Mr. O'Keefe on the head or the arm?
Objection.
Sustained.
Can we approach?
Yes.
You are muted.
May I, Your Honor?
Yes.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
All right, jurors, we will take our morning recess.
Morning, sir.
Good morning.
Now, you in conjunction with, I'm sorry, Dr. Wenchler, is that correct?
Dr. Rentschler, yes.
So you in conjunction with Dr.
Keep your voice up, Mr. Lally.
Yes. You in conjunction with Dr. Rentschler and Dr. Klein wrote a report in regard to your analysis here, correct?
Correct.
And doctor, that report was issued on February 12th, 2024, is that correct?
Correct.
And in the first paragraph of that report, the last two sentences, you or whoever the author of that particular portion indicates, this analysis is based on information currently available to ARCA and is only to be issued in its entirety. However, ARCA reserves the right to supplement or revise this report if additional information becomes available. Is that correct?
Correct.
And that's pretty standard as far as your industry is concerned. You can only work with the information that you're provided. Is that correct?
Certainly.
Now, in this instance, you were provided 10 things, and then there were 4 additional things that either you or the other doctors had reviewed as far as literature or things of that nature. Is that fair to say?
Correct.
And the 10 things that you were talking about were reports, an initial crime scene report, medical examiner dispatch removal report. Is that correct?
Correct.
Photographs of the incident location. Is that correct?
Correct.
And how many sets of photographs of the incident location were you provided with?
In terms of the number of photographs?
The number of photographs, or were there different sets of photographs?
Yes.
And how many sets?
I don't recall off the top of my head. I know that there was a series that were taken during the daytime as well as ones taken what appeared to be in the early morning hours.
And you were also provided video from the early morning hours. Is that correct?
From what I recall, I think it was daytime, but yes.
And photographs of the vehicle, photographs of recovered evidence. Is that correct?
Correct.
CDR report from the 2021 Lexus LX570, correct?
Correct.
Autopsy report, autopsy photographs, is that correct?
Correct.
And then some other things, those will be the 10 things that you were provided with, and then there were 4 other things that you reviewed or part of your team reviewed, is that correct?
Correct.
Now, in regard to, there's a section in your report called Review of Materials, and it talks about photographs and glass fragments and plastic fragments and things of that nature, correct?
Correct.
You also talk about a black drinking straw that was recovered on scene, is that correct?
Correct.
However, there's no mention in the report about Mr. O'Keefe's shoe or Mr. O'Keefe's hat. Are you aware of those items as well?
Yes.
And are you aware that Mr. O'Keefe's shoe was actually found dug out from the snow, sort of flush with the curbing in front of the area where his body was found?
Yes.
Now, over the course of your work as a crash reconstructionist, and again, I don't mean this in any way, shape, or form, but I'm just curious. Typically, you're reconstructing or you're looking at someone else's reconstruction in relation to something that occurred in the past, correct?
Not always, no.
Well, my question is, sir, how many times have you actually been on like a live scene where the vehicles are still in place of final rest? Whether a body is in place of final rest, have you ever been to a scene where those sort of conditions existed?
Certainly. We have a rapid response team that essentially we've been on site on the day of or the week of the incident, yes.
Now, how often is that?
Not nearly as often as, like I said earlier, we primarily do litigation work. So again, by the time we're retained, obviously the scene has been, is no longer present.
Scene's been cleared, items have been removed as far as evidence or other things. That's mostly what you deal with, correct?
Sure.
And as far as the hat that we were talking about before, are you aware that that was recovered as well? Same day as the drinking straw on February 3rd in the area where the body of Mr. O'Keefe was discovered?
In the area of the front yard, yes.
Now, you have some familiarity through working as a crash reconstructionist with pedestrian collisions, correct?
Correct.
Is it common or uncommon for in the course of a pedestrian collision, for a shoe or glasses or a hat or something to fall off of that pedestrian in the collision sequence near where the area of impact occurs?
Well, I think that depends on the interaction between the two. If it's more of a side swipe type interaction, if we're just talking about an arm, for instance, contacting the vehicle, no, I would not expect the shoe to come off. If it's something where the entire body is interacting with the vehicle, then yes, there's a greater likelihood that something like a shoe will come off, yes.
So that is consistent in general terms with the pedestrian collision of the shoe coming off, correct?
Again, based on the interaction between the two. I wouldn't say it's a blanket statement that, again, in all pedestrian interactions, you will have a shoe come off.
And that's not the question I was asking. So what I'm asking, is it generally consistent with pedestrian collisions that a shoe may come off during the collision sequence near the area of impact?
Shoes can come off in a pedestrian impact, yes.
Now, again, you were testifying earlier about the damage to the Lexus being isolated in the area of the taillight, correct?
Correct.
And that was based on the information that you were providing, correct?
Correct.
Now, with respect to any of the materials that you were providing, was there anything in the materials that you were provided that indicated that just the arm or an outstretched arm of Mr. O'Keefe interacted with the vehicle?
No.
And based on your review of any of the materials that you were provided, was there any information stating that Mr. O'Keefe had been struck in the back of the head by the taillight assembly of the Lexus?
No.
And based on any of the materials, let me ask you, based on any of the materials that you provided, were you aware that Mr. O'Keefe is on video exiting from the bar minutes before crash occurs at approximately 12:11 a.m. holding a cocktail glass in his right hand?
I'm not aware of that video.
Now, other than the materials that we just went over, as far as the 10 things that you were provided, you weren't provided anything else, is that correct?
That would be correct.
And so sort of the questions that you endeavored to answer, those were questions that you didn't know from any of the materials that you were provided, is that correct?
If I understand your question correctly, there was nothing in the material that indicated the questions we were to answer, if that's what your question was.
That is my question. So there was nothing in there, is that correct?
Correct.
If I may have a moment, Sharon?
Yes.
You talked a bit about, you have some extensive background in human factors, correct?
Correct.
And as far as visibility, in particular, have you ever conducted a visibility analysis?
Absolutely, hundreds of times.
And you talked a little bit about conspicuity, is that correct?
Yes.
And part of conspicuity, at least one of the factors, would be a reasonable expectation of, in particular, when you're talking about a pedestrian. Part of the conspicuity factors would include sort of a reasonable expectation that a pedestrian would be in the path of the vehicle. Is that fair to say?
I don't understand your question.
Sure. When you're talking about conspicuity or visibility analysis, in particular, you're talking about something called PRT, or perception reaction time, correct?
Well, that occurs after recognition. So first, a driver has to recognize that there's a pedestrian there before they can actually respond to it. So once they've recognized the pedestrian, then you start the perception response time where, again, the driver has identified what the hazard is. They're making a decision about what to do. They might be moving their foot from the accelerator pedal to the brake pedal. So again, kind of that's the action or the time frame in which a driver is undergoing action to potentially mitigate the collision.
And perception reaction time, that's a pretty commonly used industry sort of standard as far as crash reconstruction goes, correct?
Well, I would say that it's used in the field of accident reconstruction, but as I mentioned earlier in my testimony, there isn't a blanket number in terms of perception response time. As I mentioned, it's based upon the hazard that the driver is presented with. Again, if you've got a pedestrian crossing the roadway, that's going to be one particular perception response time based upon studies and naturalistic data versus a driver suddenly stopping in front of you, right? It's not the same perception response time in every scenario.
No, understood. And there's different variables that may affect that as far as someone's age, as far as the lighting that's available, other things. Is that correct?
Sure.
And one of those things might be the reasonable expectation of a pedestrian being present in the roadway as you're driving along, correct?
Expectancy can play a role, yes.
In expectancy, what we're talking about is sort of the disparity or the difference between driving along a country road where there's no houses for miles and miles versus an urban area where there's crosswalks every 15 feet, correct?
Sure.
Now, in that expectation of privacy, how high would that be if we're talking about a pedestrian that actually exited from the vehicle that then strikes them?
I don't understand your question.
Let me ask you this. If the operator
And we're back. Saw a little movement. Saw a little furtive movement by the camera there. You can always tell when they're getting ready to come back because the camera operator gets back there. There's a little shifting. I saw it. I seen it. So I think we're going to be imminently back to trial. All right. So I'm sorry to rip the lovely and wonderful Dr. Wolf away from you so unceremoniously like that, but you know, sometimes it has to be done. Right. So for those of you who have watched both trials, and for those of you who have not, this is an honest question right here. Are you going to believe that guy you just watched the last 40 minutes? Or are you going to believe the tuft if you're a juror? I mean, which guy is more credible? It's as simple as this case is in my book. It's that simple. It's that simple. It doesn't have to be any more complicated than that. It's easy to get lost in the minutia, though, you know. It really is in the trial. But when you kind of break it down to just brass tacks, they're getting down to brass tacks. It's that simple. This guy, yeah, I know. It was probably a real shock to the system to have Wolf ripped away from your eyeballs with his pleasing demeanor, all his smarts. Guy's a great witness. Great, and it's funny to watch those two witnesses kind of back to back. That's it. It's that simple. It's that simple. Osbrook just nailed it. I mean, it's what I've been saying for whatever, 2.5 years. Science doesn't lie. I don't give a shit where his car was or where Karen's car was. I don't care. It doesn't matter. I don't care if they're spot on to the second of where her vehicle was that evening, because at the end of the day, what this guy says, who was not hired, which is so important by either side, and who is highly trained and educated and highly experienced, and he's been doing it for a long time, and highly credible. I mean, to me, I'm just leaning so hard into Wolf and Rensselaer, and Rensselaer is just as good. You know, it's just as good. Yeah, we lost Allie probably for the whole afternoon. She's trying to get a case resolved in person, so I fear that we may not be hanging with her this afternoon. Just got me. So, did you guys have anything good popping up when I was gone? Let's see. All right, doesn't look like. Looks like Janelle Woodward joined the fam. Aw, family hug. KRP, WKRP in Cincinnati. Johnny Fever, welcome, KRP. Seems like you've been a member, right? And the delightful, not so Zen Jen. Welcome, family hugs. Aw, family hugs to all three of you. And everybody, like there was a massive family hug, like dump that took place because Idiot and Wind and her amazing gifting of 50. Oh, I love that. Love to hear it. Love to hear it. How deep are you in, Carl? I mean, it's long. It's still going. But, you know, I'm really trying to give people a... Wait, what? Osbrook, are you hating on WKRP in Cincinnati? That's outrageous. Don't be ridiculous.
All right, can you remove me? Am I still there?
No, I took you. You gone.
Okay. I'm heading to court. I'll be watching you guys in the chat while I'm driving.
Love you.
Love you.
Good luck. Take him down. I try. I do the best. Gallows humor. Gallows humor. You know, it's important. Gotta have gallows humor. Trevor loves you too, babe. She's like, no, yeah, chat, the chat. She's like, who? It's like, Trevor, man, Trevor. Oh, Rebecca Wright, 7. Welcome, 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 welcome. Love having you here. Love having you here. So, yeah, like I said, I think Hank's pretty close to wrapping on the redirect. I do not anticipate that Bob Alessi is going to take a overly long time on recross, if any. And then we move on to whoever's next in a shocking turn of events, which I was not aware of. I apparently have won the trial bingo, which is ironic because I was one of the shows donating, but apparently I had not marked off Shannon, and I had not marked off Nicholas Bradford. As I sit here today, I have zero recollection of Nicholas Bradford testifying. Who was he? Was he another one of the cops? I just don't remember him. So yeah, but now Phil Toyo Toys is telling me that I downloaded 2 bingo cards with the same email, which I'm rejecting. I did no such thing. I have 2 bingo cards, but that's only because my printer printed out 2 copies of the same card. So I'm rejecting Phil's notion that I had multiple cards in play, as I did not. However, that being said, assuming that I send the gift to myself as the prize and I get the prize from Josh, we're going to, of course, wheel spin those away to y'all. I mean, that only makes sense. It's ridiculous for me to win my own prize. It's absurd. Like, the concept of it is absurd. Absolutely absurd. Yeah, apparently I won bingo. I won. Yeah, I wasn't aware of it until Mandy sent me the tweet today, because I had obviously I didn't have the card with me when I was in Boulder, so I was not aware of the huge victory, the massive victory. But listen, I've been able to shrink the field to the people that someone in our chat, one lucky person in our chat, is going to win everything that was available in trial bingo, unless Phil's going to come at me with this bullshit that I had 2 cards. You know, I mean, I want some kind of proof. I want the hash values. He's going to have to give me hash values. I need some kind of definitive proof. I've already put a call into Aperture to hire a expert witness to plead my case. So I feel very confident that I'm going to win because I've got Aperture on my side. Hey. Oh, Liz, I did not realize the first time that you had sent a super like last week that you were Karen's sister. So I apologize for that. And we are 100% behind you and Karen and the family. And I hope that you do feel the positivity. So I thought that was really neat that you were in here. So thank you for popping in with us and hanging with us for a bit. We try to, we try to keep it a little bit light in here too, because it's dire circumstances. So like I always say, little gallows humor is good. I learned that over 2 decades of doing this in courts. It's, if you don't have, laughter sometimes is the best medicine. So, but I feel like the case is going well. And, you know, the best part is the defense hasn't done anything in terms of their case in chief yet. So that's always a good sign. That's a good sign. So, yeah, keep staying strong there. Give all the fam hugs from us. And, you know, I know that Karen and the family knows that there's a lot of support out there. A lot of support. It's a great thing to see. It's a great thing to see. But thank you for your generosity, Liz Reed. You guys hear my dog, Nanook? He's licking himself. It's kind of gross sounding. Should mute it. Yeah, we're still awaiting. Judge Bev, per usual, not timely with the return. She's already eaten into the short afternoon session that we have. She doesn't usually take an afternoon break, right? She doesn't usually do that. Like the number of sidebars that we get are typically the equivalent to a break. So I don't think we do take breaks. Yeah, we're live. Do you guys find Boston 10 to be a little glitchy? It freezes up every once in a while. I'm curious. I like the fact that they don't have a bunch of nonsense on the screen. That's why I tend to lean towards them. I don't need the lawyer ads popping up and the QR codes for, you know, whatever it may be, like those lawyers or hymns, whatever the case may be. So we'll stick with it. If it's glitchy, I'll change it to a different stream. But so far, I like it. I like it. It has been a little glitchy though. They've had some afternoon issues on a couple of days. See, Just Jim was looking at getting my True Crime Podcast Fest tickets. Didn't see anywhere to use your code. Just a question about who I'm there to see. When you check out, that's when you put the promo code in. That's when you put the promo code in. Like it'll ask for a code. I think like when you're at the very end process of checking out. Let me see if I can. Are you doing it on your phone or are you doing it on a computer? Let's see. All right. Okay. All right, we're back. I'll look into it. I'll figure it out. I didn't even see when Tony threw the super. It's hilarious. Oh, is Will in there today?
May be seated.
Smoking cigs.
All right, Mr. Brennan, whenever you're ready.
Thank you.
All right, let's go.
Sir, when I asked you about your first report regarding the protocol, you told us October 10th, followed by your supplement on the 17th. You did not remember the day that you first received any information offered by Mr. DeSorga. Is there a document that may refresh your memory?
Yes, there is.
May I approach?
Yes.
Thank you. I want you to read this. I just want you to look at it. You can look at any part of it.
Okay.
And look up when you're done, then I'll ask you a question.
Okay.
Does that refresh your memory the first time that you saw any information provided by Mr. DeSorga?
Yes, it does.
And when was that?
November 7th of 2024.
Before or after you recognized the megabyte oversight?
That would be after.
I want to go back to where we were at before we went to lunch. You had described 2 text stream events. I want to focus on the first text stream event, and that is the text stream event relative to the 3-point turn.
Okay.
You had described that there was a timestamp 154. Just to reacquaint us, can you very briefly tell us the significance of 154?
Sure. So GPS point 154 is a GPS point that occurs just before the 3-point turn starts.
And why is it important to identify when that turn starts and when it ends?
Sure. So what we're specifically looking at comparing is the end of the 3-point turn. That's going to be the text stream event ending, which is near the end of the 3-point turn, as well as the end of the 3-point turn as recorded in Mr. O'Keefe's iPhone.
Was it important to identify the beginning and end of that event to come to a conclusion to a reasonable degree of scientific certainty regarding the variance between the text stream data and Mr. O'Keefe's phone?
Yes, there was. So we can't say, we can pinpoint approximately when the 3-point turn ends based on the GPS data. But best practice would be to use a range of time. So the range we're using is the time that the 3-point turn starts to the time that the 3-point turn ends.
Could we have from Mr. Burgess's PowerPoint number 41, please? Is this part of your presentation helpful in explaining the beginning and end point of that 3-point turn?
It does. It does. So if you recall yesterday, the first heading change from a general north heading is depicted by that green shading circle.
Could you use your pointer, please?
Sure. Yes.
Ms. Gilman, can you enlarge just a little bit?
So again, this green circle is going to be the center of this circle is going to be the GPS point itself. That's going to be centered on the horizontal radius, which is the accuracy. So the green circle represents the 16-foot accuracy zone. The black arrow coming off in a northwestern direction is going to be the heading for that point. And then again, the yellow is going to be the approximately 8 seconds later when the heading changes again in a southerly direction. And then the GPS points after that also continue south with increasing speed.
What part of the 3-point turn event does the green circle signify?
Sure. So that's going to be the approximate beginning of the 3-point turn.
And that time?
That's going to be 12:23:59.
The yellow circle, what part of the 3-point turn does that indicate?
Sure. So that's going to be approximately the end of the 3-point turn. And that time is going to be 12:24:07.
Is there any correlation between the times in the green, the time difference between the green and yellow circle and the range you ultimately arrive at as far as the synchronization variance?
Yes. So that is what determines that range of 21 to 29 seconds.
This illustration or diagram where you've put the green circle, is that based on actual data?
Yes, that is based on actual data recorded by Mr. O'Keefe's iPhone.
That data, is it accurately reflected in this diagram?
Yes, it is. So again, the GPS point that is recorded within the iPhone, every point has a horizontal accuracy. And again, that horizontal accuracy is depicted by the green circle.
Is that level of precision used when you create this diagram?
Yes, it is.
The yellow circle, is that specifically reflected in the data or is that an estimate?
Sure. So that's specifically reflected in the data. So that is another GPS position that has been recorded by the iPhone. Again, with a horizontal accuracy, a timestamp, and a speed and heading.
How about the orange circles?
So the orange circles are are portions of the GPS positions leading up to this event. So if we went back one slide, you would see it would zoom out, obviously, so a little bit harder to see. But essentially what we've done is I've removed the other orange circles representing GPS points heading north and the GPS points heading south after the 3-point turn. And I've just removed those for clarity to kind of clean up the map so it's easier to read.
On the left, text stream 11621. Remind us again where that information comes from?
Sure. So that's the text stream. That's the end of the text stream event for the 3-point turn. And that is based on the infotainment clock as well as that running timer from the airbag control module.
Does this diagram reflect the data that you reviewed to a reasonable degree of scientific certainty?
Yes, it does.
In breaking down this timestamp 154 and getting into the minute detail of when it started and ended, one of your charts, does it also show it numerically?
Yes, it does.
Can we have number 40, please? Before we discuss this again, where did you get the information to put in this chart?
Sure. So this is coming from Mr. O'Keefe's iPhone. Specifically, it's coming from a SQLite database that is recording locations as he's using the Waze app to navigate.
Is the information in this chalk or diagram directly from the data?
It is directly from the data.
Is this accurate to a reasonable degree of scientific certainty?
Yes, it is.
If we could zoom in just a little, we'll have to go left to right, Ms. Gilman. We start with the left. Timestamp 154. At what point in that 3-point turn does 154 represent on the left?
Yeah. So timestamp 12:23:58 or GPS point 154 is approximately 1 second before we see the heading change. If we could zoom out just a little bit. A little bit more. Yep. So we see the heading change represented in green. That's a heading change to 284. Before that, we've got a pretty consistent heading of 348 to 339. So that first heading change, as well as the drop in speeds, is indicative of a 3-point turn maneuver.
The latitude and longitude, did that assist you in making the diagram with the circles on it?
Yes, it did.
How so?
So the latitude and longitude are the center points for each GPS point or the center point for each circle.
There's a green highlighted row and an orange highlighted row. What's the difference between the two?
Sure. So the green highlighted row is, again, the beginning, the approximate beginning of the 3-point turn. And the orange or the yellow is the approximate end of the 3-point turn.
And the time between the green and the orange lines?
Approximately 8 seconds.
Is that consistent with the range that you've shown for synchronization?
Yes, it is.
Point 21 or plus 21 and plus 29?
Yes, it is.
The inevitable variance that you found between the text stream data and between Mr. O'Keefe's cell phone, could you share with us to a reasonable degree of scientific certainty what that variance is?
Objection, Your Honor.
Sustained.
Do you have an opinion about the time range in the synchronization between Mr. O'Keefe's cell phone data and the Lexus clock that shows the text stream data to a reasonable degree of scientific certainty?
Objection, Your Honor. I appreciate an approach at the appropriate time.
Okay, so answer that question, yes or no.
Sure. So yes, I can.
So I'll see you inside that one, Mr. Wilson.
Thank you, Your Honor.
I mean, I hope Alessi's going up there to say, look, we're not objecting, but this guy's literally redoing his entire direct examination. Like, I don't want to be put in the position as a defense to have to object to it the whole time because it makes us look like we're being petty or trying to hide something from the jury. But this is enough is enough. Like, that's not what redirect's for. Redirect is not for regurgitating, puking back up all the exact same information that has already been asked and answered on direct. It's crazy. So I'm hoping that that's what this conversation is. And that Judge Bev is saying, obviously he's right, Mr. Brennan. You don't get to just regurgitate this again. over and over. The jury's already heard this. How is it
Everyone in
addressing
this
it?
room is now dumber for having listened to it.
Yes, agreed. So hopefully that's going on, and hopefully that's going to shorten this thing up. I mean, we don't need to be going through this again. We don't need to be hearing this again. So I don't know. We'll see. We'll see what it is. Because it wasn't a specific thing. When Bob objected, he said, when you get a chance or when you deem it appropriate. So it wasn't necessarily a specific thing. In terms of what was just said, it seemed like it was kind of an overall objection to this entire thing that Hank has been doing the entire trial, which is basically having his witnesses testify to the same thing 2 times, once on direct and then again on redirect. What'd Allie say? I didn't even see her. She say something hilarious and glorious? Oh, Olivia Yates knows. She likes her some Crash Daddy. I must have blocked Allie. I never see any of her messages. She in chat? I don't know where she is. I don't see her. Where is she? I don't know where she is.
Hey, Allison.
Where you at, girl? Can't see you. Yeah, I'm just trying to work us through it, kids. Trying to work us through it. Oh, text. Oh, I see. Okay, I'll peep that in the text. Oh, man. Oh, there she is. Oh. I mean, Allie's question is like legit. Because, I mean, that would be way before the 3-point turn. Appears that it happens way before they're claiming that she was struck by the vehicle, right? Because that was at like 12:23, the 3-point turn. Am I missing something? Like, why do they keep harping on the 3-point turn? I think that the reason they're doing that is because it's the 3-point turn where they claim that they're able to sync up the phone's activity with the Lexus's activity. I think they're using that as the factor that was used in order to get rid of the time discrepancy. So that would do it. That would absolutely do it. I mean, this is a brutally long. You know what? When we have a sidebar that's this long, we have no choice. We really don't. We have no choice but to have a little party. And that's what we're going to do. So cover your ears because this is a loud soundbite because it's a party. It has to be loud. Oh, yeah. Yes. See? It works every time. Like going to the bathroom. That's when the phone rings. Every time it works. Mr. Brennan.
Can we go back to slide 40, please? In reaching your conclusion about the variance between the defendant's Lexus as contained in the text stream as it relates to Mr. O'Keefe's iPhone, was stamp 154, timestamp 154, part of your analysis?
Yes, it was part of my analysis.
Was the running clock on the text stream data part of your analysis?
Yes, it was part of my analysis.
What else was part of your analysis?
So in addition to the location data, including the GPS 154, that would be the running clock for the text stream data, as well as the infotainment clock from the Lexus.
How does the running clock correlate with the text stream data and with the time on Mr. O'Keefe's iPhone?
Sure. So they correlate. So the running clock and the infotainment clock are used to create that timestamp for the text stream events 1 and 2. And then comparing those to the iPhone, we can adjust and get a clock variance for those.
Did you come to a conclusion to a reasonable degree of scientific certainty about the variance range between the defendant's Lexus and its clock system and Mr. O'Keefe's phone?
Yes, I did.
And to a reasonable degree of scientific certainty, what is that variance that is needed to identify for synchronization?
Oh,
That is 21 to 29 seconds.
We now have number 43.
It's a pretty great monocle.
Did you create this diagram?
I did, yes.
Correct. Correct.
When comparing the text stream event, the backing maneuver, to Mr. O'Keefe's clock on his phone, do you recognize the different timestamps on each device?
Yes, I do.
When you are trying to synchronize them, what do you do? What is the base? Do you start with the text stream event and you add, or do you start with Mr. O'Keefe's phone and subtract?
Sure. So we could do it either way because we're wanting to compare this against other events that happened or occurred on Mr. O'Keefe's phone. We're going to adjust the text stream clock or the Lexus clock to Mr. O'Keefe's clock. But you could do it either way.
The window that is depicted on this diagram, this is not the 3-point turn?
No, this is not the 3-point turn.
Which event is this?
This is going to be the backing maneuver.
The green, what does that green depict?
Sure. So the green depicts the range of time that this text stream event ended. So based on our range of 21 to 29 seconds and applying that, adding that to the Lexus clock, we get a adjusted time of 12:32:04 to 12:32:12. And that's going to be the approximate end time of text stream event 11:62:2.
Now, again, the text stream data has a limit on the amount of time available?
Can you rephrase your question? So I
Sure. You
understand.
said a window is captured during a triggering event.
Sure. Yes. So there is a window that's captured during the triggering event.
And what is that window? How much time?
Sure. So from the text stream trigger, there's 5 seconds before and 5 seconds after.
Can an event be longer than that 10-second window?
Yes, it can.
And in this case, do you know at the end of this reconciled event at 12:32:12, do you know from your study what direction the defendant's car was traveling at 12:32:12?
It would have been traveling in reverse.
And at 12:32:12, do you know how fast the defendant's Lexus was traveling at 12:32:12?
I do not recall.
Mr. O'Keefe's last user interaction with his phone at 12:32:09, where does that fall within the 10-second window that was captured by the text stream data?
Sure. So that falls within that 8-second window. So again, the text stream event ends somewhere between 12:32 and 04 and 12:32:12. But that does not represent that the backing maneuver has ended. Just the recorded data has ended.
And in your review, do you have around this time any other movement of Mr. O'Keefe's phone after 12:32:16?
I did not look at that specifically. It was my understanding that Mr. Whiffen looked at that.
To a reasonable degree of scientific certainty, did both these events, the last user interaction and the window captured on the reconciled data for the text stream, happen around the same time?
Yes, they did.
I have no further questions.
Thank God.
All right, I can approach later or now.
Thank you for being an amazing, beautiful witness for me. By the way, the tuft looks amazing today. I'll tell you right now, Hank's about 3 months away from having a tuft. Oh my God. Another sidebar? Ugh, Jesus. You know what that means. You know what that means. Oh, whoa. It got cut off right in the middle. Mandy, did you kill the shot party? I feel like Mandy just killed the shot party, like right when I was mid partying. Crazy. Why did they take another sidebar? I don't know. I don't understand it. A lot of sidebars. Boy, Karen and Ajax are really having a intense conversation right here. Wouldn't it be great to be a fly on the wall right there? That's right, Mandy. Pin it on the girl. Pin it on the girl. Pin it on the girl. Bobby, the boy just ain't right. I have a narrow urethra. That's what's we got going on here? Let's see, Mellow. Yeah, just Jim, I want to try to figure that out. Let me know if you figure that out in chat. You don't have to send a super or anything. Just let me know if you're able to figure out that code. So I can also message Laney, the organizer of the festival. Mello, what was his quote scientific reason for why magically at 5 a.m. the clock drift is less accurate, or that accuracy didn't matter then? It's a great question. It's a great question. I don't know that got addressed either. And then Norman Corey, they're also using the 3-point term because it happened in the text stream, even when it was in the state police custody. Interesting. It's interesting. Are they currently... The only thing that I can think that's going on right now is that Alessi did want to have some recross, and Judge Canoni was inclined to say, you're good. And he wanted to make a record of it and tell her why he felt that a recross was necessary. I mean, she's going to be saying, but Bob, all he did was say the same shit that he said on direct. Like, what do you have that's new? I'm guessing that's like, what else could it be? I don't know who called it. Does anybody know who called the sidebar? I'm not sure who called the sidebar. Oh, Hank. Hank asked for the sidebar. All right. Maybe he's out of witnesses for the day. Maybe it is a half day. Look at that. I don't know. What the dog doing? Sleeping. It's napping. It's a little overcast today. in the greater Chicagoland area. So he's laying there quietly, just being the sweetest guy ever, because that's what he is. All right, let's see what's popping, what's cracking.
Your Honor, I move into evidence the following pages from Mr. Burgess's PowerPoint presentation. Move into evidence page 41. I move into evidence page 40. And I move into evidence page 43.
Okay, allowed.
Thank you.
You are correct.
I have no further questions.
You are correct.
Once we get these marked, I'll
All right, so Hank forgot to move some stuff into evidence. That's what the whole sidebar was. Because you have to move your evidence in at the right time. So he had to go over there and snivel a bit. Because he whiffed.
A, B, and C. All right. Whenever you're ready, Mr. Alessi.
Thank you, Your Honor.
Tough, just like, oh, fuck. This guy again. The robot is going to cross me more.
May I, Your Honor?
Yes.
Thank you. Mr. Burgess, between the time you left the witness stand yesterday until this moment, have you talked to anyone about this case?
No, sir, I have not.
Has a filing ever been made in any court in which your educational background has been misrepresented?
No, not that I'm aware of.
Pardon me?
Not that I'm aware of.
Ruh-roh. You do some digging at lunch? Don't know what that means.
Did I understand that you're based out of the Aperture office in Texas?
Yes, I am.
And are you aware of a case in the United States District Court, Eastern District of Texas, Marshall Division, titled Jeffrey Glover and Teresa Glover versus Graphic Packaging International LLC? Are you familiar with that case?
Yes, I am.
And is it correct that in that case, well, tell me how you are participating in that case, sir.
So I'm no longer participating in that case. So if I believe correctly, that would have been a accident reconstruction case from, I don't recall, a year or two ago.
And so it was a case that you did participate in, correct?
Yes, I did.
And what was your role in that case?
Sure. So my role in that case was an accident reconstructionist.
And did you provide any testimony, deposition, or otherwise in that case?
No, I did not.
Did you, in that particular case, there were, like all cases, filings made, correct?
I'm sure there were, yes.
Don't mess with Texas. Don't mess with Texas. Yeah, this guy's still up, especially for you, Dr. Shiloh.
May I approach, Your Honor?
Yes.
I would like to have a document marked as the next exhibit for identification.
Okay.
Please.
Exhibit EEE for ID.
May I present to the witness, Your Honor?
Yes.
Thank you. Mr. Burgess, I am showing you a document which has been marked as Exhibit EEE for identification, and I'd ask that you take a look at it, sir. Your Honor, may I remain here?
Sure. As
Thank
long as you stand back a little bit.
Exactly, yes. Thank you, Your Honor. I'll take it even farther.
Yes.
Mr. Burgess, with regard to Exhibit EEE, do you recognize the second page, and do you recognize any stamping at the top of each of those pages?
Yes, I do.
And can you describe what that stamping is?
Sure. So that is stamping for a file date of 8/7/2023.
And is that a stamping of a federal court?
That I'm not sure.
If I were to show you a document, might a document refresh your recollection as to whether
Sure.
Exhibit EEE is a filing in a federal court?
Yes.
May I,
That's
Your Honor?
weird.
I am showing you,
Did you show those to Mr. Brennan?
thank you, Your Honor. I believe I did, but I want to make sure.
And just let me know if we need to move.
We will, Your Honor. Thank you. Can I mark each of
Yes.
these for identification? There,
Yep.
Let me just give one first. See if I can see that back and court report. I want to see if this is the second page for that document. It is, so it can be marked as one document for identification.
Exhibit FFF for ID. Thank you.
I reach over you, sir.
Yes.
Thank you. Sir, I am showing you what has been marked as Exhibit FFF for identification and ask whether or not this document can refresh your recollection as to whether the court filing that you reviewed in Exhibit EEE is indeed a federal court.
Yes, it is.
So that document refreshes your recollection that what has been filed is represented in EEE as a filing in a federal court, correct, sir?
Correct.
Now, what I'd like to do is to draw your attention to the second page of this exhibit. Is that a curriculum vitae of you and a picture of you?
Yes, it is.
And sir, under education.
Objection.
I would.
The objection stays.
Right. Do you
want to bring it over? We can take
I
it
will,
there.
Your Honor. I will.
Jurors, feel free to stand up and stretch.
That was Bob walking over there with this CV from this other case. Oh boy. What is with this weirdo smile that Judge Bev keeps doing? Let's take another look at it. It's very disconcerting. I don't know exactly what it is.
Stand up and stretch.
You know what it reminds
I
me
will,
of?
Your Honor.
It's like when the Grinch's heart.
Yes, it is.
Throws.
Curriculum second page of this exhibit, is that a curriculum vitae of you and a picture of you?
Yes, it is.
And sir, under education.
Objection.
I would.
The objection stays.
Right. Do you?
Do you want to bring it over? We can take
I
it
will,
there.
Your Honor. I will.
Jurors, feel free to stand up and stretch.
Wow, that's like crazy. She's like, hey, want to come over to my place and let's take a look at that CV? Come on over. Let's go over in the corner. Let's check it out. Look at it together. Yeah, it's weird. It's weird. It's one of the many weird things about this trial. So many weird things. All the weirdness. Samantha says that Alessi is the most badass nerd ever. Nerd king. King of the nerds. That's what he is. Ah, no question, Benjamin. Alessi's fire. Absolute fire. He is the nerd king. I mean, can you believe that dude's 67 years old? Yeah, you heard that right. 67 years old. Oh, Farmer. Oh, it disappeared. You guys chat so fast. Farmer Whitehair says Judge Bev Pennywise. Yes. Yes, indeed. It's funny that Pennywise came up. We were playing code names the other night, and there was a clue with, I think penny was one of the words. And then our oldest daughter gave the clue of clown. And like Allie's like, well, Pennywise. I'm like, it just says Penny. The clown's name is Pennywise. And there was hospital on there. If you guys have ever played code names, you know how that works. You have to be careful. Yeah, Pennywise is it's funny. It's funny how shit like that happens. Life is strange. Life is so very strange. Oh, she's gonna let him impeach him. She should. There's zero reason why he cannot impeach him with this. I mean, he sat here and testified that it was, never brought up in another court. Can impeach somebody with a ham sandwich. Sir, have you ever had Crocus ham? Okay. And do you eat it on rye, sir? With only mustard? Sir, answer the question. Sir, isn't it true that back in 1984 that you ate a ham sandwich with ketchup on it, sir? I mean, somebody does that, they've lost all credibility. Let's see. Dragonfly Lady, Defense Diaries podcast. Can you explain why the judge has to scrutinize the exhibits? I don't know if she's so much scrutinizing that particular exhibit. Like that one, she might be taking a look at. But I mean, typically, if the question is to an exhibit being entered into evidence, she may want to take a peek at it. Because remember, judges don't know what all the evidence is before a trial starts. Like typically the only thing that they'll know about is if it's something that's addressed in filings, pretrial motions. Like judges in cases are never handed a discovery package and they don't go through it and look at it and familiarize themselves with all the evidence in the case. It's not what happens. So, sometimes if it's a question of whether or not it should be admissible to want to inspect it, depending on what the objection is, which we of course don't know.
May I approach again, Your Honor?
Yes.
Thank you. Mr. Burgess, I'm going to have to get a little close in
Sure.
proximity. Bear with me, please.
Burgess,
What I would
may I
like to
sit
do,
here,
sir,
Tom?
is to put before you again Exhibit FF for identification and Exhibit EE for identification. And what I would like to do is to ask you some questions, sir,
Unless you want.
with regard to the process in the case.
Okay.
Are you aware, or do you recall in this litigation that, as typical in litigation, including federal courts, that as part of the litigation process, the parties have to designate their expert witnesses. Are you aware generally of that process?
Generally, yes.
Yes. And have you participated in the documents that need to be prepared for an attorney or a party to prepare documents and submit them to a court to establish the designation of expert witnesses?
No, I have not.
And so you have never participated or never been aware of a process like this?
No, I'm aware of a process, and that process goes through other staff members
Okay, so it goes through other staff members where?
At Aperture.
Right.
Correct.
Are you aware that that process is occurring, even though it may be done by other staff at Aperture?
Yes, I am.
And in this instance, you were aware in this litigation that staff at Aperture needed to submit documents in support of an expert witness designation, correct? Even though you may not have done it yourself, you were aware that some person or persons at Aperture were performing that process, correct?
Correct.
And they were performing that process so that you could be designated as an expert witness in that case, correct?
Correct.
And so you were aware of the process, you were aware they had to submit documents that would establish your qualifications as an expert in the case so that you could be designated as an expert witness, correct?
Correct.
And now specifically with regard to Exhibit EEE for identification with these court filings, etc., even though you may not have done it yourself, were you aware that this document, which is EEE, was submitted as part of the expert designation process we were talking about?
Not this specific document, no.
Were you aware that a CV was needed to be submitted on your behalf as part of the designation process?
Yes.
So you were aware a CV had to be submitted, but you're saying you don't recall this specific one being submitted?
Correct.
Does the timestamp up at the top of each page of Exhibit EEE, including this page that is your CV, match the timestamp, or is it different from the timestamp at the top of Exhibit FFF?
No, that is the same.
So it's exactly the same.
Yes.
And have you been involved in processes in courts where your qualifications, including your CV, have had to be submitted to courts to establish a designation as an expert witness?
Yes.
And can you conclude from these documents, including the timestamps, that the submission that was made to the court to establish your status and as an expert witness consisted of Exhibits FFF and EEE?
Objection.
I'm going to allow that. Were you aware of that?
Yes.
Your Honor, at this point, I move EEE and FFF into evidence.
Yeah.
You need one more step, Mr.
And sir, do EEE and FFF fairly and accurately represent the submission of documents in support of a designation of expert witness in this case?
Yes, as far as I can tell.
Your Honor, I offer these two into evidence.
I'm going to allow it over here.
May I have a briefing?
Yes, come on up. Bring those, please, Mr.
Oh,
Yes,
good
Your Honor.
God. Good God. Good God. So one of two things happened here. Either, I'm gonna guess it's the former, which is gonna be the first thing I'm gonna say. Either Alessi set this trap by not bringing this up in his cross and decided to wait with it until after Brennan's redirect, where he tried to rehabilitate his witness in order to be able to then impeach him, knowing or hoping that Hank would ask the question as to whether or not he's ever been rebuffed in another court in another case, or if he's ever misrepresented his educational background in another case. So I'm thinking it's the first thing. I'm thinking Bob laid the trap meister, and there's nothing I can do about it at this point.
Yeah. Bob's definitely playing some 4D chess. There's no question. And you guys know what Hank's playing. I've already told you. Color forms. You know it. I know it. I don't know if I have any blooping. Maybe a little bit. Bloop, 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 bloop. Oh, perfect.
May I reapproach, Your Honor?
Yes.
Never know, Samantha. You never know.
I'm going to have to stand here again, Mr.
Sure.
Burgess. So what I would like to do, Your Honor, at this time is to offer into evidence Exhibit E, and Exhibit F for identification.
As one exhibit?
As one exhibit.
Right, we'll do that.
And that would be the order.
Exhibit 193.
Brian, are we sure that Bob's not your dad?
May I hand to the
Yes.
Mr. Burgess, I am handing you what is now in evidence as Exhibit 193. I would like to draw your attention to the fourth page, which is your CV. And further, if I could, sir, draw your attention to the category of education, where it says BGS. Is it correct that there you state Bachelor of General Science in Mathematics and Business Administration, University of Alabama - Birmingham, Alabama, comma, 2024? Did I read that correct?
You did read that correctly. And this was filed in 2023.
Understood. So now what I'd like to do, Your Honor, is to may I keep this for a moment, Your Honor, give it to the witness as needed. Thank you. With Your Honor's permission, I would like to publish a document that is already in evidence.
Okay.
Actually, there may be two, 183 and 184. Let's start with 183. Let's expand it. And then, Mr. Wolk, do we have what has just been to publish as well? So what I'd like to do is to publish first, with the court's permission, Exhibit 193 that we were just talking about, so the jury can see what has been the subject of discussion.
I'm going to tell you right now, this is what was like.
And sir, if you, Mr. Wolk, if you could just enlarge, all we need is the education section. Now,
this is what the toughest thing.
Mr. Burgess, as I heard it correctly in questions from Mr. Brennan, you answered the question that whether you had ever filed a document that misstated your educational background in a court. Do you recall that question asked of you?
Yes, I did.
And your answer was no, correct, sir?
Correct.
So let's look at this document, which we've just gone through, was filed in federal court in the United States, lists under BGS, Bachelor of General Science in Mathematics and Business Administration, University of Alabama, Birmingham, Alabama, 2024. You see that, sir?
I do, yes.
Now, you stated, and now what I'd like to do is is there any qualification whatsoever in that line, that reference to BGS, qualifications at all, explanation, sir? Is there anything?
I don't know what you mean.
It's just a statement, right? There's words there. There's nothing after it that explains what's intended, correct?
Correct.
Now what I'd like to do, Your Honor, is to go to what was filed in this case, which is in evidence, and we'll go to 183 and then 184. Now, in what has been filed in this case, there is a currently pursuing at the end after University of Alabama - Birmingham, Alabama, correct?
Yes, that's correct.
Let's go back, please, to Exhibit 193.
Currently pursuing.
There is no currently pursuing there, is there, sir?
There is not, but that was filed in 2023, so that would be an expected graduation date of 2024.
Okay, so this document was filed in 2023. However, there's nothing in this document that in any way leads the reader to believe anything other than the degree is obtained on 2024, correct?
Correct.
So the only way somebody in the court system or a judge or a jury would know anything about this is to have to know about court filing dates, correct? I'll ask it another way, Mr. Burgess. You know how to write. Let's go back to 183 and 184. You know how to write currently pursuing on your CV, correct?
Correct.
And writing currently pursuing lets the reader know that you don't have that degree, correct?
Objection.
In that form, it's sustained.
What? You intend by writing currently pursuing, don't you, sir, that anybody reads this to know that you do not have a bachelor degree, correct?
Correct.
Now let's go back to what you filed in what was filed in federal court in that case. And it does not have the words currently pursuing, correct?
It does not.
So the reader, so it doesn't have that verbiage, correct?
Correct.
So isn't it the correct answer that you did file a document, your CV, in this federal court case that misstates the status of a Bachelor of Science in Mathematics and Business Administration?
Objection.
Sustained.
What? Why?
Excuse me, Your Honor.
This guy hates life. This guy hates life. Just hating
You
life.
stated again, sir, that you have not filed a document that misstates your educational background, correct?
Correct.
And the last time I'll cover it, you know how to put currently pursuing on anything to do with a Bachelor of Science, correct?
Correct.
A Bachelor of General Science in Mathematics and Business Administration does not exist as an offered degree at the University of Alabama, Birmingham, does it?
Sure. So that is an error. Clearly, BGS stands for Bachelor's of General Studies, and that should have a with minor in Mathematics and Business Administration.
What is clear from that document that BGS stands for a Bachelor of General Studies? What is clear in that document about the definition of that acronym?
That is a known acronym.
Let's go back to
Known by whom, sir?
Bachelor of General Science in Mathematics and Business Administration. That degree does not exist. It is not offered at the University of Alabama, Birmingham, correct?
No, that is not.
So therefore, an incorrect statement about your educational background was filed in a federal court in Texas, correct?
Yes, it was.
Long road to impeachment there.
That's it, Mr. Alessi?
Yes.
Okay. Is there anything?
There is.
Okay.
Oh, God. Oh, God. Here we go.
The document that the attorney just showed you, did you submit that to the federal court?
No, I did not.
Did you ever see that document before it was filed?
No, I did not.
The document says 2024 for a degree. Is there a presumption whether you had it or expected it if that document was filed in 2023?
Yes, there is.
And what is the presumption if it was filed in 2023?
Objection, Your Honor, respect.
So presumption,
Well,
we'll strike that.
okay.
Well,
He asked if there was any designation to make it clear. If it says 2020, if it was filed in 2023, and it says 2024, what was your expectation at that time as far as your degree?
That I would complete my degree in 2024.
When you didn't complete your degree in 2024 as you expected, did you then change your CV
Yes, I did.
to accurately reflect the change in your status?
Yes, I did.
And what did you change it to?
Currently pursuing.
Why didn't you finish your degree in 2024?
Sure. So
Objection, Your Honor, still.
No, I'm going to allow it.
as most people can probably relate, work, family, and life many times get in the way. So as a personal objective, I would like to finish my bachelor's, but again, work and life gets in the way.
Did you ever represent to a court that you had a degree that you didn't earn?
No, I have not.
He asked you a number of questions about this 2023 filing, but didn't ask you any questions about the data. Does your opinion regarding the data change in any way in light of his questions about a 2023 filing that you didn't file and someone filed on your behalf?
Objection, Your Honor.
The objection is sustained. I'm going to strike that question.
No further questions.
All right.
Sit the
Mr.
fuck
Burgess,
down,
you're all
Hank.
set.
Thank you.
2 hours later.
All right. There you go. There you go. Our little friend, the human tuft, has left the stand. I was really hoping on redirect that.
Mr. Brennan?
I'd like to play a number of clips.
End of-
If I could begin with clip 23.
Time. Time for clip.
So we approach from the north, we actually missed the turn, and John says to me, it's Fairview, we just passed it, it's back there, it's on my left. I said, all right, so I pull nose into a driveway and back out onto the street, which I now own as Cedar Crest, and then come from the north onto Fairview.
Like the next play, clip 25.
Nosed into the driveway. Well, they proved up she did a 3-point turn. Case over. Let's all go home.
At 12:41, I leave a voicemail to John, where you can clearly, and this will probably be played on Monday, you can clearly hear me pull into John's garage. You can hear my car sensors beeping as I come close to the sides of the garage door. And then you hear the car go off, and then you hear the slight ding, ding, ding as I open the door, shut the door. I had high heels on that night. You hear me walk in, go into the stairs up into the kitchen, shut the door, and you hear me walk in the kitchen. It's like a full minute long. That's at 12:41.
And finally, clip 24.
I do. I mean, I'll tell you, John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30 on the early morning of January 29th.
Thank you. I have these for submission into evidence, Ron.
194.
And
The next witness is on.
Yes, sir. I'm calling. Call Miss Christina Hanley to the stand.
oh no. Oh no. Oh my God. Drifted into a rally direct. Oh. Oh no.
Step up, face the clerk, and raise your right hand.
You solemnly swear the evidence given before the jury in the case down here is the truth, the whole truth, and nothing but the truth, so help you God.
Good afternoon. Good afternoon.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Could you please introduce yourself to the jury, spelling your last name for the court?
Sure. I'm Christina Hanley. Hanley is Hanley.
And Ms. Hanley, what do you do for work?
I am a forensic scientist 3 at the Massachusetts State Police Crime Laboratory in the Trace Arson and Explosives Unit.
And where did you go to school?
I went to, I had received my Bachelor of Science in Chemistry with a concentration in forensics from Merrimack College.
And do you have any other degrees?
The hell's her last name?
I do not.
Now, following your education, where did you first go to work?
I began working at the State Police Crime Lab in 2008 in the drug identification unit. And
Thank you.
in 2009, I transferred into the Trace unit. And in 2017, I was promoted from a forensic scientist 2 to a forensic scientist 3 in the Trace Arson and Explosives unit.
Could I ask you please to speak up, please?
Ms. Hanley, if it helps, that microphone is adjustable, so if you could get it as close to you as possible, that would be great. Thank you. The Massachusetts State Police Crime Laboratory where you work, is that accredited?
Yes, it is.
And by whom?
We are accredited by ANAB.
And what does ANAB stand for?
ANAB stands for ANSI National Accreditation Board.
And what does ANSI stand for?
Sorry, I can't remember exactly what ANSI stands for. I apologize.
That's okay. As part of that accreditation process, do you undergo any sort of proficiency testing?
Yes, I do.
And can you explain to the jury what that proficiency testing process consists of?
Sure. So proficiency tests are a quality assurance measure that's used to monitor performance. And I'm required to complete at least one external proficiency test per year, where I'm authorized to do casework in multiple subdisciplines. In my unit, I typically complete more than one proficiency test per year.
And what areas do you specifically undergo proficiency testing in?
Sure. So I'm authorized to do casework in multiple subdisciplines in Trace. So I complete proficiency tests in the subdisciplines of hairs, paint, disciplines of fibers, glass, tape, and serial number restorations and physical match examinations.
Are you sure?
And generally speaking, what is entailed in those proficiency testing that you're given multiple times a year?
It's provided by an external company that provides the proficiency test, and I'm required to successfully complete one of those proficiency tests per year.
Now, have you successfully completed each of those proficiency tests that you've taken?
Yes, I have.
Now, what type of training or continuing education have you undergone at the State Police Crime Laboratory?
Sure. So I had internal training as well as external training. The internal training consisted of I had to complete required readings. I was required to complete some laboratory exercises, learn how to utilize the instrumentation in the lab. I observed other analysts in the unit working on casework. I was also required to complete a written exam as well as a competency test, and in addition to that, a mock trial.
Now, you mentioned earlier in the testimony you're a forensic scientist 3 currently, is that correct?
That's correct.
And what is the difference, or can you explain the difference to the jury between a forensic scientist 2 versus a forensic scientist 3?
Sure. So forensic scientist 2 is essentially just like a bench chemist who their primary role or responsibility is casework. A forensic scientist 3 does casework, but in addition is also a unit supervisor.
Now, what does the trace unit do or examine within the Massachusetts State Police Crime Lab?
Sure. So I'm responsible for examining and comparing trace items that, for example, such as paint, glass, fibers, hairs, tape, miscellaneous items. I also perform serial number restorations on firearms and physical match examinations.
And what are your general duties and responsibilities within the trace unit within the lab?
So I am responsible for the general operation of the unit. I train other forensic scientists within the unit. I also complete technical and administrative reviews of casework. And I also complete my own casework in the trace disciplines that I previously mentioned.
Now, Ms. Hanley, you as a supervisor, you review other analysts' work within the trace unit, correct?
Yes, I do.
And who reviews your work for any sort of trace analysis that you do?
So depending on what the subdiscipline, some of the casework that I'm authorized to do work in, it needs to be technically reviewed by an external technical reviewer because I'm the only one within my unit that can do certain types of casework currently. So we have to utilize an external technical reviewer at this time.
Now, with reference to physical match analysis, can you explain to the jury first, just in general terms, how is that analysis performed?
Sure. So when I receive an item, I take that item into my custody, and I document it with photographs, and I make observations and take notes. And then I'll examine the items microscopically, and I will do any comparison work to determine if there is or is not a physical match between items.
Now, that physical match analysis within the trace unit at the state lab, is that general work supported by any sort of scientific principle or methodology that you're aware of?
Yes.
Let me ask you this. Are you familiar with something called the Lockhart exchange principle?
Yes. So the Lockhart exchange principle, it's kind of the foundation or basis of trace analysis. It is a principle that states that when two when two objects or two items come into contact with each other, there is an exchange of material.
Now, with reference to your workspace, what is it that you do to your bench between your examination of separately packaged items?
Sure. So the benchtop as well as the tools that I'm going to use are all cleaned with a bleach solution. And once that's done, there's a clean piece of butcher paper that's put down on the bench, and that's done in between looking at different items.
And why is it that you do that in between looking at different items?
That's done to prevent any cross-contamination.
Now, you've alluded a little bit earlier in your testimony, but on what types of evidence can you perform a physical match analysis?
Sure. So physical match examination can be conducted with many different types of material. For example, plastics, glass, tape, etc.
Now, when evidence is submitted to your lab, how is it kept track of throughout its stay at the lab?
Sure. So when evidence is submitted to the laboratory, the case information is put into our LIMS system, which stands for Laboratory Information Management System.
And once it's assigned that number, how is it sort of tracked as it progresses through the different units within the lab?
Sure. So the unique case number that's assigned to the case is tracked within the system. It's referred to as the chain of custody. So items of evidence will get scanned depending on where their location is, and the LIMS system keeps track of all of that. So we know exactly where an item is.
So when you take an item or you receive an item to be tested, can you explain to the jury what you do to begin your analysis?
Sure. So when an item gets scanned into my custody, after I've prepped my area to examine the item, I scan that item into my custody, and I will document that item with photographs. I will make notes of my observations. I will examine the item microscopically. If needed, I'll proceed with sampling and possibly additional microscopic examination and instrumental analysis.
Now, specifically starting with items of glass, when you take an item of glass to conduct a comparative analysis, generally speaking, what is the process for conducting such an examination of glass?
So it'd be the same process that I just mentioned. I would take that item, take photos, make any observations. I would proceed with, first I would check to see if there's any physical match comparisons, and then if needed, I would take any samples to examine it microscopically and or instrumentally.
And that general process that you've just described is the items that you tested in reference to this case or analyzed in reference to this case. Is that the process that you followed in this case?
Yes.
Now, what kind of instruments do you use, starting off with items of glass, what kind of instruments do you use to conduct that analysis?
Sure. So I'll use a stereo zoom microscope to initially examine it microscopically. If I take samples to do additional microscopic examination, I'll examine it under a polarized light microscope. And then if I need to take samples to do instrumental analysis, that would be using our, it's referred to as a GRIM, which stands for Glass Refractive Index Measurement. It's an instrument that measures the refractive index of glass.
And if you could please explain to the jury, what is a refractive index?
Sure. Refractive index is a measure of how light bends when it passes from one medium to another.
And how are you viewing that utilizing the GRIM device when it comes to glass?
So a sample is prepped on a slide and it is placed on a hot stage of the microscope of the instrument, and the oil that the sample is in it goes through a cooling and a heating phase, and as it's going through a cooling and a heating phase, it passes through what we refer to as a match point. So you can make that observation as the sample is running, and then when the sample is done running, it takes an average and it calculates the refractive index of the sample through the calibration data of the instrument.
What is an FTIR?
So an FTIR is a Fourier transform infrared spectrometer, and it is an analytical tool that we use to analyze certain types of samples. Essentially, a sample is exposed to infrared light, and your sample reacts in a certain way to it, and it produces a spectrum or a graph of peaks and valleys, and it is representative of your sample.
And how is that FTIR instrument, how is that used in this type of physical match analysis?
So actually the FTIR was not used for physical match examination.
Now, you mentioned it a little bit earlier in your testimony. What is a polarized light microscope?
So a polarized light microscope is it's a microscope that just has a couple of filters in it that we use to look at samples at a higher magnification and make observations of certain optical properties of samples.
And how are you utilizing that instrument in your analysis in the lab?
So it's used to examine various different types of samples, paint, fiber. We can also look at glass.
Do you document your work as you perform your analysis in the lab?
Yes, I do.
Now, Ms. Hanley, at some point were you assigned to perform some work on a lab case number 22-02184 pertaining to this defendant, Karen Reed?
Yes, I was.
And what type of work were you assigned to do in this case?
So I was given items for physical match comparison of some glass items, as well as some instrumental analysis of the glass. And I was also given items for some items of plastic for comparison.
Now, starting with glass pieces, do you recall what item numbers you analyzed pertaining to the glass pieces?
Yes. So I examined items 3-2, which was a clear glass cup with broken irregular edges. I was also given item 3-3, which was 5 pieces of clear glass with broken irregular edges from the bumper of the vehicle. And then I was also given item 7-12, which were clear and glass pieces recovered from the road. And I was given also 7-14, which...
Okay, we have 0 blooping, and we cannot listen at 2 times speed because we're at real time. That's why the pausing in the analysis is good, because we fall behind time. And then when we get boring ass witnesses, we get to bloop and listen at a faster speed. Let the lesson be learned. Now we're paying the price.
Was a clear piece of glass recovered from the road.
And now if we could, Ms. Hanley, just break those down sort of one by one. So starting with item 3-2, what was provided to you in reference to a description of what that item was?
Sure. So item 3-2 was a clear glass cup with broken irregular edges, and there was dirt debris on the exterior and interior of the cup.
Now, did you measure that item?
I did.
And what measurements did you obtain from that item, the drinking glass?
Huge.
I just would need to refer to my report for measurements.
Okay, you can do that. You have your report right there. Go right ahead.
Thank you, Your Honor.
So the diameter of the bottom of the glass cup was 2 3/4 inches, and it measured approximately 2.5 inches in height.
You mentioned that there was debris on both the interior and exterior of the drinking glass. Is that correct?
Yes.
Now, turning your attention to item 3-3, what was provided to you as a description of item 3-3?
Sure. So item 3-3 consisted of 5 pieces of clear glass, all with broken irregular edges.
And was there anything provided in the description of where those 5 pieces of broken glass were located?
Yes, they were recovered from the bumper of a vehicle.
And was there any identifying information provided to you as far as in reference to that vehicle?
The only other description of the item is the license plate of the vehicle.
What was the license plate that was provided?
So it was MA3GC684.
And did you measure each of those respective items?
Yes, I did.
Now, as far as before we get to the measurements, Ms. Hanley, when it comes to a lab item number, say 3-3, that has multiple pieces to it, how are each of those individual pieces then subsequently labeled?
So sometimes we'll subsequently label them with a lettering system.
And as far as these particular pieces contained within item 3-3, the pieces of glass from the bumper of the defendant's vehicle, how are they labeled?
So these were labeled A through E.
And with reference to the measurements, what measurements did you obtain from the pieces within item 3-3?
Sure. So I measured the largest and the smallest, and the largest measured approximately 7/8 of an inch by 5/16 of an inch, and the smallest measured approximately 3/16 of an inch by 1/8 of an inch.
Now, with reference to the drinking glass, you examined that microscopically, is that correct?
I did, yes.
And with reference to these items from item 3-3 from the bumper, you examined those microscopically as well, is that correct?
Correct.
And was there a particular piece from the pieces from the bumper that you did any additional examination of?
Yes, I did.
And what instruments did you use in which piece?
Sure. So there was one piece, I sampled piece E that I had labeled as piece E. And I took a sample for examination under the polarized light microscope and a sample to analyze it instrumentally on the Grimm instrument.
Now, turning your attention to item 7-12, what was provided to you as a description for item 7-12?
Sure. So item 7-12, that consisted of 5 pieces of clear apparent plastic and 9 pieces of clear apparent glass with all with broken irregular edges.
Now, the 9 apparent pieces, well, let me ask you this first. As far as the description that you were provided, was there any description as far as where those items were recovered from?
Yes. Those items were recovered from 34 Fairview Road.
And is it your understanding they were recovered from the street or the roadway outside of that residence?
It just says recovered from 34 Fairview Road.
Now, as far as the 9 pieces of clear apparent glass from item 7-12, were those similarly sub-labeled as the previous item 3-3?
Yes, I received those labeled with the lettering system. They were labeled A, B, C, D, E, F, I, K, and L.
And with reference to those 9 pieces of glass, did you examine those microscopically as well?
I did, yes.
Now, turning your attention to item 7-14, what were you provided with as far as a description of that item 7-14?
So this item consisted of one piece of clear glass with broken irregular edges.
And similarly, was there any description provided as to where that item was recovered from?
Yes, it was recovered from 34 Fairview Road as well.
And again, how many pieces were contained within that item 7-14?
7-14 was just one piece of glass.
And did you measure that item as well?
That item, I do not have the measurement of. It was examined by a previous analyst within the unit. So that measurement was taken at that time.
And that other analyst would be Mix Valier, is that correct?
Yes.
Okay. And as far as your examination of that item 7-14, what type of instruments did you use to examine 7-14?
So I sampled 7-14 to examine it under the polarized light microscope, as well as to analyze it instrumentally using the GRIM instrument.
Are you familiar with a term called a class characteristic?
Yes.
Can you explain to the jury what that is?
Sure. So a class characteristic is when a material can be associated with a group of items that share characteristics.
And what is an individual characteristic?
An individual characteristic is when a material can be related to a single source, such as a physical match.
And so what is the difference between a class characteristic versus an individual characteristic?
So class characteristic is that it can be associated with a group of items that share characteristics, versus the individual characteristic. It's more individualizing. It can be related to a single source, just in the case of like a physical match.
And what is a physical match?
So a physical match is if an item is broken and those pieces are compared to each other, and their broken irregular edges fit back together, and they have a jigsaw fit, that would be considered a physical match.
Now, can you please explain to the jury the steps and the process that you undertook in your comparative analysis of items, specifically of glass in this case?
Sure. So I first did a comparison of all of the glass pieces and the glass cup that were recovered from the road. So those were items 3-2, 7-12, and 7-14. So I examined all of those to determine if there was a physical match between any of those items first. There were, I believe, 6 pieces of glass from item 7-12 that fit mechanically to the cup that was also recovered from the road, item 3-2. After I completed...
Okay, the jury has no fucking idea what this woman is testifying about, why it matters in this case at all. They're sitting there like, what in the fuck is going on right now? Like, why are we talking about this glass? Like, who is this woman? Why won't he bring her water? Like, what is going on? This is insane. And I think she's like the second to last witness. I think they're ending it with Welcher. That's what I think. I mean, she's making me thirsty. Let's have a drink.
That examination, I then did a comparison to see if there was a physical match to some of the two of the glass pieces from the bumper. And there were 5 total from the bumper. 2 of them I used for physical match comparison. And there was no physical match comparison between those 2 pieces from the bumper, item 3-3, compared to the glass pieces and the cup that were recovered from the road. And then I sampled, as I had mentioned earlier, one of the pieces from the bumper to do further microscopic and analytical analysis on, and did a comparison with one of the pieces from the road.
Can I see counsel at sidebar for just a minute?
Oh, she's calling it. She said, I am bored as fuck right now. And what I'm about to do, Mr. Lally, is call it for the day, sir, because you have bored me out of my skull. Cannot handle one more minute of this. You refuse to bring her water. The mouth noises are driving me nuts. I don't know what to do other than call it a day. Thank you. Get out of my courtroom. Well, let's see. We have a little blooping. Oh, hold on. Bloop. Let's see what kind of blooping action we have. Bloop, 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 bloop. Oh man, we're up to real speed. I know it's only 3:30, but Judge Cannoni can only take so much in one day. Tammy, thank you. Crank the volume. I'll make sure to scream like all kinds of profanities when you're in the grocery store, shocking all the nice elderly women trying to buy soda crackers. Nice tea, some kind of nice tea. Giving you side-eyeing you the whole time. Like, oh, there's that. What is she listening to? Yeah, I mean, this testimony is like, it's like Roosevelt asked, like where does this glass play into their theory? Like, where does it play in? Have we heard about the microscopic pieces of taillight from the sleeve yet? Have we heard that? I can't remember if that came up. Just can't remember. Oh, is this the gal? What's up, Will? Did you make it into the court? Were you in there today, man? People were saying you were in there, chilling, cold chilling. Will, give us the inside dope, man. Is it done for the day? Let us know. Give us the tip. Need the inside tip. Oh. Has Will got a bad knee? Did he get a knee injury? What's going on? What's happening? What? Will's got a cane? Maybe he had some arthroscopic. Clean that thing out. You know? I didn't see Will.
Jurors, it's been a long day.
There you go.
So we're going
Called
to
it.
stop for the day. Ms. Hanley, I'm going to ask you to come back tomorrow, but a little bit later in the day, and the victim of this person can tell you the time.
Broke his knee?
So folks, we're gonna end for today. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know, and watch your social media use. Thank you. So Ms. Hanley, after Jane,
All right, so the court, please.
So now we know. Bev was feeling everything we've been feeling about this afternoon. I mean, she only came out for 4:40. Like, she's like, I'm calling this shit. Claire cracked it over a fence. What? Okay. You're a grown fucking man. What are you doing climbing fences, bro? That's kid shit. I'm gonna have to have a talk to you about climbing fences when you're 40 and over. It's not recommended. It's a bad idea. Apparently, Will broke his.
You don't need me for anything, right? We're all set?
We're all set.
He's like, I'm out. I am out. Yeah, apparently Will's still jumping fences. Or advanced age. Maybe he was trying to escape the buffer zone police. He was on the run. Oh man, I'm out. All right, there's that. So, synopsis for the day. Long day. Wasn't nearly as fun and as exciting as yesterday. Mostly to blame is Brennan for that and his just completely mind-bogglingly boring direct examinations where he just has his witness puke back up everything he said on direct. And, we got a little bit of Alessi in there, a little Bob action. It's always good, dug into the fibbing, which is good. And then we ended with the incredibly boring glass woman. So that's your synopsis for the day. You guys were incredibly generous all day. So thank you so much for that. She is in court, Kate O'Connor. Where's Allie when I need her? I'm still stuck on this glass. As I understand it could not be matched back to either bar/establishment. True or false? That's what I understand as well. That's what Roosevelt had asked earlier. Plus, I just don't know how it fits into their narrative, the Commonwealth's narrative. Like, where does that glass come in? You know what I mean? Because if I remember correctly, not only does it not match from one of the bars, but like the piece that they found on the taillight didn't match the glass that was found by John, right? Am I crazy on that? Because right, I mean that's Lana. That's clearly a very plausible explanation where that glass could have come from. Lana had said inside the house. Unfortunately, they didn't investigate any of that. There is court tomorrow. We will be back at 7:50 a.m. tomorrow morning. I think I gave everybody the love for all your supers. Thank you so much for that. I think I gave everybody the love for the Venmos. I didn't see any Cash Apps, so I don't think I missed anybody on that today. But I did get a couple of Venmos come in, and I think I shouted you all out just in case I didn't. Yeah, there was Christy with the $5 Venmo. Thank you. Meg P with the $40 Venmo. Thank you very much. And Sarah with a 10. So thank you guys all for your incredible generosity. I think tomorrow is a full day. I think tomorrow I'll do a wheel. So look out for that. And I was talking to Mandy. I think we're going to be doing our next members only live on Thursday night. That will include your voicemail. So now is the time to be leaving your voicemails. We've built some up. I've got some that have not been heard. They're a lot of fun. Like I said, I had one complaint by somebody, and I don't care. I think I love hearing from you guys. I don't care what anybody says. It's amazing. Like, it's fun. It's a fun thing. And and you could say, do whatever you want. Thursday, Kim, is going to be today. Today is Tuesday, if that's what you're asking. The members only will be, yep, Amanda, some. I typically don't listen to them ahead of time because I like to hear them first blush when we're doing it. Sometimes we will end up, like, I'll listen to them if it's, one like, oh, what do they have to say? So, but they're phenomenal. Don't worry about what your voice sounds like. You guys all have beautiful voices, the voices of angels. So Do not let that dissuade you. You can say whatever the hell you want. You can rant, you can rave, you can ask a question, you can say whatever you want. We're going to play them all, and they're a blast. Same start time tomorrow, Mickey. Yes, 7:50 a.m. So hit your notifications on the way out. Make sure you like, share, and subscribe. And if you didn't see it, I'm going to be on Vinny tonight. I thought he was there too, but the producer hit me up. So I'll be joining for VPI at, I think, 8 p.m. Central. So check me out over on Core TV tonight, where I'll be trying to convince whatever schmuck they have on the other side that this case is hot garbage. So, all right, you guys are amazing. We love you all. I'm sending you all the love from Allie as well. Oh, check on Mark's going to be on Nurse Kim tonight. Go over there, check that out. I'll probably pop in on the chat over there, say what's up. And, just remember this one thing. Without y'all, I'm just an old man talking about Karen Reed walking out of that courtroom, a free woman. Bye.